of the lordship gives. But the agency is not in front of my shop room, but we are constructing a toll plaza where the other places are left. I cannot let that it is constructed in a way that I have to close down my shop. So large is not.
No, Mr. Chakravarti, not right now.
But I can't run my
Next.
Lordship, this is extension of interim order.
Hello.
Quantum application.
Not right now. Yes.
Extension of interim order.
Yes.
Millet amount was deducted from my bills below, and in spite of Millet several reminders, the authority is not Millet return back the same and remain silent Millet.
Please, Nandi, please wait for some time. We have to. Yes.
Lordship, this is the case for the Section 8 company. They amend the articles the earlier group. Now this ROC replied us that they have cancelled the SRA. So it needs a court's order. That is why we are given.
I know. Yes.
My lord, the eldest son of your petitioner and forcibly entered the house and torturing the parents. I filed the appeal challenging the order of the maintenance tribunal, which is pending before the respondent number 2. But they are not taking any steps. I came before your lordship for direction for early hearing.
Upgraded either. Upni to upgrade. Yes.
Today is 59, item number 59. Auction process has been already started of my property. This is I'm praying that my title interest shall not be transferred. The document shall not be transferred. I challenge the auction process, my lord.
My lord, let's see if I permitted to be mentioned for matter relating to senior citizen freedom fighter pension scheme.
Wait for some
I
time.
several times.
Wait for some time. Yes.
For the upgradation, my lord, I think clearly supporting for wrong between diet. The commission has said that commission has awarded with 2 lakh, my lord, but law says that for the case, I am entitled to 10 lakhs, my lord.
Please wait for some time. Yes, Mr. Vanit.
This pertains to final survey report of an insurance claim. My urgency is that limitation is running away. I'll have to take them to arbitration. Under the IRDA regulations, all they're required to do is give me the final survey report. That is all that I prayed for. There's nothing else that I need.
I know. Yes. Yes.
My
lord, for strategy, yes. Oh, no, I'm sorry. Yes. Ask him.
Yes, sir. The last week I am also mentioning that it is on the list when the hospital is supporting loans and they
Hand over the slip, please.
Now, this is under the Housing Code Act. Now, what has happened? This one is that is the public-private partnership project. They are not only allowing us to examine the deed of sale.
No, Mr. Chatterjee, not right now. Not right now. Next one. Not right now. No. Hand over. Yes.
My lord, for non-prosecution.
Yes. No further upgradation.
Awarded your lordship.
No further upgradation. Yes.
40 minor for upgradation 200 workers are almost done.
Wait for some time. Yes.
This minor, but most urgent minor, they are start.
Yes, please. Be a bit louder. Why? Wait for some time. No, not right. Why? Wait for no. I cannot. No.
My matter was twice directed for these two. It has not happened yet. And this is a big matter. It is a PSC application by the bank before the registered magistrate.
Hand over. কেন আসছেন অরিত্রকে জিজ্ঞেস করতে হবে হ্যাঁ Yes.
My lord, my client is senior citizen and filed a petition before your honor and contrary to your lordship. Direction a complete path and disconnection of my electricity. That is item number 490. Extreme urgency, my lord.
Can you to mention a matter something about voting lordship for an open application?
Application, wait for some time. There are so many applications, sir.
liability is to be changed from one bank to another bank. Will it?
Wait for some time, yes.
Spite of the valid license of a shop, my lord, issued by the West Bengal Agricultural
Yes, yes.
Marketing Department. The petitioner is not, petitioner illegally evicted from the shop, my lord.
Mine is in original side.
No.
But this
Yes.
is an original side matter.
Audience said wait for.
My lord, may I be permitted to mention one new motion, my lord? A matter is not in the list. Petitioner before your lordship is the widow of the corona victim, though she is entitled to get the compensation, my lord. Till now, no compensation has been released.
Wait for some time.
My lord,
Yes.
twice I mentioned this matter before your lordship, my lord. Matter initially appeared before my lord, Mrs. Justice Mosmi Bhattacharya. After matter gone out of the list, I mentioned twice, my lord. In this matter, my lord, what has happened, my lord, your lordship kindly consider, my lord.
Mention the
This-
urgency only, Mr. Gupta.
lord,
I'm not
urgent.
interested whether it appeared before Justice Bhattacharya or before Justice Sen Gupta. I'm not interested.
No, no, my lord,
What is the urgency in the matter?
I-
Please
I
tell
said
that.
to Mama-
So many people are waiting behind.
My lord, I'm telling the agency, my lord, petitioner has paid all the liquidated or entire dues, my lord. Bank is withholding the
She
picture.
seriously thinks there are no more urgent matters like this.
My lord,
56 matters, 46 matters
my
are
lord,
in the
my
update
business has
list.
been stopped.
Why do
my
you
lord.
mention you're pretty senior in the bar? Yes,
My lord, my business has
No.
been stopped, my lord.
definitely not.
For non-prosecution.
Hand over. Yes, Mr. Pal.
Housekeeping service tender lordship, I stood L1 lordship, but they are going to issue work order in favor of the L2 lordship. Within 25th, they will issue the work order lordship. This Friday lordship. By this Friday, they will issue the work order. So
Hand
anything.
over. Hand over. Yes. Yes, Mr. Rai.
Mentioning for inclusion of matter notice which was released by court number 13 for want of determination. Now here with your lordship, Lord, this is regarding.
Sir, I cannot add in further matter now. I'm sorry. Yes, Ms. Ghosh.
One motion.
No, cannot. It's useless. Yes, Ms. Ghosh, anything to mention?
Hearing as item number 169, your lordship. I filed in the second week of July, your lordship. Hearing my authorization has been stopped, your lordship.
No, Ms. Ghosh, not right now. Yes. Yes, sir.
As I mentioned twice, your lordship.
Yes, next. Yes, you. You. Not right now.
Salary has been illegally withheld, your lordship, for the past 8 months, your lordship.
Wait for some time. Yes. No, not right now. Yes. Not right now. No. Second. Not right now. Yes.
May be competent to mention a matter for inclusion. I want the petitioner entered into an agreement with the state respondent wherein the petitioner was entrusted to make a multi-story building into the land of the state of.
Cannot add any further matter right now. Sorry, sir. Yes.
Your lordship, electricity connection has been disconnected.
Not right now.
This contempt application lordship is to dispose of on Friday. The correction of cost is necessary lordship.
We mentioned for correction.
There's a DM. I am.
Yes, Mr.
For the affidavit. also.
Whatever. Yes.
136 and 132 matters, my lord. We have paid 50%, my lord. They have been connected with, we are waiting, last Friday I mentioned.
No, Mr. Haldar. Disconnection not right now. Yes.
We are mentioning for inclusion in the list, my lord, company circumstances, my lord, 4 years. My EMD has been forfeited 4 years back, my lord, not got
Good
it
for a
back, my
little bit.
My bank account has been closed, my lord, but without intimating.
What are you? You are a juristic entity or a person?
Lord, I am an entity.
You are a
Entity, my lord.
hand over. Yes.
My lord, may I permit to mention one update matter, my lord. This matter is regarding rational distributorship. And the authority.
No urgency at all. Yes.
Bank account has been frozen.
You're behind in the second line. Yes.
Lordship, the writ
No,
I'm I'm mentioning for upgradation, your lordship, the writ petitioner before your lordship had applied for transfer. And now he's come to know that a private respondent is being transferred, is being appointed in that post.
What
he's
post?
being-
MMR?
The MMR.
MMR. Wait for some time.
Lordship, lordship, because he's already there. Once his new appointment is given, your lordship.
No.
But the MMR post has been filled up without due process of law. So
MMR not right now. Yes. Next.
My lordship, the DM has failed to adhere the required procedure and the order
Which provision of law?
14.
Hand over. Yes.
Date of birth in the passport, my lord. The petition is not outside for.
Please wait for some time. Not so urgent. Yes. But be a bit louder.
Urgent motion, my lord, inclusion, suddenly you are out of the list, my lord.
No. Yes. Yes. Be a bit louder.
Start manner, the Western government handloom department manner share. Intentionally manner that's not what? Not use manner.
Wait for some time. No, not right now. Yes.
Number 100 for upgradation, the urgency, the petition has not only been blacklisted but also been debarred from participating in it.
For some time. There are more urgent matters. Sorry. Yes.
About 68 years. Now, my lord, he applied on the Pradhan Mantri Awas Yojana.
You applied for?
Pradhan Mantri Awas Yojana for making.
No, wait for some time. Yes.
To mention item number 641, this is a tender matter. What
Can't hear you.
already
Mr. Mukherjee can't hear you. Be a bit louder. Tender matter, this much I could hear.
Work order already.
My lord, for upgradation, my lord, from the monthly list 560 is a change, shifting of meters.
My lord, poor farmers, petitioners are poor farmers. They are unable to cultivate their own land. Their livelihood is in stake, my lord.
What is the cause of action of
My lord, for the
poor farmers' livelihoods are always at stake. What is your cause of action?
my lord, the registered document was tampered. For that, the opposite private respondent are unable. They are.
What are you not getting?
I am not getting to able to my land to cultivate.
Not right now. Yes.
Bank account has been frozen, my lord. I mean, the LP, my lord, statutory compliance with my statute. Dues are not able to pay, my lord. There is no specific.
Hand over, please. Yes. Sir.
Extension of entry order.
Please hand over. Yes.
Lordship, this is a DRI has already issued a notice regarding the not payment of the GST, and the petitioner is the proprietor of a sole proprietorship company. The urgency is I have already. The reason is already, if the petitioner has not been paid by the central company, the DRI has already in the meantime issued the notice. So
no.
kindly.
Next one, please. Yes. You.
My lord, decision for appearing in the application for correction of the order, my lord.
Correction of my order?
No, my lord. His Lordship Honorable Justice Mosumi Bhattacharya.
Mentioned before her leadership.
She released this matter, my lord. His Lordship released.
Not right now, then. Yes.
And to mention it before the appropriate.
Not right now.
Have your lordships give to mention a matter for inclusion in the list upon notice, my lord? My lord, this matter relates to the cancellation of the registration of a registered society operating in Malda by the district planning officer who has been arraigned as a party respondent, my lord.
Not right now. This is not such an.
They're accepting funds and.
No, not right now. Yes. And yes.
Urgency made an application for new connection.
New connection. Connections wait for some time. Yes. Loud. Upgradation. Why? Matter is dangerous. No. Electricity connection. It's in a dangerous condition. Not right now. Yes, Mr. Mahath. Not right now. Mr. Mahath, no. Not right now. I have to refuse. Yes.
For the issuance of RC2.
RC2 wait for some time. No. Yes.
Privates he had a consignment with he had a work order with the railway. He complied with the state work order.
Not getting the money. Wait. Yes. No. Next.
Electricity matter, you lost. I have paid the question amount for it.
Wait for some time. Electricity matter. I'll fix some. Yes.
20th of the monthly lordship. The matter is surface matter, lordship, where the bank is trying to take possession of the property which is not mortgaged to the bank, lordship.
Yes. Yes, please.
Lady, a widow, and solicitor of a testament. Now, your lordship, maybe on the earlier occasion, had heard this matter for a couple of
challenged.
She filed an probate, and after being objected, she filed an ordinal. Came to know that a big fraud had been committed with the connivance with the bank authority by an intruder. Your lordship, since the matter is pending so long, your lordship.
Wait for some time. No. Yes.
My lord, without pollution certificate, my business is hampering, my lord.
Not right now. Yes. I know nothing doing. Yes. Yes, anything to say?
I mentioned that is application 184 matter. That matter your lordship already directed municipal corporation Vidhan Nagar municipality to submit a report why they had not paid my due. But without.
Cannot go into those now.
But
Yes.
I'm paying for upgradation in respect to item number 33 of the monthly combined list. But my trade license has been suspended and I have been blacklisted by the Paschim Bongo Gramin Bank.
No, no, cannot include now.
Lordship, item number 131 for upgradation. The petitioners are immunization volunteers. They're entitled to get, they are getting rupees 90 per day.
Hand over.
May I find?
Upgradation.
Yes, Lordship.
It upgraded matters listed. Yes.
Grateful, Lordship.
Please take the microphone. It is near you.
My lord, this is my lord for inclusion in the list, my lord. It's a motion stage matter, my lord. The petitioners are not getting their payments for a long time, my lord. And they're suffering from
What
financial.
are you? What are the petitioners?
My lord,
Payments in lieu of your contractors. Did somewhat.
yes, my lord. They have
Wait for
supplied
some-
something.
Wait for some time. Yes.
Item number 223 of your lordship's list today, my lord, withdrawal, my lord.
Withdrawal handover. Yes.
Your Lordship, item number 140 of today's list, Your Lordship, the urgency is that the petitioner is a company who has been rendered out of business, Your Lordship, due to an order which was passed without jurisdiction. And all the workers are in starvation.
Wait for
Your
some
Lordship.
time, please. Yes.
Lordship, this is going on since May.
Wait for some time. Yes.
Item number 148 of today's list, my lord, the urgency is that the BSNL authorities, the respondent BSNL authorities are
Can you give my microphone to her? Yes.
the respondent BSNL authorities are precluding the petitioners from raising new invoices, and for that the GST amount is withheld. So, my lord, the
Not
petitioner
right now. Yes.
My lord, may we permit to mention for upgradation of item number 170, tender work order can be issued at any moment by this week. my lord.
No.
My lord, earlier on,
No.
I also mentioned.
Yes.
Passport matter, petitioner already the year 2021.
Please wait for some time. Passport. Yes.
By 97 lakhs has been withheld by Ministry of Commerce and Tea Board. I'm a cheap lending company.
You played very well in the program, but this matter is refused. I'm sorry. No. For the guitarists are there together. Yes. So same order for you also.
I have a lordship to mention, the fast food center is being run from my building. I'm a tenant.
What is being run?
Fast food center, without any file license, without any food license, nothing.
You are serious. It is so urgent.
It's an older dilapidated.
No, no.
Causing some hazards.
Not right now. Yes.
Sir, item number 644 of the monthly list, urgent matter. It was upgraded when the government was.
That is extremely urgent. I can understand. But what now?
My coaching my series and the drag license has been issued by the.
No, no. Not right now. Yes. Next.
Medicine has.
Interesting, but not right now. Yes. Parkinson, I can understand. We have scored a brownie point, but what is your cause of action? No, sorry, not right now. Yes. Yes, Miss. Yes. Please wait for some time. Yes. Tender wait for some time. Yes. Then it is not urgent at all. Yes, Mr. Ghosh.
105 of your supplementary list, your lordship.
আপনি নিজে লুকিয়ে হয়ে গেলে আপনি শুনবো আপনারটা
5 of your lordship supplementary list so that this matter in connected matters your lordship had appeared have an XC order.
কানেক্টেড ম্যাটারস ইয়েস ওটার সঙ্গে একটু দিয়ে দিতে পারি যে নাম্বার আইটেম
May I permit one mentioning the upgradation, new connection quotation
Pardon?
Your lordship
For?
For release, when your lordship had appeared for the same client.
Oh, acha, you mentioned for release. Very well.
May I permitted one mentioning lordship the new connection of the lordship. The quotation money was deposit lordship.
No, not right now, no.
That's a 348, my lord, upgraded motion, my lord.
Of which section 348 or?
No, my lord.
What is the urgency?
Urgency is, my lord, I am filing RTA application, my lord, there's not a proper answer, my lord.
No.
Not supply in.
Item number 440 of your lordship's monthly list. But on account of my job, I am scheduled to travel in October. Now, my lord, the authorities say that they are not issuing the passport to me. But kindly consider.
Wait for some time. Sadash, no.
Job, kindly.
I've released sufficient passports till now. No, not anymore now. Yes, Mr.
But only thing is the
No, Mr. Das, not right now.
Non-payment of victim compensation.
Hand over. Yes.
Your lordship, this is a listed motion, your lordship. whereby this matter had been heard before by your lordship, and due to the court deficiency, the matter till date is pending. It is a termination of the station ticket booking agency.
Station?
Station ticket booking agency, your lordship.
Wait for some time, please. Yes.
Lordship, this matter has been earlier mentioned before your lordship, and your lordship was pleased to allow this matter, yet this matter has been.
I've changed my mind. What is the urgency now?
Lordship, the petitioner are octogenarian, your lordship. They are senior citizens and they are been deprived by their own son and daughter-in-law.
There is an act for you. Go before that for us.
Lordship, the petitioner has duly moved to the DM and the other concerned authorities under section 22 and 23 of the Maintenance Act.
What is the cause of action here?
Lordship, the concerned respondent authority, the DM and the deputy, the BD.
They are not doing what?
They are not complying with the directions, your lordship.
What direction? Whose direction?
They are not complying with they are not looking after they are not looking
Taking up the matter.
They are not looking into the representation, your lordship. They have duly represented before the
Handover. Representation. Yes.
Your Lordship, may I be permitted to mention one matter? This is item number 79 in today's list. The urgency is that the responding authorities has already terminated the contract. They have invoked the bank guarantee. The bank guarantee cost around 1 crore 50 lakhs, your lordship. Also, they are now going to float another tender, your lordship. Kindly fix it.
I'm sorry, ma'am. No, not right now. Yes.
May I permitted to mention item number 287 of monthly combined list. My urgency is that, my lord, it is against the Howrah Industrial Park, my lord. My lord, we were allotted block A kind of shop room, but my lord, we have paid for that, but now, my lord, we are being allotted block B. My lord, we are paying on block A, my lord, we are being paying to block B.
No,
my
not
lord.
right now. Yes.
To mention on that, lordship, monthly item number 7, lordship.
Take the microphone. Yes.
The respondent authorities, lordship, illegally freeze the bank account of the petitioner. There and reason said that a complaint has been received, but no any kind of information has been provided. Lordship, kindly.
No, not right now.
Kindly,
Yes, Mr. Huda.
Lordships, kindly mention item number 64 of your lordship's list, my lord. This is in respect of, my lord, a tender, my lord, for supplying tank trucks to IOCL, my lord. It's item number 64, the only.
May I be permitted to mention, my lord, in the monthly list of August, my lord, 865 is the matter, my lord, for upgradation, my lord, in a suit for a permanent injunction and declaration, my lord, the evidence of the petitioner witness has been completed, my lord. The defendant have filed an application under Order 6, Rule 17, my lord, much prior. Much after the completion.
So what do I do with that?
My lord, the next returnable date in before the trial court
I
is.
don't have determination.
My lord, it is appearing in the monthly list, my lord.
Item number?
865, my lord.
It's a CO or WPA?
CO.
It's an assigned matter.
Yes, my lord.
Say that. Yes, what is the urgency? Order 6 Rule 17?
Has been accepted, my lord, by the trial court, my lord. My lord, the next date, returnable date is on 23rd of this month, my lord.
Take time. See, the judge is not taking up any.
I'm not trouble you, my lord.
Don't trouble me at all.
My lord, kindly fix in the September. Any day?
No,
Any day.
sorry, no. Yes.
We are, my lord, market owners in the Howrah Maidan metro station area. Now
Yes.
the metro is going to start from October. We gave up our land on the condition we'll be rehabilitated back in the same place. Now they're changing the allotment. They are forcing us to accept the new allotment, which would be bring for
Yes.
leave.
My lord, read
Leave.
petition, my lord.
Why leave? File it in due course.
My lord, may I
File it
try?
in due course. Give the number to my officer. It will be
Lordship.
taken up as a news. Yes. Yes,
My lord,
Prasad.
third round of litigation, my lord, writ petition challenging an order, my lord, rejecting my RC2 certificate only on the ground that the date of commercial production is not correct. My lord, this is pursuant to an order of, my lord, our High Court, that the authority passes this order, ignoring the, my lord, information memorandum issued by the Department of Commerce, which specifically says that the date of commercial production is such and such.
No, sir. Not right now. No. Sorry. Yes.
Item number rejected for
44 is in the upgraded list. No further upgradation. No further upgradation. Yes. No further upgradation. I'm sorry. Yes. No, new connection. Wait for some time. Yes. Sorry. A bit louder, please.
Refund of provisional bill amount. The petitioner is more than 70 years of age. Your lordship, hardly is matter substantially. Your lordship is because the.
Wait for some time. Mr. Gupta, I'm sorry.
66 of my lord's list. Well, it's a training course which the petitioner has been interested with by the central government.
but for imparting vocational education and technical education to 840 students. Now payment was to be made in phases. We have been made the first phase payment. The rest has not been paid, and the entire course is
Vocational course of what sort? For which people?
imparting technical education to 840 students. It's a central government and state government.
Hand over.
766.
Upgraded. Yes.
Item number 213, my lord. The petitioner is a 84-year-old year, my lord, senior citizen, my lord. Now the private respondent, what he is doing, my lord, by misrepresenting before the election commission and the other authorities, my lord, he has portrayed that he is the brother of the petitioner. Now, my lord, he is getting the land recorded in his favor, my lord. My lord, kindly, my lord, because my lord, we have made complaint before the other authorities.
Not
because there was no deed of adoption, my lord, nothing, my lord.
May I be permitted to file this with leave of your lordship to file this matter? The urgency is, the lordship. I am running a common biomedical.
Why is leave required? File it in due course.
Lordship, the thing is, there is an allocation, your lordship, for collecting of waste by the CBWTF. Your lordship, now the allocation, I have to travel more than 150 kilometers, your lordship, which is not in the statute, your lordship. I have to collect the waste.
File it in due course, please. Yes.
May I be permitted to mention one matter for inclusion, your lordship? This is a matter relating to Right to Information Act. There are 3 second appeals pending before the concerned.
Right to information, I cannot give precedence now. I'm extremely sorry. No. Yes.
Item number 459.
What is the urgency?
My lord, in front of my dwelling house, there is a public pathway noted as.
Oh, no, not right now. Yes. Mike.
Deeply apologize for mentioning the matter again.
Accepted, but not. Yes.
This CSC matter, my lord, the Chandrasekhar Gupta, the developer is stopping my from the CSC and the petitioner from complying to my lordship's order.
Wait for some time, sir, please.
May we permit to mention for
No, from that side, yes. Oh, wait for some time. Yes. You. New?
New electricity connection.
Wait for some time. Yes.
Person may I be permitted to mention, lordship, item number 64 of today's list, lordship, which is electricity matter. The petition is above 60 years.
Electricity, wait for some time. Yes.
So it's electricity charging surplus electricity.
Wait for some time, not now.
I'm praying for inclusion, my lord. The petitioner runs a sawmill for more than 15 years. Now, my lord, the forest department has cancelled his license with it.
No, not right now. Yes.
This is item number 388 of the monthly list. My lord. I had mentioned it on the last week also.
What is the urgency?
My lord, the insurance claim of the petitioner hasn't been settled. My lord, in
No, wait for some time. Yes.
expiry of the statutory period.
My lord, my section 14 application under the SABYASACHI Act has been kept pending by the district magistrate.
Wait for some time for this. Yes, you first, then I'll come to you, Doctor. Yes. Apni mic hai ashun.
Your lordship, DRT3 recovery officer ব্যাংকে ম্যানেজার মিলে আমার প্রপার্টিটা আন্ডার ভ্যালুতে 24 নভেম্বর 2021 বিক্রি করে দিয়েছে। টিল ডেটে আমাকে না হিসাব দিচ্ছে না টাকা দিচ্ছে।
আপনি ডিআরটি তে গেছেন?
স্যার ডিআরটি
করেছেন?
হ্যাঁ, ডিআরটি আমাকে বলছে 6 লাখ টাকা পেড রিপোর্ট না দিলে
ডিআরটি তে অ্যাপিল লাই করে, সেটা করেছেন?
ডিআরটি তে মামলা চলছিল 2000।
তার বিরুদ্ধে অ্যাপেলেট ট্রাইব্যুনাল আছে, সেখানে যান। এখানে আর্জেন্সি গ্রাউন্ডে
বলছে ডিআরটি বলছে 6 লাখ টাকা পেড রিপোর্ট দিলে তবেই মামলা শুরু।
এটা অত আর্জেন্ট নয়, আমি এখন ঢোকাতে পারবো না লিস্টে। আই এম সরি। ইয়েস।
My writ petition against medical council. My lord, they are acting.
Your matters are not at all urgent.
No, my lord, that's not the point. No, my point.
That is the only point.
No, I came
for
here 2 months
inclusion,
ago.
that is the only point.
Kindly let me just 1 minute. I came here 2 months ago.
Mr.
You
Dr.
said
Shah,
this
you
was
can
some-
have a very good point on merits.
No,
but I cannot because I am refusing 84 year
Okay,
old
but just
people.
put it to be mentioned. Allow me for VC. Let me go. I have to go back. I am waiting 2 months, more than 2
No, I'll allow you VC then. If you're out of station, I'll definitely allow you VC.
So then keep it,
Have to
kindly
apply
keep it
for
to be mentioned and pass an order in this because I will be gone.
Very good.
So
Hand it over to be mentioned. Very good. I'll do that.
Grateful.
Not my technical.
No, advocates mentioning is over. Yes, call on the list.
For judgment, item 1.
Beg to appear on behalf of the petition.
Yes. Accordingly, WPA 21887 of 2022 is allowed on contest, directing the respondent number 7, the special officer pension, Government of West Bengal, to disburse the entire retiral pensionary benefits of late Shochipati Ghotok, an ex-employee of the Katua Subdivisional Hospital, Paschim Burdwan, calculating such pensionary benefits by applying the appropriate scales for the entire period till the demise of late Shochipati on December 28, 1981. Such disbursal shall be effected within 2 months from the date of communication of this order to the respondent number 7. It ought to be recorded here that interest is not being awarded on such amount, since I cannot find any patent malafidez on the part of the respondents, as it genuinely appears that the respondents have, over a period of time, made efforts to trace out the records of service of late Shochipati Ghatak, and there was a bona fide doubt all along as to the entitlement of the petitioners to the retirement death benefits of the said employee. Respondent authorities are also directed to consider as to whether either of the petitioners is entitled to family pension on the demise of late Shochipati. Upon deciding on such issue, a communication in that regard shall be made to the petitioners by the respondent authorities within 1 month from date. It will be open to the petitioners, if agreed by such decision, to prefer a further challenge before the appropriate forum. No address to cause urgent certificate copies.
Deeply obliged. Deeply obliged.
Grateful, Your Lordship.
Thank you.
Interest time.
No.
Sir.
Sir, but
Sir. May I, sir? Extension of interim order, item number 2.
Yes.
My lord, I appear for the petitioner.
Right.
In this case, Your Lordship, there's a debarment order that has been stayed by Your Lordship's order dated 17th of March.
The stay is expiring when?
On 31st of August, my lord. But there's one more aspect of the matter, my lord. After the filing of the writ petition, we emerged as a successful bidder in several other tenders, 7 in number. We filed an application being Can 1 before Your Lordship for further orders in aid of the early interim order, because even though we emerged as a successful bidder, we are not being issued the tenders or the letters of acceptances. So we were L1 in all these tenders, my lord. But on 17th, there's a letter after we filed the Can application, we received a letter which has been issued. May I please hand it over to Your Lordships the time being?
Yes.
May I please place the letter, Your Lordship? This is dated 17th of August 2023. Your Lordships will kindly notice the reason for issuing this clarification, so to say. The attention is invited to this office letter referred to above, via which order of debarment from Ms. Webfield Limited from participating in the procurement process of the Ministry of Railways and its attached subordinate offices, autonomous bodies, etc., for a period of 6 months from 3rd of March 2023 was communicated. Para 2. Subsequently, Messrs. Webfield Limited filed a writ petition being WPA number such and such, Messrs. Webfield Limited and other versus Unit of India and others, against the debarment order of Ministry of Railways in the High Court in Calcutta. Thereafter, Lordships, they reproduce the operative portion of the interim order. In Para 3, the above stay order has been extended. Your Lordship is being led by. Lordship, Para 3, the above stay order has been extended from time to time. In Para 4, Your Lordships, they quote the legal opinion that the cell has given to them. The board has received references from zonal railways seeking clarification regarding debarment.
So they're willing to consider your tender now.
Your Lordship, this is just a legal opinion. This is not a binding instruction. And Your Lordship, this has been issued by the issuing authority of the debarment order.
Yes.
But it does not say you follow it. It just communicates a legal opinion. So we will be pressing our Can. We will be pressing our Can application. We just want to place this on record that their own legal cell admits that we are allowed to participate in the tender processes and that it may be given. We participated.
What is the application for? What have you sought in the Can?
Your Lordships will kindly see the prayers at page 9.
With this letter.
Yes.
Lordship,
So Mojumdar, if you want, you can take over.
Lordship, this Mr. Shatru,
So let me hear him first. Yes. Yes.
But the debarment order has been stayed by this honorable court. But after the stay order, we were emerging successful bidders, but work orders were not being issued to us by the railway authorities, probably because of the stay order and not the issue not having been finalized. In that context, our business was coming to a standstill. So we filed this application so that this would not stand in the way of work orders being issued to us. Now, it has now transpired after filing of this application, and we sought for certain further orders rather, that they are obtained legal opinion and this
apparently in your favor.
Accordingly, it's apparently in my favor. So not all that we pray before your Lordship today is
So I'll
kindly.
keep this Can pending then. If they don't comply with this legal opinion of theirs, then you can press the Can.
Yes, can't keep it
I'll not
pending.
decide it right now. So that will,
Not necessary.
Cannot.
Some observation may help. That's all.
I'll only extend the interim order. I'll keep the writ petition along with the Can on some day.
Yes, Lordship, for hearing, Lordship.
For hearing.
Final hearing.
Both
Yes,
together,
Lordship.
yes.
Kindly fix a date, Lordship.
Very well. Learned counsel for the petitioner submits that during pendency of the matter and subsistence of the interim order passed herein, comma, the case was apparently examined by the legal cell of the respondent authorities, which opined that in view of the interim order passed by this court, the petitioner has got the same rights and responsibilities as other bidders stroke tenderers, and the railway cannot infringe its right by not considering its tender and not awarding tender if it becomes the L1 bidder. Full stop, next para, it is submitted by learned counsel that although the said legal opinion is apparently in favor of the petitioner, comma, an interim application is now pending permitting work orders to be issued in favor of the petitioner in the event the petitioner emerges successful. Full stop, next para, it transpires that it would be premature to decide the interim application at this juncture, comma, since apparently the legal opinion of the respondent's legal cell is for the present in favor of the petitioners. So be that as it may, comma, the decision on the application is dependent on the adjudication of the main writ petition. So accordingly, Can 1 of 2023 shall be listed along with WPA 6526 of 2023 on September 12, 2023, fairly at the top of the list. Full-stop, the interim order granted earlier stands extended till October 19, 2023, or until further order, whichever is earlier.
So, Lordship, preferably may fix a time then. Because Lordship is suffering the interim order for the long, Lordship, and it was fixed for hearing on several occasions, but could not call on.
11:15 would suit you, 11:15 or 11:17. Which time suits you? I've fixed a particular date. I've said fairly at the top of the list. That is sufficient. I can.
But instead of 12th, I was praying for 13th or 15th, subject to the convenience of.
Instead of 12th?
Yes.
15th, very well. September 15th. 15th.
Grateful.
Not the.
Video service. File on record. Kept on record. Yes.
Top item, item 3.
Lordship, I beg to appear on behalf of the respondents.
I'm appealing for the petitioner.
Yes, sir.
This happens in 2017.
Yes.
There was a e-auction on scrap of cast iron by the respondents in 3 different lots. I participated there, and being a successful bidder over there.
You're for the petitioner?
My lord, I'm for the petitioner.
Yes. So habituated in finding you on the.
Actually, my lord, it's my misfortune that I could not get you for so long. Actually, my basic practice was in the revenue side. Actually, that's why.
You're very confident this side also. No. Yes.
I'm learning in this process, my lord.
Please take your seat.
This scrap cast iron.
You have a seat behind you, no?
I'm asking for my juniors to give me a seat.
Anyway, yes.
My lord, I participated there and I became a successful bidder. After that, my lord, I was allotted the 3 lots itself. A particular date was mentioned for making me payment. I defaulted for some period of time. That was accepted, and for that period, a particular interest was also charged. I paid the interest successfully, and the entire payment was done. I'll show from the document. And after that, my lord, I was given a particular time to take that goods from the godown, which I cannot, due to the reason that a particular period, I'll demonstrate from the documents itself, that there was a puja during which it remains closed, and trucks and nothing was available to that effect. My lord, 40 days delivery time was free of ground rent. That is, it was in the e-auction itself. Now, my lord, within that period, I asked for an extension of the period. I was asked to pay a ground rent on that. After a particular period, they have said, no, you'll have to pay the ground rent. I disputed that. Well, on that score, subsequently, I have been issued with a notice that we are going to cancel and everything. But prior to that, my writ petition has been filed. During the pendency itself, they says that it was, Lordship knows that it was dismissed for default in 2019. We made immediately an application. Lordship, on the last occasion on Friday.
How is puja good as a ground? Does it continue for 40 days?
My lord, no.
Unless you see it's act of God, literally.
My lord,
because it's puja.
may I explain, my lord?
exactly, we asked for this particular period for 7 days.
Yes.
And thereafter we said within that 40 days, what I was having, actually 40 days was free of ground rent. That I,
So you did not pay the ground rent because you had challenged?
Well,
For
no,
that, they are
I
now
said
penalizing.
that they are asking for ground rent. I said that ground rent is not payable for me because I have 40 days of free ground rent.
Yes.
Without
So they are asking for ground rent before that 40 days.
Yes, my lord, that was the original writ petition.
Achha.
Now, sometimes in 2022, my lord, all of a sudden I got a notice that your lot has been cancelled, your sale has been cancelled. My lord, my limited scope of this writ petition is whether ground rent was at all chargeable on me or not during that particular period, and the letters that they have made, whether that ought to have been within the limits of this, the terms and conditions of the e-auction.
Give me the dates, Mr. Ganguly, first. The date when you stopped paying or whatever. I mean, when the 40 days expired. And
Yes. My lord,
give me
originally,
that. Give me the dates. Show me the clause. Get your order. Yes.
at page 39, your lordship will find the sale release order after my payment.
No, that is post facto. First, you have to satisfy me on the ground rent.
My lord,
Non-payability.
my lord, that is the very first issue, because ground rent will start till the sale release order is not with me. I cannot remove the goods.
My lord, may I just indicate, sorry for disturbing in the middle. Since, my lord, we have been only assigned with the can.
Oh.
Can, my lord, and it was all, and my lord has fixed today on the very limited thing, my lord, because my lord might remember on the last.
Can is for?
Can is for recalling the dismissal order, my lord.
So that has
which my lord is allowed.
restored yesterday, as I'm
Just a
told.
minute. I will just take
So
a
that has been allowed.
That has been, my lord, only the thing, my lord, my submission was very limited to the point, my lord. This writ petition was filed way back in 2018. 2019, my lord, the writ was disposed of, dismissed. My lord, now we are standing in 2023, end of August.
So you said it was sold to a third party. They were taking instruction on this.
My lord, they said, my lord, now we are in 5 years, practically 5 years have gone, my lord. In meantime, the stocks were there, my lord. On last occasion, I have submitted same thing, my lord. As per records, my lord, the ground rent as of 23rd of February 2022 stand at around 4,51,82,305. So, my lord, 5 years has gone. There was no order, my lord. There was no communication for them. This is the public money which was involved, my lord. So we do not have any option rather to sold that scrap because that would have become completely valueless, my lord. 18 to 22, my lord. In 22, again it was
Scrap iron.
Yes, my lord, and that was occupying a whole lot of area, my lord. Neither we were getting the rent for that period, 4,51 lakhs and odd, my lord. That
So there was no stay order also.
no
So
stay
you
order,
could
my
have-
lord. After 5 years, what was the
You
option?
say it
left?
has become infectious. That's why.
Yes, my lord. What was that? Practically speaking, what was other option that was left to us, my lord? Apart from selling it off.
Then I'll give them liberty to file suit for damages if they're entitled.
If there is any case at all.
If they're entitled.
If they are entitled, my lord. That is my
Yes,
submission.
Mr. Ganguly,
because-
what do you say to that? If they've sold off. No, you may have a very good case. But if I go into the merits of that, since the scrap iron was the premise of the subject matter of this writ petition, that has been sold out. Good, bad, indifferent, whatever the outcome. Now, if they've sold out, you cannot get back those items now. Your only relief lies in damages. If you have to get damages, you have to quantify the damages and you have to satisfy whatever court you approach that yes, there was scope of damages. That entails an adjudication on facts by taking evidence.
No,
So
that was only
I'll give you that liberty. I'll dispose of
My
it.
lord, may
This
just
has become
indicate
infectious.
one issue.
Yes.
My lord, whether the ground rent at that point of time when I preferred the writ petition was at all maintainable or not, my lord, that issue might be.
Mr. Ganguly, that issue remains.
It
I
remains.
agree to that.
My lord,
But that issue cannot fetch you an order, even if you win on that issue. Even if I say that yes, ground rent was not payable by you before that or whatever, in your favor, then also the relief you can get is damages. I don't want to prejudge on that. I'll give you liberty to go before the civil court. It has to go before civil court if you ask for
No,
damages.
yes,
It
yes,
court cannot.
it has to.
I'll keep all questions open because you have to satisfy the civil court two things. One is that your termination or whatever action they have taken, that was illegal. For that, you have to satisfy that court that ground rent was payable or not. All the questions have to be decided. That is the first component you have to show. And second component, what is the quantum of damages?
My lord, so far as the second part is concerned, as it had fallen from your lordship, absolutely we have to pursue in a
There is
suit
no other
court, otherwise
option.
there is
Yes.
no other option.
Yes.
The reason is there also why we are saying, because the goods, it is not the fact that we have made a part payment. Part payment remained unpaid. Therefore, they are automatically because the ownership of the property transferred to me. Therefore, I have to get a sufficient notice that, look, either you are to pay 10 rupees or else your scrap, whatever may be the ground rent, they may charge at best the entirety of the ground rent for the entire period till date.
Why do you say you have ownership?
My lord, because entirety has been paid under sale release order. My lord, if your lordship kindly takes up this sale release order.
Even then the only relief you now can get is damages.
My lord, yes, that is there. But my lord, that
if I can't quantify damages, why decide it?
My lord, but the very preliminary issue
will be a futile exercise.
My lord, that preliminary issue, my lord, whether at all that period during which at the time when I came before your lordship, my lord, whether that ground rent was at all payable by me, my lord,
that question will remain open. I'll hold that. Learned counsel Learned counsel for the respondent submits that in view of the long pendency of the application for recall, the respondents were compelled to sell out the iron and steel scraps, which are the subject matter of the writ petition, to third parties. Full stop next para, as such, it is submitted, the writ petition has become infructuous. Full stop next para, learned counsel for the petitioner submits that the petitioner has challenged the writ petition on several aspects, including on the question as to whether the respondents were justified in charging ground rent for the relevant period at all. It is submitted that by way of the sale to third parties, the respondents have virtually rendered the writ petition infructuous, despite the pendency of the same. Next para, upon a primary consideration of the arguments of parties, it is evident that the relief sought by the writ petitioners entirely pertains to the iron and steel scraps, which have already been sold out to third parties. Even today, if the petitioner succeeds in getting an order in the writ petition, the best relief which the petitioner could get is one of damages, which cannot be quantified by the writ court without taking elaborate evidence. Next para, instead of prejudging one of the issues piecemeal, it would be appropriate if the entire question is left to be agitated before an appropriate and competent civil court, giving liberty to the petitioner to seek damages, if it is so entitled. Next para, needless to say, the entitlement of the petitioner to get damages also hinges upon the outcome of adjudication on the preliminary issue as to payability by the petitioner of the ground rent during the relevant period in the first place. Next para, instead of deciding the writ petition piecemeal, WPA 13800 of 2018 is disposed of as infructuous, with liberty to the petitioner to seek the appropriate relief of damages and ancillary reliefs, if the petitioner is so entitled, on the self-same cause of action as taken in the writ petition. Next para, it is made clear that if the petitioner approaches a competent civil court for such reliefs as indicated above, it will be open to the civil court to decide all issues, including those challenged in the present writ petition, on its own merits without being influenced in any manner by any of the observations made herein. No address to cause urgency. Thank you. Next.
Item 4.
But I paid for the writ petition.
Yes, Mr. Mujumdar. You have for the
For respondent number 2.
2. Right.
Number 2.
Yes. 2 is the main party. No, 2 is the private.
I think the West Bengal
clinical establishment has.
Yes.
You have served properly.
We have served twice perhaps.
They have filed an application also for
Let me hear out then. If
Yes,
they choose not to appear.
Kindly take the writ petition one.
Yes. Please take your seat.
Yes. But the subject matter of challenge is an order passed by the West Bengal Clinical Establishment and Regulatory Commission dated September 6, 2021. The Lordship will find this order at page 66. And before I take your Lordship to the order, may I place the facts before your Lordship? Matlab, they are, matlab, the petitioner
Clinical
is-
Establishment audit through Clinical Establishment Act about Clinical Establishment Act. Yes, please continue, Mr. Majumdar.
matlab,
I'm sorry.
this, the petitioner runs a hospital, namely Bhagirath Neutia. Park Hospitals, matlab. Now, matlab, what happened on 24th April, it appears from the pleadings and the, matlab, the submissions made on behalf of the parties before the Clinical Regulatory Commission, that on 24th April 2021, matlab, a patient came to this Bhagirath Neutia Hospital. Matlab, the patient was being treated by a doctor, namely Dr. Namta? No. Dr. Khaitan. When we call Dr. Khaitan, Dr. Khaitan is also associated with Bhagirath Neutia Hospital. When we contacted Dr. Khaitan, that what do we do about this patient, Dr. Khaitan told us over the phone, the telephonic conversation is also on record, that this hospital does not have the necessary facility for treating a patient suffering from eclampsia. That's a gynecological disorder associated with some neurological disorder also, eclampsia. Now, my lord, then obviously, my lord, we gave some, administered some preliminary treatment, arranged for an ambulance, and the ambulance took the patient to, my lord, the Bellevue Clinic and Hospital. When the patient arrived at Bellevue Clinic and Hospital, my lord, the Bellevue Clinical Hospital also appears from record, attended the patient, and the patient died at the stage of admission in the Bellevue Clinical Hospital, Bellevue Clinic. It also transfers from record that Dr. Khaitan, admittedly, Dr. Khaitan advised the patient party to take the patient to Apollo. Now, my lord, it so happened that the patient was taken to Apollo. Apollo refused admission. The patient on its own, the patient party on their own, took the patient to our hospital. My lord, we consulted the doctor. The doctor told us that this treatment cannot be rendered in this hospital. So the doctor advised us against taking admission of that patient. We immediately arranged for an ambulance.
The doctor is on your panel.
The doctor is, yes.
He's your, he's
one of the doctors associated with the hospital. And my lord, finally, the patient was taken to Bellevue Clinic. My lord, if your lordship finds, you will not find from the order that Apollo has been spared, Bellevue has been spared, and my lord, all the penalty compensation as we are now being pointed out as we are responsible for the death of this particular.
So Apollo refused in the first instance?
Yes.
And Bellevue, she died in Bellevue?
Yes. But what, interestingly, my lord, in response to the complaint, we filed an affidavit. My lord, there was no rejoinder to the affidavit. My lord, the commission, while deciding the matter, was clearly swayed by the opinion of an expert, namely Dr. Madhusudan Banerjee. My lord, the commission did not even consider our affidavit in totality. But if your lordship kindly takes our affidavit for once, one by one. Kindly take our affidavit, which your lordship will find at page 56. Yes. But kindly take from paragraph 7 onwards. 6 onwards. That the concerned patient Shraddha Bhutra, now deceased prior to the night of 24th April 2021, had no maternity booking at our hospital, although that is not a precondition. That on 24th for 2021, Shraddha Bhutra, now deceased, was brought to our hospital by her family members at about 11:15 p.m. That after arrival of the aforementioned patient, she was taken to the emergency department and examined by the RMO on duty at emergency department at that point of time. That the RMO, after examining the patient, found her to be in delirium, agitated and disoriented, and was restless. She was even not allowing the attending physician to examine her. The concerned RMO of the hospital had contacted the consultant, obstetrics and gynecologist of the patient, Dr. Supriya Khetan, over telephone to inform her about the patient's conditions. That being apprised about the situation of the patient, the above-mentioned consultant informed the RMO over telephone that she advised husband of the patient to get the patient admitted in Apollo Hospital, being a multidisciplinary hospital. That Dr. Supriya Khetan further informed the RMO over phone that she will instruct the husband of the patient to shift to Apollo Hospital. That during this period, the RMO of Bhagirathi Neotia provided basic emergency treatment in consultation with the consultant, Dr. Supriya Khetan. That thereafter, as per instruction of the consultant, Dr. Supriya Khetan, family members of the patient desired to shift the patient to Bellevue Clinic. Accordingly, our hospital arranged for an ambulance as a humanitarian gesture for expediting the transfer of the patient to Bellevue. That in the meantime, after administering the basic treatment, necessary prescription was prepared and handed over to the husband of the patient. An office copy of the said prescription is marked with letter B. That during the period of stay of the patient in the emergency department, no negligence in a treatment was done by the attending RMO. All steps were taken on ward footing manner, considering the distress of the patient. That since the consultant physician of the patient, Dr. Supriya Khetan, did not want the patient to be admitted in our hospital.
What was the reason for Supriya Khetan and you blindly accepted that? You also are a clinical establishment. You haven't, I mean,
we do not
some
have
reason has to be there.
We did not have the
Nothing
necessary.
is reflected in opposition.
The opposition has not been answered.
Here, has it been reflected even that yes, this is the reason? You only say, doctor, you put it entirely on Dr. Supriya Khetan.
This was attended by an RMO, there's a resident medical officer.
Yes.
The RMO consulted Dr. Khetan. Kindly
she did not want the patient to be admitted. This is not a ground. You are a clinical establishment.
Kindly take, for once, the telephonic conversation, which your lordship will find at page 32.
Yes.
Because that telephonic conversation will have some impact on this matter.
You have the backup, I mean, this was taken from
this eclampsia, this is essentially.
So this telephonic conversation, how do you prove that this was?
This was part of the records. There is no doubt about it. This was placed before the commission.
Yes.
RMO Dr. Samina Ali receives the call and starts speaking to Dr. Supriya Khetan. Dr. Samina Ali, your patient has come, the one you had asked to go to Apollo, but she is in delirium. We are not being able to check her BP, fetal heart sound, because she is not letting us. She had a convulsion probably and might have got high blood pressure. So what do you want us to do? At Neotia, there isn't a proper ICU. That's why I had told them to go to Apollo. Otherwise, I would have myself told them to go to Neotia. She needs ICU. We are not being able to check anything basically. She is not letting anyone check. Is she conscious? She is conscious, but altered consciousness. She is in delirium. She is in constant mumbling. She is not letting anyone check her BP. She is not letting anyone.
You have seen it. This was a contemporaneous conversation.
This is the conversation we led the RMO to arrange for the ambulance and shift her, because the patient party also wanted to shift her to some other establishment.
Very well. So lack of proper ICU and
lack of proper ICU is there. That reason is there. Right. That is the reason is there. Kindly take the complaint now, because the lordship will get the jurisdictional fact in the complaint itself.
Right.
Kindly take the complaint, which starts at page 36. Kindly take the allegations from paragraph 7.
Yes.
Paragraph 6. That the crux of the case was started on 24th day of April, when the petitioner and his pregnant wife went on and around 8 p.m. with mild chest pain to the doctor's chamber at Bangur, and after checkup by Dr. Supriya Khetan, The petitioner's wife had been instructed that everything is normal and no need to worry at all. And accordingly, the petitioner and his wife returned at home. That thereafter, very next hours on and around 10 p.m., again, petitioner's wife, feeling severe and flagrant pain in her lower abdomen, for which the petitioner rang to the doctor for immediate medication of his wife, considering the present situation, but it is utter surprise that Dr. Khetan refused to medicate, and neither she agreed to come to the house of the petitioner to oversee the current situation of the petitioner's wife, nor she advised to come to her chamber. Rather, the doctor advised to visit hospital. That the petitioner states that after such inhuman and impassive behavior with his family, the petitioner became amazed, and the petitioner had a belief such and such. This is all about the doctor.
Yes.
The petitioner has no other option to go to the nearby hospital to save the life of his wife and his child, who is growing in the womb of the petitioner's wife. And accordingly, the petitioner reached Apollo Hospital at EM bypass with his wife, but Apollo of his hospital did not admit his wife on the pretext of COVID treatment are going on and that hospital, where number of COVID patients are admitted, and the petitioner, after realizing the present situation, rushed to Bhagirathi Neutia Women and Child Care to admit his wife. That the petitioner.
So, the Bhagirathi Neutia Women and Child Care Center does not have an ICU.
Well, for this purpose, this is eclampsia. Well, it requires.
What is the spelling of eclampsia?
ECLAMPSIA. Eclampsia.
Very well.
Something to do with some. Well, it's a complex gynecological and neurological disorder. It's a complex of both the disorder. That the petitioner and his family members with his wife went to Bhagirathi Neutia, and when the petitioner reached with his wife to Bhagirathi Neutia Women and Child Care, then blood pressure of the petitioner was 117, which was confirmed by the said hospital authority. That the petitioner states when the petitioner came to know that diastole is 117, then the petitioner and his family members were praying before the administration of Neutia to admit the wife of the petitioner, but the authority of Neutia moving around here and there and whispering each other's ear to admit the petitioner's wife. In the meantime, petitioner had been informed that they had a talk with Dr. Supriya Khetan, and the hospital also said that the doctor had not. Well, this is very important. So the patient party also had a discussion, and the hospital also had a discussion with the doctor. Had not been instructed to admit his wife, and when the petitioner learned that both the doctor and the hospital authority refused to admit the wife of the petitioner, then the petitioner and his family members
the petitioner did not have a talk with Dr.
Kindly
Supriya.
take my lord for once.
They were informed by the hospital authority that she had.
They had been informed they had a talk, and the hospital authority, they had a talk. In the petitioner had been informed they had a talk with Dr. Supriya Khetan.
They means obviously hospital authorities.
Then it comes again, and the hospital authority said.
The petitioner had been informed
that they had
a talk with the Dr. Supriya Khetan.
And
if the petitioner had a talk, they were not needed to be informed.
The petitioner, then my lord, the second part of the second.
So that is in line, because if I am the petitioner, I cannot be informed that I had a talk.
And the hospital authority also said that the doctor had not instructed to admit his wife when the petitioner learned that both of the doctor and the hospital authority.
Learned entirely from Mr. Mujumdar. We have to continue from para 11. Para 11 says that he went to them to admit his wife, but the authority of the Neutia hospital moved around here and there, whispering each other's rather than admit the petitioner's wife. In the meantime, petitioner was informed
that the petitioner was informed. If we don't go by this,
I cannot be informed that I had a talk with somebody.
It may so happen, the petitioner may not directly have a talk with the doctor.
No, she did not. From this,
not she, the husband.
I'm sorry, he did not.
He did not.
As per this statement, no.
Let us take, my lord, the petitioner did not, but the petitioner was informed about a telephonic conversation. That there is no doubt about.
Absolutely, yes.
That there is no doubt about it.
So there is a tallying of that doctor conversation.
Right. And the timing also matches.
Yes.
If we take the timeline also matches. Despite several requests and enormous effort by the petitioner and his family members, the above hospital authority abandoned all requests and without giving any medication. This is again, my lord, incorrect. Well, because we have filed and rejoined affidavit, and there is no reply to that affidavit. Spent 45 minutes from 11 p.m. to 45 minutes, which resulting the death of petitioner's wife. That the petitioner thereafter went to Bellevue
So after that, the allegations against Bellevue.
After that, allegations against Bellevue.
Bellevue.
First against Apollo,
Yes.
my lord, the second against my lord, this Bhagirathi Neotia, and third against Bellevue.
Apollo has a better alibi probably. They were a COVID hospital, so they could have.
Well, they had a COVID hospital, but Apollo is truly a multi-speciality hospital.
Yes. But during COVID times, it was different.
Well, then we come to two hospitals, namely this Bhagirathi Neotia.
Bellevue.
The Bhagirathi Neotia is not a multi-speciality hospital.
No, it is.
Bellevue is a multi-speciality hospital, but my lord, Bellevue has some my lord, access to medical practitioners all over the city. But
Bhagirathi Neotia does not.
My lord, it may so happen, my lord. Bhagirathi Neotia is a purpose-specific hospital. It is a purpose-specific hospital. It's an SPV for maternity.
She went for maternity basically.
Yes, but no,
she was to have a delivery for
she
child.
was, that state was eclampsia, and that has been recorded in the order. It's not my saying, man. Well, today I file an affidavit.
Mr. Mujumdar, you should write in block letters in front of you, in your front office, that we don't treat eclampsia. Apart from eclampsia, other delivery patients, please speak to us.
I put the
This
question.
is not proper, Mr. You are citing some exotic name of a disease, but you are a maternity hospital. You should be equipped with this.
Then, my lord, the entire
take some steps.
Is it? I put the question myself with all humility.
Yes.
There were three actors. My lord, the first actor clearly denied admission. The second actor, when the doctor advised admission to Apollo. The second actor, the doctor did not advise admission to Bhagirathi Neotia. Still, Bhagirathi Neotia gives some preliminary treatment, maybe emergency treatment, and arranges for an ambulance. And the third actor is Bellevue, where the patient was brought from Bhagirathi Neotia to Bellevue. The order records that there was a lot of activity around. There was a lot of hustle and bustle around, as evident from the CCTV footage. And that is
of you.
No.
Bellevue.
And that is good enough. That is good enough. That is the reasoning of the this commission. Now we'll come then from paragraph 14.
So unfortunate for the patient itself.
Very unfortunate for the petitioner, but it would be, my lord, it would be.
How do the patient know?
There are many cases.
And all these things here. Maternity ward.
We all have our personal experiences to share. But my lord, what is most important?
But you have to empathize also with patients.
I will definitely empathize. My lord, I called up the doctor. It's not that I didn't call up the doctor. Doctor has to be admitted under somebody. The doctor who was treating this patient was Dr. Khetan. Dr. Khetan, in no uncertain terms, directed that you please don't admit this patient.
That's true. Yes.
Then, my lord, what do we do under those circumstances? We arrange for an ambulance. My lord, kindly come to the next part, the order.
The Khetan was also investigated. I mean, she was also a part of. Or are you trying to protect her?
No. She can be, but inquiry can be held only by the medical commission. The clinical regulatory commission does not have the jurisdiction.
Lordship, before the medical council, matter has been pending.
No, I'll come.
That's true. That's
a different side.
That's a different side. But my lord, so far as this clinical regulatory commission, kindly take the order now.
Yes.
The lordship has seen, my lord, now. Kindly take from page 66. But this is the backdrop of the case. My lord, I take your lordships to page 67. Kindly take page 67. My lord, kindly take from 1 to 10 lines from the top, to his utter surprise. Page 67.
To his utter surprise, right.
To his utter surprise, Dr. Khetan, but this backdrop is the facts as found out by the commission from the complaint and, my lord, the pleadings exchanged. Because thereafter, your lordship will find a heading complaint.
Right.
To his utter surprise, Dr. Khetan refused to prescribe medicine, nor did she agree to come to their house to examine the patient, only advised her for hospital admission. The complainant was surprised by such indifferent behavior of Dr. Khetan.
Backdrop, need we go through?
No, my lord, this is important.
Yes.
Apollo declined to admit.
No, she has admitted in her complaint also.
Yes, but that is also recorded.
Yes,
The
yes.
commission says that I will not penalize Apollo since Apollo is not a party.
So we'll see how it was dealt with. Let us come to the response. I mean,
Kindly take, my lord. Then, my lord, my response from
that tallies
Neotia.
with your opposition, that affidavit.
Yes, that is from my opposition.
Right.
But, my lord, now kindly take my response.
Yes.
It starts at Neotia.
Mm-hmm.
Pinky Doctor, so and so.
So you exactly tally with your whatever you have said.
More or less. More or less. Now, my lord, Bellevue.
Yes.
Bellevue gave their response in a letter dated so and so. According to Bellevue, the patient arrived at.
Apollo did not respond.
No, Apollo was not made a party.
Apollo is not subject to this authority.
No. Apollo is subject to authority, but there was no complaint against Apollo.
Achha.
There was complaint against Bharati Neotia and my lord Bellevue.
Yes.
And the commission records that since there is no complaint against Apollo, then we are not going to take any action against Apollo.
All right.
Bellevue gave their response in a letter dated so and so. According to Bellevue, the patient arrived at 12:15 a.m. She was immediately attended by Dr. Shantanu Adhikari. The patient was examined by the doctor in the ambulance itself. So she was in an ambulance. The ambulance was provided by Bharati Neotia. Her condition was critical. She was brought to the emergency department for further management. The patient was clinically unresponsive and all possible measures were taken to resuscitate her. The patient had history of seizure at 10:15 p.m. The complaint also informed the doctors at Bellevue that patient had pre-eclampsia during the said emergency. The patient came at a very late stage in a critical condition, acute critical condition. The Bellevue extended treatment support. All possible care was taken. She was admitted in a gasping condition and in a very feeble pulse with unrecordable blood pressure and also fetal heart. The sound was not audible after checking with Doppler. Dr. Saurabh Kole and Anirban Niyogi, young senior doctors attached to Bellevue, attended the patient. The medical team contacted Dr. Bhaskar Pal, gynecologist attached to Bellevue. The petitioner was intubated. CPR was given. Despite all their best effort, the petitioner died at 1:12 a.m. The relevant treatment records are enclosed with the letter. Then comes the hearing. Kindly take my lord first Apollo. Complainant did not make any complaint against Apollo at page 73. Then comes Neotia. Neotia submitted whatever was there in the affidavit. Then comes Bellevue at page 74. Well, Bellevue shared a pen drive containing the CCTV footage for about 9 minutes. Then my lord kindly take from page 75. We find an ambulance parked at the emergency gate where the doctor and the sister were rushing towards the ambulance and examining the patient. The people found rushing would include paramedical staff who took her in an emergency room. We are, however, candid enough to say that the CCTV footage would not show the timing also and when the ambulance arrived at the premises. We are not fully satisfied. We asked for the CCTV footage from another angle. Bellevue shared the same that would have recording within the emergency triage. Fortunately, the emergency footage would have time recording. We would find active movement of medical. This is all. We will find active movement of medical and paramedical staff within the emergency room. The patient was brought in and was taken to the treatment area. That rightly did not have CCTV footage coverage. We also find that first CD would start at 12:11 when we find a lot of activity by the medical and paramedical staff. Doctors and staff were discussing something and informing someone over phone about the condition of the patient. They would also inform someone over the phone that no critical care bed was vacant at the moment. The people were found rushing around at 12:13. Then code blue was declared and ultimately the patient died. Then kindly, our view. The panel heard the matter Panel heard the matter, did have its esteemed member, Dr. Banerjee, the expert of the subject. Dr. Banerjee gave his opinion as quoted below. This is the story of the death of a pregnant mother who was also a medical doctor. The death was tragic as it was preventable and could have been prevented, should have been prevented. First in the list of deficiencies was that of Dr. Supriya Khetan. The mother, Mrs. Shraddha Bhutra, was under her care from early pregnancy. This was the first emergency. Dr. Khetan did not took her patient, Mrs. Bhutra, I think it's Bhutra, for treatment confinement at any center. In spite of repeated requests by the patient party, at around 5 p.m. in the evening of the fateful day of 24th, patient Bhutra visited her Dr. Khetan for mild chest pain. Dr. Khetan examined her and said nothing is wrong. Then at around 10 p.m., the patient had severe pain in her abdomen and sought help of her Dr. Khetan. Dr. Khetan refused to attend her and asked her to be taken to Apollo. Accordingly, the patient was taken to Apollo at around 10:15 p.m. By then, she was quite ill and was in the state of threatened eclampsia. In fact, she might have already had an attack of seizure, as evident in the clinical note written later at the Bellevue Clinic. Still, Apollo did not attend her or admit her on the excuse that Apollo was a COVID designated hospital. The patient was taken to Bhagirathi Neotia, a super specialty mother and child care center. At the time was past 11 p.m. There in emergency, the doctor and MD in Obgynae attended her. She had telephone talk with Dr. Supriya Khetan, the specialist, under whose treatment the patient was all through her pregnancy. Dr. Khetan's response was that she had asked the patient to be taken to Apollo. She would have done nothing more to do with that patient. The patient was already in acute emergency, but the doctor in emergency at Neotia finished her responsibility by arranging her transport in an ambulance to Bellevue, and that too with no medication, no support, no help. The last stop in the fatal journey was at Bellevue Clinic. It was midnight around 12 a.m. of 25th April. The medical note written there shows diagnosis of preeclampsia with convulsion, seizure at 10:15 p.m. Still, the patient was kept waiting without any medication, any treatment for over half an hour as alleged. The patient was eventually admitted in Bellevue under the threat of exposure. This is very important. Or in social media and a telephone call from local police station, Shakespeare Sharoni. An attempt for resuscitation was done, but it was too little too late. The mother, Shraddha Bhutra, died, and the cause of death was eclampsia. Eclampsia is a pregnancy-induced hypertensive disorder with superimposed seizures and convulsions. It is largely preventable. Also, there is a WHO-designated very effective anti-convulsion tranquilizer therapy in eclampsia. Also, there are other anti-convulsant regimes. Still, a mother had to die of eclampsia in the metropolis of Calcutta with no treatment, no care. In truth, each transfer and transport added to the seriousness and severity of eclampsia. We have considered the medical records as well as the opinion of Dr. Banerjee. We have perused the complaint and the response and the oral submissions made by the parties. Dr. Banerjee, according to Dr. Banerjee, eclampsia is a pregnancy-induced hypertensive disorder with superimposed seizure convulsion. It is largely preventable. Also, there is WHO-designated very effective anti-convulsion tranquilizer therapy in eclampsia. Also, there are anti-convulsant regimes. It is unfortunate the patient, although a medical practitioner, did not get basic treatment at the emergent hour. From the sequence of events, it is clear that the patient was neglected, so and so, everything normal. Then misery started at the chamber of Dr. Khetan that continued when the patient was refused admission at Apollo. It is unfortunate the complaint, the husband of the patient did not make any formal complaint against as Apollo. Even at the time of hearing, he did not make any such request to ask to add Apollo as respondent. Since it would be difficult for us to rope in Apollo, it is most unfortunate Dr. Basu would deny the very fact of patient's visits at C, the clinical establishment. However, in absence of proof, it would be difficult for us to blame Apollo. Pertinent to note that the incident happened on April 24. We gave notice to Apollo on July 8. There was no scope for CCTV footage verification, as probably this footage has not been preserved for so long. We could have ventured for the same had there been a formal complaint by the complainant at the appropriate time. We received the complaint on April 30. We received the response from Neotia, said to be an affidavit without affirmation or identification, that too undated. Subsequently, on or about July 7, 2021, an affidavit duly affirmed by Mrs. Dotto was filed. We received, kindly mark here, this is somewhat little bit preconceived. Why I tell you, Lordship, preconceived? In case of Bellevue, they treat a letter to be an affidavit. In case of Neotia, we file a letter that is not treated as affidavit. We were directed, we file an affidavit. And if they're so serious about the affidavit, then my lord, my affidavit, all the statements which I made in my affidavit would have to be considered. And if there is no rebuttal to those statements, subject to a lordship's kind consideration, I have, my lord, this is a denial of principles of natural justice. We have also received a rejoinder from Abhijit Ghoshal, the advocate of dealing with response with Neotia, but that is not with us. A copy of the notice rejoinder from Abhijit Ghoshal, that is the advocate. Khaitan on such and such, by letter dated May 15, 2021, Obik Kumar Das, learned advocate, replied to the notice issued to Dr. Khaitan. According to the said reply, the patient was having stable, uncomplicated progress during her pregnancy. The delivery was planned sometime around June 12. She advised the patient to choose any hospital for delivery. On April 24, 2021, the patient was examined by her. At her chamber, she was advised standard medication. The patient was stable and there was no complaint with regard to uneasiness when they left the chamber at about 8 p.m. At about 10:30 p.m., the patient family informed Dr. Khaitan suffered a neurological seizure. However, the severe and flagrant pain was so-and-so were never communicated to her. She was an obstetrician, so-and-so. I'm not troubling your lordship with this again, once again. The complainant, Sri Ghoshal, replied to the said letter directly to Khaitan on May 29, 2021. The second C, in our view, would be fully responsible for the unfortunate death. But this is contrary to the expert opinion. If the expert opinion, I read out the expert opinion, your lordship will find the expert points out that it is each and every movement, transport, and denial of admission contributed to this unfortunate incident. However, it is apparent that she was refused treatment by Neotia. That would be apparent from the affidavit itself. Neotia in their affidavit categorically stated that they did inform the condition of the patient to Dr. Khaitan. Dr. Khaitan did not advise them to admit her. As such, they could not admit the patient contrary to her instruction. In our view, there might be agony on the part of the patient family. They might not be in a proper state of mind, particularly looking into the condition of the patient. For that, there might have been some unpleasant incident and Bellevue. However, looking into the medical records and chain of events, it would be difficult for us to ascertain any delay in treatment at Bellevue. The expert says there was delay of treatment at Bellevue. For half an hour, the patient was not treated. But this is why the findings are perverse. And my lord, the direction issued by the commission is again, my lord, contrary to the findings of the expert. And my lord, the expert's findings have not been qualified by the commission. Rather, they rely on the findings and then they come at a conclusion that yes, Bellevue is to be spared. It's all about Neotia. Well, we cannot brush aside the fact that the patient was attended by Dr. Adhikari in the ambulance itself and she was taken to the emergency. The fact was corroborated by the complainant himself at the hearing. We thus exonerate Bellevue. Our esteemed member, Dr. Banerjee, was critical against Bellevue, as well as that would appear from his opinion set out here in below. Under the provision of so-and-so, the commission is not examined to make any comment as to the treatment protocol. The facts would reveal the patient was attended. We have seen from the video what treatment was actually given or not would be within the exclusive domain of the commission. It would be helpful for us if the complaint would approach us again, if he actually approaches the medical council. Then, my lord, the conclusion, then we would then be in a better position to examine the conduct of Bellevue. My lord, then, my lord, they should have awaited the decision of the medical council. Because if somebody is really responsible, if at all, well, I'm not here to judge anybody. But my lord, the first responsibility was with the doctor. The doctor had to be, my lord, they had taken an action against the doctor,
Said your learned friend said that the doctor against the doctor
Yes.
it's pending.
Then Malad, these decision should have they should have kept this decision pending. They say that so far as Bellevue is concerned, I will only take a decision if they come up with a fresh complaint after any decision being taken by the medical council.
But that is irrespective of the medical council decision. Dr. Khaitan, whatever his her role, they are only considering your role in there. What you could have done.
Absolutely, Malad,
They
absolutely.
cannot go beyond that.
Absolutely.
Suppose Dr. Khaitan was wrong. She was negligent.
Well, I
If
will-
that does not pertain to you, then
Yes.
you are absolved.
Yes,
I mean,
Malad. Kindly take Malad page 80 and 84. 85, I'm sorry.
Yes.
Malad, it is not about, Malad, we are not here to question the treatment protocol administered by by a clinical establishment, because that is within the exclusive domain of the experts. What we are here is that whether there was actually any negligence. Malad, I will take your lordship to page 80 for once. Kindly take page 80, the second last paragraph at page 80.
Yes.
The last stop in the fatal journey was at the Bellevue clinic. It was midnight around 12 a.m. of 25th April. The medical note written there shows diagnosis of preeclampsia with convulsion seizure at 10:15 p.m. Still, the patient was kept waiting without any medication, any treatment. It's not about a treatment protocol, my lord. She was kept waiting without any treatment.
And under threat he was.
And under threat of the social media, they were constrained to admit her and render the possible treatment. Over half an hour. And what the commission says, that we are not here to judge the treatment protocol. It's not the question about protocol. It's not the question of what medicines you administered. It's not the question of why did you administer CPR at that stage. It's the question whether you at all treated the patient for the first half an hour. But at least within our limited sources, we made an attempt to treat the patient on emergency basis, but we took instruction from the doctor. Your lordship will find from the records itself that the doctor made these observations over the phone. My respectful submission before your lordship is that, finally what they have done is that the page 87, Dr. Khaitan is beyond our reach. The patient's family is free to take appropriate steps against Dr. Khaitan if they so like. The young medical practitioner died without treatment at prime age as a consequence of a child who was being nourished by her in her womb. It is not only unfortunate but also a matter of great shame. No amount of harsh word would be apt to blame the CE. We feel it is a fit and proper case where we should send the complaint for consideration by WBMC. So far, the treatment protocol undertaken is concerned. In the case the WBMC would take cognizance of the complaint, they would not only examine the conduct of Dr. Khaitan and medical examine negligence, if any on our part, but also examine the treatment protocol of eclampsia at Bellevue. The complaint would be free to approach us again if the occasion so arises in future after disposal of West Bengal Medical Council procedure. We award a compensation of rupees 20 lakhs against Bhagirathi Neutia. In case the complaint or patient family would decline to accept the amount, the CE would be obliged to deposit it with the Missionary of Charity for their orphanage, and they would maintain that they would maintain in the memory of Dr. Shraddha Putra. My respectful submission would be that if you rely on an expert, if the expert has recorded his findings, and the expert has recorded that actually delay was caused at Bellevue, our hospital, that is the petitioner with your lordship, could not have been blamed. The findings are perverse. The directions are also contrary to the findings of fact. But these are my respectful submissions, your lordship.
I'll hear you after 10 minutes. I'll come back and hear.
Lordship, my learned senior friend, what submission made, that is totally different, my lord, to the present matter. My lord, the issue involved in the writ petition, I category 2 or 3 point. There is point which has been made to the writ petition, that is, there is no booking prior to treatment. Any patient come to the hospital, he has to make prior booking unless
No,
he
they
or
have
she
also said, they have also said that that is not mandatory. They have admitted that in there. Yes.
Another point is that multi-specialist hospital, they are not recognized as a multi-specialist hospital. That is the point. And basic treatment which has been given to the patient, that is totally, there is no treatment at all, just to take blood pressure, nothing else beyond that. That is the vital point in this issue, my lord. Another point, my lord, whether patient Butra under within the meaning of the act and rule of the commission, my lord, her treatment whether has been established by the act, as my learned friend said, act is provide and commission has been established to adjudicate the complaint against the clinical establishment only the thing. That is the point. My lord, that point has been taken in the writ petition also. And my lord, my learned friend saying some special disease, that is eclampsia, that has not been uttered in the writ petition also. There is no point at all. At the time of, at the moment of submission, that has come out. That is the point. My lord, I am submitting, my lord, some Supreme Court judgment where, my lord, Supreme Court said that obligation on the state to preserve the life. Every doctor has professional obligation to extend service to protect life. All government hospital, medical institute to provide immediate medical aid to all cases. That has been escaped. That is, my lord, Parmanando Katra versus Union of India. That is August 1989. That judgment.
It's not a reported judgment.
Lordship, I don't have in my hand judgment.
That means you did not do the research work. That's why.
Lordship,
you should be prepared on these judgments. And what is the citation?
That is the
give me the name.
vital
Give me the name and the date.
Lordship, I am Parmananda Katara.
Parmananda. P-A-R-M-A.
P-A-R-M-A-N-A-N-D.
Yes.
K-A-T-A-R-A versus Union of India. Date of judgment 28 August 1989. Milord,
yes,
I am whatever it is, Milord. I am, Milord, before your lordship to say something that basic treatment has been escaped. That is the thing. That should not be.
Yes.
Milord, kindly text Milord para number 13, Milord. What is the important in the case, Milord? That will one minute. That it will not page number. Page number 42, Milord, in my complaint. Page number 42.
Please give me half a second.
Lordship.
Permanent cutter is reported to Lordship. 1989, just give me. এই অরিত্র ওকে ডাক আমাদের ওয়াইফাইটা কাজ করছে না এটা দেওয়া আছে হ্যাং করে যাচ্ছে কেন 90 please take down the citation 1995 3 SCC 248 No, that was a different judgment. Name is same. It's on a different issue. Anyway, what is there? Please read out your.
Lordship, kindly text me note page number 40.
Did not give the page number. Please read out the paragraph.
Paragraph, my lord, it is my complaint where I made submission in my complaint that despite several requests and enormous effort by the petitioner and his family member, the above hospital authority abandoned all requests and.
Have you got an extra copy of that? Have you got an extra copy of the judgment?
Lordship.
You have not got. So
Lordship,
it's unreported. You don't have a copy of it,
Lordship.
and you're citing it.
If possible, my lord.
What other judgment? Any other judgment you're citing?
Lordship, I have, but my lord, I have to produce before the Lordship. If Lordship.
Give me the
kindly
names
give
and
me-
the dates. I'll find out.
Lordship. Lordship, right now I have one judgment, that is Katra, that is.
Acha, read out that paragraph, please.
Lordship, I am.
Read out the paragraph.
Lordship, that is my complaint in the read petition. Kindly text page number 40.
No, first read out Paramanand Katara, the relevant paragraph. What is the ratio laid down there?
Lordship, obligation on the state to preserve the life. Every doctor has professional obligation to extend service to protect life. All government hospital and medical institute to provide immediate medical aid in all cases.
Very good. Yes.
That is the point, my lord.
Yes. Show me your complaint. Which page?
Lordship, page number 42. My lord.
42. Yes.
My lord, I categorically say that despite several requests and enormous effort by the petitioner and his family member, the above hospital authority abandoned all requests and without giving any medication spent 45 minutes. That is the vital point. 45 minutes has been gone away without any treatment. My respectful submission before Lordship that why it is the basic my lord, right to get access some medical treatment from the clinical studies, and that is my point, my lord.
Right.
And my lord, since 11 PM to 11:45 PM, there is no treatment at all.
What else? Yes, I've seen this.
Lordship, thing is that, my lord, in another judgment, my lord, Lordship rightfully established the section, my lord, where that is the section 38(1)(3) and 9, my lord. This is the Lordship judgment where Commission has every right.
Give a copy to him. He's
Lordship.
exactly a copy.
Commission has every right
Yes.
to pass an order with a compensation. That is already has been established by Lordship direction.
No, that is not disputed by them.
That is the pleading in the writ petition. That's why that already has been escaped by my learned friend. Learned friend emphasis only the word, the particular disease dyslexia that is not included in the writ petition. That is my respectful submission, my lord. My lord, now all on a sudden matter has been called and my lord, submission is going on. That should be taken into the writ petition. The point of the writ petition, my lord, is totally different. That is prior to booking. There is no multiple specialist hospital. The basic treatment has been given. That has been escaped away, not given. Only blood pressure taken away. My lord, whether Butra is the patient under the meaning of this act. The patient, my lord, establishment.
No,
my lord,
definitely she's a patient. They are not denying that. They are
that
not
is
denying
the
that.
abandonment in the writ petition. That's why.
Oh, that forget that.
My lord,
So this is your case.
Lordship, my lord,
Yes. Anything else?
there is, if my lord permit me, then my lord, kindly I give the judgment if you
Which
allow
judgment?
me. That judgment, Carter judgment, I have the copy. If my lord allow me, I can give you.
Hand over when you can. Yes.
Lordship,
Very good.
Lordship. My lord,
Yes.
after my lord, all these things, my lord, several time I wrote the letter to the Khaitan. Khaitan complaint has been pending in the medical council. My lord, I am so surprised that they are not interesting to take up the matter. They are doing the matter once in a year. My lord, incident happened in the year 2021. Today is 2023. My lord, one or two, my lord, that kind of lackadaisious attitude, my lord.
You should have challenged that also. in a
Lordship,
proper-
Lordship, I have to, my
should
lord.
have.
There is a pathetic thing, my lord. Kindly consider. I will
If
provide
you
the
prefer a
judgment.
proper writ petition or whatever challenge, if there is any forum, then there could be a report sought from that.
Lordship, Lordship,
Well,
Lordship.
I'll close arguments on this. Hearing is concluded. Judgment is reserved. Thank you. Next. Please give your appearance. Yes. Orichuta kota.
Item 5.
Matter জমে গেছে। দাও। Yes. Yes, Mr. Chakraborty is on.
But on last occasion, this was taken up by your lordship that can one, my lord.
Pardon?
This- Pardon?
Can't hear you.
Can one was taken up on last occasion, my lord. On that day, my lord, lordship directed to intimate Mr. K.D. Poddar.
Mr. Poddar is there.
Yes, my lord.
In his. Yes. What is the matter in the writ
The
petition?
short matter, my lord, the father of the petitioner, my lord, he expired, my lord. The father, he was having a savings bank account in UCO Bank, Shampur branch, my lord.
Right.
My lord, intimating that account number, my lord, the petitioner made an application before the bank authority to inform that how many money is lying with that account, my lord, and whether there is any nominee in respect of that account, and whether any locker in the name of the deceased father of the petitioner, my lord.
You are the son.
I'm the one of the sons.
You want to operate or you want only the information?
Only information. Only.
You are for the bank, Mr. Poddar.
Yes, ma'am.
Give the information.
My lord, what happened, my lord? The matter came up for hearing before the Honorable Justice M. Bhattacharya. Her lordship, my lord, directed the petitioner come up with all the legal aids. My lord, he is claiming, my lord, one of the sons.
All the legal layers individually also are entitled to know. After that, whatever steps they take, that's a different thing. She is not claiming for disbursal of that amount or operation. I won't give her that permission. You're right. For that, all the legal aids are required.
Yes,
you are absolutely right.
my lord,
But just disclose the information. She has a right. She can prefer an appropriate,
My lord,
maybe succession certificate
kindly see,
application.
my lord, page 12, my lord.
Yes.
My lord, from this annexure,
Yes.
this is the one page Xerox copy of the one page of the passbook of the deceased holder. My lord, from this, my lord, it is appearing, my lord, the balance is, my lord, 27,000 and odd. 27,000 and odd. My lord, if all the legal heirs, my lord, approach the bank with all complying all formalities, it can be disbursed, my lord, by execution of a.
Not asking for disbursal, wanting for a
My lord,
information.
My lord, my lord, if he holds the passbook, my lord, it is easy to get the, my lord, account updated. No problem. My lord, thing is this, my lord. Second query is, my lord, who is the nominee? Whether there is any locker stands in the name of the deceased account holder. This is the all personal in nature, my lord. This can't be, my lord, shared, my lord, unless, my lord.
What is your
direction
proof of
from the
your
civil code.
heirship? What proof have you given
There is
regarding your
nothing.
heirship?
Well, here I have not
Something annexed
annexed,
to the writ petition?
well, in this writ petition, I have not annexed any document.
What document do you have?
Well, in
Anybody and
that case,
everybody
I have
is right, Mr. Poddar is right.
Well, in that case, I have to ask the petitioner.
I'll dispose of the writ petition, prove your
I
heirship
have
before them.
already, can one, my lord,
Is
I
there
have
amount,
already
my lord?
made party the other legal heirs, the other sons and daughters, I have made party
Can is
there.
for what? Addition of party?
Yes, my lord.
This will not help, my lord.
Pursuant to the,
Where you will allow this addition of party, I'll direct you to serve on them. For this matter, this is unnecessary.
Yes, my lord, the amount is very, my lord.
my lord, nothing, my lord, my prayer is only to
Sawai
give
mile
that
approach for-
information, nothing more, nothing else, my lord. Because these
This information
my
can't
lord,
be
I
shared.
will
That
not
is
be able
So
to.
choose your relief. If you want only information, I'll dispose of the writ petition. I'll direct you to produce your heirship certificate
My
for the
lord,
bank. They'll just see.
My lord, dispose it off, my lord.
But then this would allow you have some fear regarding the other legal heirs.
No, my lord, no fear, nothing, my lord. Nothing is there, my
If
lord.
they are implicated, then probably a greater relief can be given to you.
Amount is, my lord, 27,000.
Where was the direction by Justice Bhattacharya? Which date?
We ordered the application and
But on the very first day, it was.
Yes, madam.
ordered there was-
and dates application.
Oh, there was a specific direction.
Yes,
Mr.
yes,
Chakur. Recorded direction. Then I have
My
to.
lord, in the can, my lord.
No,
can
no,
one
I'll
of-
act
my lord,
order.
in Can, my
Can
lord,
1 of 2022 is taken up for hearing. First up, it is seen from the order dated August 29, 2022 that a coordinate bench had directed the other legal heirs of the deceased Sheikh Abdul Jalil, comma, of whom the petitioner claims to be a son, comma, to be implemented. Full stop, next para. The present application has been made for such implement. Full stop. Accordingly, can 1 of 2022 is allowed, thereby implementing the proposed added parties as named therein as party respondents to the present writ petition. Full stop. The necessary consequential corrections are to be carried out by the learned advocate and record for the petitioner during the course of the day in the cause title of the writ petition, comma, liberty for which is hereby granted. Full stop. The petitioner shall serve copies of the writ petition on the added respondents, indicating that the matter shall be listed on September 19, 2023 under the same heading when the petitioner shall file an affidavit of service. Full stop, next para. Learned counsel appearing for the petitioner is also permitted to amend the prayer portion of the writ petition, thereby incorporating the prayer for operating the bank accounts of the deceased.
But in can 1, my lord, page 6, I have annexed a certificate issued by the Gram
We'll
Panchayat.
take that into consideration.
My- And my lord, also liberty
Please
to
carry out the necessary correction in the cause title in the prayer portion also. I'll direct you to if the other heirs are agreeable.
cause title of the can also, my lord.
No, can is disposed of, not necessary. Can should not be. Why the cause title? Can is for implement of those people.
Only the
Allowed. Implement them. You incorporate your prayer for operating the bank account also. I'll direct lock, stock, barrel. Yes. Next.
I'm deeply
Item,
obliged.
item 6.
6.
The last occasion, my lord, 9th.
Yeah, for the LIC.
My lord.
Right.
My lord, I kindly see the order, my lord, 9/8/2023. My lord directed me to, my lord, withdraw the case, my lord. I have made an application the next day, my lord, by put a petition, my lord. But my lord.
We adjourn this.
Yes, my lord.
On the prayer of the
Just
petitioner.
one thing, my lord, I would like to point out, my lord. Here,
Yes.
my lord, the son of the deceased, as per our official record, my lord, son of the deceased is the nominee, my lord, who is not a party to this present writ petition, my lord. Who was, I'm sure it was the notice, necessary notice was served.
Who is he?
My lord, he is the brother of the deceased, who is claiming the.
No, my lord, my elder brother has executed a will that was, my lord, probated. Thereafter, my lord, I came.
No, your right lies against the nominee. The nominee is the receiving hands. But no.
My lord, I am my elder brother.
Nominee has to get the money. Your right lies in a civil suit against the nominee for recovery of that money. If you have a right.
It's not a case of nominee, my lord. Whatever, my lord, my elder brother has.
LIC, there is no case of nominee. Every LIC policy has a nominee.
My father is a LIC, my lord, employee, my lord.
Employee, my lord.
Oh,
The
no, nominee in his service account also same.
Service benefit, my lord. He has executed a will giving all, my lord, immovable, movable property, including the service benefit. My lord, I have.
But implement the son also.
My lord,
My lord, kindly see, my lord, kindly see the.
Let me see
I I have, I have executed, I have, a will was executed, thereafter, what happened, kindly see the order, first.
So there is a probate order, my lord. He
Yes.
applied for a probate on the basis of a registered will
Yes.
executed in his favor, in his client's favor, my lord. So now, my lord, the point is, my lord, since in our official record, the son is the nominee, my lord. Therefore, my lord, my understanding, my lord, my
In any
prayer
event,
would
you are
be
asking
they
for
should-
time, implead the son also.
They should be before the court, my lord. That is my.
Learned counsel for the petitioner submits that pursuant to the order recorded on August 9, 2023, the petitioner has already applied for having the petitioner's suit filed on similar cause of action, dismissed.
That was not the similar cause of action, my lord.
That was for what?
My lord, when I filed a,
For
probate
disbursal of the amount.
No, my lord. That suit is, my lord, that I filed a probate application, and at that time, my lord, I filed a suit that that no one can be, my lord, taking that amount, my lord. That's why I filed a suit, my lord. That suit, their injunction was granted. That suit was.
Where is the plaintiff of that suit? Give me a copy.
That I have not annexed, my lord.
Have you got a copy?
No, that is not.
Have you referred to the prayer of the plaintiff in the suit, in the writ petition?
No, my lord, that was not also there.
Learned counsel for the petitioner asks for how much time?
My lord, 1 month.
1 week's time. Full stop. Let the matter.
4 weeks time. 4 weeks.
Learned counsel for the petitioner seeks for an adjournment of 4 weeks. Full stop. Let the matter be listed on September 12, 2023. In due course. It will be under the normal heading now.
Well,
Yes.
let the son be impleaded, my lord, subject to my lord's.
He is willing to at order record. Learned counsel for the petitioner. Learned counsel for the LIC submits that the son of the deceased account holder of the deceased employee of the LICI is also a necessary party to the writ petition. Full stop. Leave is granted to the petitioner to implead the son and serve a copy of the writ petition, indicating the next returnable date. Full stop. It will be open to the writ petitioner to proceed with the writ petition without impleadment of the son, in which case, such a non-impleadment will be at the own risk and peril of the writ petitioner.
Problem is that, my lord, we don't know the address. It's the problem.
Next matter, please. Yes.
Item 7.
Get.
Lord, I beg to appear on behalf of the state respondents, my lord. And on the last occasion, your lordship's pleasure was that, my lord, I should file a report of compliance.
Yes. You have complied?
Required compliance, my lord.
Yes.
And my lord, if your lordship kindly takes, my lord,
Right.
If your lordship kindly takes, my lord, paragraph, my lord, page, internal page, my lord, 5. Internal page 6, my lord, paragraph number 4.
Right.
In pursuance to your lordship's order, my lord, the requirement of law, my lord, for the purpose of appointment of an MMR, my lord, local residential proof is necessary. My lord, in support of his claim, he only, my lord, submitted, my lord, one unregistered tenancy document. My lord, that cannot be considered, my lord, as law envisages that prevalence of local men of respectable character and suitable attainment. So that's why, my lord, we have asked, given him, my lord, some more time, 15 days time, for submission of either voter card, Aadhaar card, or my lord, residential certificate. So, my lord, he has been allowed 15 days time.
My lord, kindly consider, my lord.
Please take the microphone, Mr. Mukherjee. You can't produce any voter card, Aadhaar card.
Yes, my lord. On their instruction, I have deposited all those things, my lord. All these things, my lord.
I do not within that.
They have received. Kindly see, they have received.
Please consider this and decide.
Lordship.
Learned counsel for the state files a report as per previous direction of court. Full stop. It is reflected in the same that, in deference to the said order of the court, the petitioner was given a hearing. Full stop. As per Rule 4 within bracket small a of the rules made under the Bengal Act 1 of 1876, documentary evidence is required in support of the claim of an applicant for the post of MMR regarding local residency of the said applicant. Full stop. In such regard, the petitioner only produced an unregistered tenancy agreement, which was not sufficient in the I of the respondents, comma, for which 15 days time was given to the petitioner to produce relevant documents in that regard. Full stop. Next para. The report be kept on record. Full stop. A copy thereof is also served on the learned advocate for the petitioner here and now. Full stop. Learned counsel for the petitioner submits that the petitioner is in possession of all relevant documents, including his Aadhaar card, to establish local residency and produce the same before the authorities. Full stop. Be that as it may, comma, WPA 3923 of 2023 is disposed of by directing the petitioner to produce the documents pertaining to the local residency of the petitioner in the concerned area within a week from date. Full stop. Upon such documents being produced and copies thereof being handed over, comma, the respondent authorities shall ensure that the petitioner is appointed as an MMR in the locality concerned. Full stop. Such entire exercise, comma, it is expected, comma, shall be concluded within a month from date. No orders to cause urgency.
Milord, I have already handed over, Milord, a copy of the comprehensive to my landed.
Recorded.
Lordship, grateful. My lord, this is the receipt of 17th August they have received, my lord.
Give again, take another receipt and just within a month, they'll have to give you that appointment. Thank you. Next.
Item 8.
Yes.
I'm appearing on behalf of the petitioner.
What is the case?
Lord, I appear on behalf of WPACTCL. On the last occasion, my lord, there was a
private respondent.
there was a direction passed by your lordship to my lord inspect, give a report, and also if ascertaining that we can give connection to give a offer letter. My lord, we have inspected, my lord. What is the report, my lord? I've already handed over the report, my lord.
My lord, may I indicate the previous?
No, wait. Let me see the report. What is the crux of the report?
My lord, this is a dispute between father and son, my lord. The property admittedly is being owned by the father.
You are the father.
The
His son, very
the
well.
son, my lord, according to my lord, their statement at paragraph 4, they were enjoying the supply from the meter in the name of the father. The father has disconnected the supply upon giving consent. May I kindly come to the report. Why it is difficult for us now to give the offer letter, which my lord has directed on the last occasion. May I kindly see paragraph 4. There are 7 meters, out of which all are disconnected. And the first 3 is being deemed temporarily disconnected. First 2, may I kindly see, is being temporarily disconnected, and the subsequently are being deemed disconnected. Out of the 7 meters, 6 are single phase meter and 1 is a 3-phase disconnected meter. In respect of the meter in the name of the father, which has been temporarily disconnected on 2023, according to them only, they were using that meter. If we now, my lord, give a new meter in respect of that particular portion, it will amount to clause 14, my lord, splitting of load, because that meter is already there, 180 days has not gone. And this is for temporary disconnection on the prayer of the consumer itself. Now, my lord, secondly, when we have inspected, no separate establishment could be provided. Obviously, my lord, since he is using the space of the father and the father has been thrown out, then, my lord, we cannot provide that meter, my lord, in respect of that particular portion, my lord. Here we are lying the, my lord, difficulty. Subsequently, the other part.
What is the provision under which you temporarily disconnect, Mr. Mukherjee?
My lord, it has been temporarily disconnected, my lord.
Which provision?
My lord, there
is a procedure.
There is a procedure, my lord, upon.
This becomes permanent when? How long?
My lord, after 180 days, my lord, if there is no dues, my lord.
How much time has elapsed after this disconnection? 12th of June.
They kindly see the first meter date of disconnection is 4/5/2023.
He is wanting where? From 1, not 7?
From 1, according to paragraph 4, which I have gathered.
7 is also there. So 1 is
the name of
earlier.
the father.
Yes.
These are all the tenants subsequently, and 7 is the 3-phase meter.
So if that was on 4th of May, June, July, August.
Yes.
So 180 days have elapsed. That has
what-
attained finally.
Yes, this
So it's a new connection. Now give him a connection.
if your lordship so decide.
No, not my desire. As per your argument, Mr. Mukherjee, you argued that after 180 days, temporary becomes permanent. Regarding the first meter, 4th of May 2023 was the disconnection date.
Yes.
If that was so, 180 days by calendar has elapsed, not by my wish.
We'll direct that, we will remove this meter and we'll give.
What do you say to that?
I am the absolute owner of the land, my lord. I am thrown out from the house estate by my.
Have you filed
my
a civil
son.
suit for that? Or any other act?
No, I have not filed my.
You are a
lord.
senior citizen.
A
Your
senior
client is a senior
I am
citizen.
74 years
If
old.
you are senior citizen, you should have taken advantage of the act, proper act, or filed a civil suit. Do that. Why didn't you do it till now? When were you dispossessed?
The family dispute, my lord. Is
When were you dispossessed? At which date? On which date?
I am the
So long back you have forgotten.
2 years, my lord.
2 years you have done nothing. The only thing you do is disconnect your son's electricity.
Residing at the tenanted room, my lord.
So you must have not been aggrieved with that. For 2 years, if you did not do anything, you cannot just go on disconnecting electricity like this. Anyway, I'll pass my orders. Learned counsel for the WBA-CDCL files a report as per previous direction. It is submitted by learned counsel for the WBA-CDCL, on the strength of such report, that there are several temporarily disconnected electricity supply lines in the premises in question, by placing specific reliance on serial number 1 in a chart given at paragraph 4 of the said report, it is submitted that meter number 525716 standing in the name of the pro forma respondent of the private respondent, who is the father of the petitioner and the absolute owner of the property, stood disconnected on May 4, 2023. It is submitted that since the petitioner seeks an electricity supply at the same locale, in view of the existence of the previous meter, such connection could not be given. Next para, learned counsel for the private respondent submits that he, despite being the absolute owner of the premise, was forcibly evicted by the petitioner about 2 years back. Next para, heard learned counsel for the parties. The petitioner's grievance is that the petitioner has not been given a new electricity connection by the WBA-CDCL despite having applied for the same. Next para, even as per the submission of learned counsel for the WBA-CDCL, the law prescribes that a disconnection, after the lapse of 180 days thereafter, becomes permanent, and it is deemed that the contract between the consumer and the licensee stands terminated. Applying the same proposition in the present case, the temporary disconnection effected at the behest of the private respondent on May 4, 2023 has, by now, reached the terminus of 180 days, and as such, the previous contract between the petitioner and between the licensee and the private respondent has expired. In such view of the matter, there cannot be any impediment in the petitioner getting a new electricity connection at the same premises, since the petitioner is admittedly in occupation of the property, although the legality of such possession is disputed by the private respondent. Next para, the remedy of the private respondent lies before in an eviction suit filed before an appropriate forum court. On query of court, it is submitted by the private respondent that no steps have been taken for eviction of the petitioner or restoration of possession of the private respondent till date. Hence, the private respondent, in an oblique manner, cannot curtail the right of the petitioner conferred under Section 43 of the Electricity Act 2003. Accordingly, WPA 18141 of 2023 is allowed, thereby directing the WBA-CDCL to give a new electricity connection to the petitioner at the premises in question within a fortnight from date or from compliance of formalities by the within a fortnight from compliance of all formalities by the petitioner. The WBA-CDCL shall, within 48 hours, give an offer to the petitioner, indicating the estimates to be paid by the petitioner. Upon such offer being raised, the petitioner shall comply with the formalities at the earliest thereafter, and the connection shall be given to the petitioner within the time frame as indicated above. No orders to cause urgency.
We shall remove the meter, let that be there.
No, that is always there.
Until and unless there is specific, because there is already an objection from him, written objection, which
Mr. Mukherjee, if the contract between you have terminated after the expiry of 180 days, you cannot say that you record the leave of court to remove the meter. You cannot say that.
My lord, may I seek one illness? There can be some hazard at the time of.
Achha, very well. In the event any obstruction is raised by the private respondent, he is not residing there.
No, my lord. There can be some dispute.
Achha, very well. In the event there is any obstruction raised from any quarter to the WBSCDCL giving such connection, it will be open to the WBSCDCL to approach the nearest police station, upon which police assistance shall be given to the WBSCDCL at the cost of the petitioner by acting on a server copy of this order. Thank you.
I'm grateful.
Item 9.
Yes, Mr. Gupta.
Please, Your Lordship.
Yes.
This is my.
Lord, I appeal for the respondent. Before my learned friend starts, my lord, may I take the point of maintainability of the writ
Yes,
petition?
Mr. Gupta, this is disproportionate asset for you.
It's disproportionate punishment. That's why, my lord, we had to.
That is for the court. Yes, Ms. Rao, what is your maintainability?
My lord, maintainability of the writ petition before this honorable court.
Why not maintainable? Yes. Apart from the size, obviously. Yes.
No, no, sir.
But Your Lordship needs to be troubled only with the first volume, possibly, as of now.
My lord,
I'm elated.
my lord, the company having its registered office in Odisha.
Right.
My lord went under corporate insolvency resolution process
Yes.
for the National Company Law Tribunal, Cuttack bench.
Yes.
My lord, the petitioner before my lord was appointed the resolution professional. He carries out the functions of a resolution professional, invites resolution plans, makes publication, participation from Odisha. His function he carries out probably here because it was virtual mode. But my lord, everything relating to Odisha, resolution plans submitted, my lord, considered by the Committee of Creditors, resolution plan allowed. In the meantime, my lord, the resolution professional comes to know that there was a writ petition pending before the Honorable High Court at Odisha in respect of the property of the corporate debtor. He participates in that. In fact, there was an order of sale by the Honorable High Court at Odisha. He participates in that, says that there is a moratorium, CIRP admitted, kindly do not proceed to sell the property because there is a moratorium now. Initially, Odisha High Court refuses the prayer. He goes up before the Honorable Supreme Court. Supreme Court passes certain orders, comes back to Odisha High Court. Odisha High Court thereafter stays their hand. He proceeds with the resolution plan admitted. Before the admission of the resolution plan, there were two objectors to that. One is another company and the second were workers. They make certain applications. My lord, I'm not going into what those applications were. Those applications were considered by the.
What is the present cause of action?
Present cause of action is his license to act as a resolution professional has been cancelled, terminated by IBPI, insolvency resolution.
How is he invoking the jurisdiction of this court?
That
Because
is
it
what-
was communicated here.
Yes, because it was communicated here. My lord will kindly take page number 96, paragraph number 42. That
Mr.
is
Gupta,
the
since
only
I'm hearing
page-
the maintainability point first, I'm hearing her first. Then you'll reply to this. If I am satisfied, then only I'll proceed. Yes.
page number 42, paragraph number 96. Order dated 13 July 2023 has not been received but was uploaded. That apart, all notices, show cause letters and like leading to passing of the order dated 13 July 23 have also been received by the petitioner at the registered address within the jurisdiction of this honorable court. Petitioner carries on business as an insolvency professional from his address. Affectation of the rights of the petitioner has taken place at this address and therefore it is apparent that the substantial and material cause of action has arisen within the jurisdiction of this honorable court, and this honorable court also has the jurisdiction under Article 226(2) of the Constitution of India to try, entertain, and determine the instant writ petition inasmuch as the substantial and relevant part of cause of action has arisen within the jurisdiction of this honorable court. All communications of the petitioner have also been received from his office within the jurisdiction.
Why was he removed?
My lord, after his reply to the show cause notice, in fact, the appellate tribunal also held that he did not perform his duties as a resolution professional to the duties which are encoded in the code was not performed by him. He
So
did
apart
not,
from paragraph 96, everything is in Odisha.
everything is in Odisha. Only thing is, my lord, even when he was acting as as a resolution professional, he can also be appointed as a resolution professional for a company in Bombay. No bar there. But my lord, just because I received the notices here, in fact, you had received probably all your emails right here in the office sitting in Kolkata. But that does not make it, my lord, take it out from the jurisdiction of NCLT Cuttack and bring it to NCLT Kolkata. Though, my lord, the judge was also the same then because it was virtual mode and he was presiding there.
Obvious, yes.
But that is how it is. Now, my lord, before I take my lord to all that, my lord will kindly take once page 51.
No, why not New Delhi?
I have no objection if it's New Delhi, because IBBI is there. The order was passed there. NCLAT's observation was there.
His alleged non-performance or bad performance was in Orissa.
Orissa, IBBI.
But he comes up against his termination as a resolution professional.
That was passed by the IBBI, which is in New Delhi. My lord will see the cost.
Yes, I'm seeing the cost title only.
Yes, okay. So, my lord,
So that has to be New Delhi, yes.
It is New Delhi.
I don't think has
Well, my lord, if it is New Delhi or because part of cause of action, my lord, his acting as a resolution professional was also in Orissa. So, my lord, whether it is Orissa or New Delhi, I don't say anything.
Then why not 226-2?
Why I will say, my lord. My lord,
There are certain judgments both ways, yes.
My lord, I'm carrying a few judgments.
Both ways there are judgments, yes.
My lord, first take page number 51. 51 is, my lord, the order. Order, my lord, admitting the company into CIRP. Orissa. My lord will kindly take.
Yes.
My lord has found that. Then, my lord, page number 52, P4. My lord, this, my lord, is an email sent by IBBI to the petitioner. My lord will kindly see what it says. Reference to the complaint received in the caption matter. You are advised to give paragraphs comments. My lord, this is, my lord, he receives this probably in his office, but my lord, it does not specify the addresses here. Then, my lord, his reply, which is P5, page 59. Again, my lord, an email. Received from where, my lord? I might receive it here right now in court, my lord. That does not, I mean, like if this was somewhere outside. Then, my lord, page 99 is again an email by IBBI. His reply, continuation to page 99, all emails, everything email, my lord, nothing sent by post. Page 102 is again an email by IBBI, my lord, reply there too. Show cause, my lord, which is at page 225, probably volume 2. Volume 2?
No, 1.
Volume 1.
225, volume 1.
Volume 1. My lord, show cause, my lord, the email is at P13, page 225.
Yes.
Again, it's an email. My lord, initially, my lord, there was a mistake by IBBI. My lord, they had sent a notice on 29th of March, fixing the date of hearing on 6th of March. He replies to that and he says, your notice is dated 29th of March. So, my lord, we give him another fresh hearing date again in April. That is also email, page number 243. Impugned order, my lord, is 261. So, my lord, apart from this at page 96, my lord, there is no other pleading that any part of the cause of action arose within the jurisdiction of this honorable court. My lord, now 226-2.
Yes, I have. Yes.
My lord, power conferred by clause 1 to issue directions, orders or writs to any government, authority or person may also be exercised by any high court exercising jurisdiction in relation to the territories within which the cause of action, wholly or in part, arises for the exercise of such power, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories.
The part cause of action is a test.
Yes. Now, my lord, will kindly allow me to place the judgments which I would rely on, because I have shown, my lord, everything was email, nothing was addressed to him at this address. His mails have also been sent from his email, nothing posted. At least I have not been able to find any post.
Right.
My lord, the first one that I would place, my lord, I'm sure my lord would also appreciate, Kushum Ingot. My lord, since, my lord, this is one of the most judgments that we regularly place for this, I'm not placing the judgment. I'm straight taking, my lord, 2 paragraphs which I would rely on, 25, 27, 30.
Right.
My lord will kindly take page, paragraph 25, 262 internal page.
Yes, yes.
Said decision is an authority for the proposition that the place from where an appellate authority or revisional order is passed may give rise to a part of cause of action, although the original order was at a place outside the said area. When a part of cause of action arises within one or the other, High Court, it will be the petitioner to choose his forum. Then, my lord, 27. When an order, however, is passed by a court or tribunal or an executive authority whether under provisions of statute or otherwise, a part of cause of action arises at that place. Even in a given case, when the original authority is constituted at one place and appellate authority is constituted at another place, writ petition would be maintainable at both the places. In other words, as order of the appellate authority constitutes a part of the cause of action, writ petition would be maintainable in High Court within whose jurisdiction it is situated, having full regard to the fact that the order of appellate authority is also required to be set aside, and as the order of original authority merges with that of the appellate authority. Then, my lord, 30. We must, however, remind ourselves that even if a small part of cause of action arises within the territorial jurisdiction of the High Court, the same by itself may not be considered as a determinative factor compelling the High Court to decide the matter on merit. In appropriate cases, court may refuse to exercise its discretion jurisdiction by invoking the doctrine of forum convenience. Here, my lord, I say not even a small part of the cause of action has arisen here. This is the first. Second, my lord, the ONGC versus Utpal Kumar Basu. Dada.
Judgment side করবে এখন একটু খেয়াল
5, 6, and 8. My lord, internal page 716.
Yes, please.
Clause 1 of Article 226 begins with a non-obstante clause, notwithstanding anything in Article 32, and provides that every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within whose territories directions, orders, or writs for the enforcement of any of the rights conferred by Part 3 or for any other purpose. Under Clause 2 of Article 226, High Court may exercise its power conferred by Clause 1 if the cause of action wholly or in part had arisen within the territory over which it exercises jurisdiction, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. On a plain reading of the aforesaid two clauses, it becomes clear that a High Court can exercise the power to issue directions, orders, writs for the enforcement of any of the fundamental rights conferred by Part 3 of the Constitution or for any other purpose if the cause of action wholly or in part had arisen within the territories in relation to which it exercises jurisdiction, notwithstanding that the seat of government or authority or residence of the person against whom direction, order, or writ is passed is not within those territories. In order to confer jurisdiction on the High Court of Calcutta, NICO must show that at least part of cause of action had arisen within the territorial jurisdiction of that court. That is at best its case in the writ petition. Here, my lord, that advertisement was published for participation. 6. It is well settled that the expression cause of action means that bundle of facts which the petitioner must prove, if traversed, to entitle him to a judgment in his favor by the court. Then, my lord, the judgment is set out. Therefore, in determining the objection of lack of territorial jurisdiction, court must take all facts pleaded in support of the cause of action into consideration, albeit without embarking upon an inquiry as to the corrections or otherwise of the said facts. In other words, question whether a High Court has territorial jurisdiction to entertain a writ petition must be answered on the basis of averments made in the petition, truth or otherwise whereof being immaterial. To put it differently, the question of territorial jurisdiction must be decided on the facts pleaded in the petition. Therefore, question whether the instant case Calcutta High Court had jurisdiction to entertain and decide writ petition in question, even on the facts alleged, must depend on whether averments made in so-and-so paragraphs are sufficient in law to establish that a part of the cause of action had arisen within the jurisdiction of the Calcutta High Court. Paragraph 8, my lord. Page, my lord, 719. From the facts pleaded in the writ petition, it is clear NICO invoked the jurisdiction of the Calcutta High Court on the plea that a part of the cause of action had arisen within the territorial jurisdiction. According to NICO, it became aware of the contract proposed to be given by ONGC on reading advertisement which appeared in Times of India at Calcutta. In response thereto, it submitted its tender from its Calcutta office and revised the rates subsequently. When it learned that it was considered ineligible, it sent representations, including fax message to EIL, ONGC, and New Delhi demanding justice. As stated earlier, steering committee finally rejected the offer of NICO and awarded the contract to so-and-so at Delhi. Therefore, broadly speaking, NICO claims that a cause of action arose within the jurisdiction of Calcutta High Court because it became aware of the advertisement in Calcutta. It submitted its bid or tender from Calcutta, made representations demanding justice from Calcutta on learning of the rejection of its offer. The advertisement itself mentioned that the tenders should be submitted to Delhi, that those would be scrutinized at Delhi, and that a final decision whether or not award the contract to the tenderer would be taken at New Delhi. Of course, execution of contract work was to be carried out in Gujarat. Therefore, merely because it read the advertisement in Calcutta, submitted the offer from Calcutta, made representation from Calcutta would not, in our opinion, constitute the facts forming an integral part of the cause of action. So also, the mere fact that it sent fax message from Calcutta, received a reply thereto at Calcutta would not constitute an integral part of the cause of action. Besides, cannot be constituted conveying rejection. My lord, here it is fax. In this judgment, it is fax. In our case, it is the email. Receiving and sending from Kolkata. Now, my lord, the third one. National Textile Corporation versus Haribox Palram.
Yes.
আমার আরেকটা ছিল কলকাতাটা কোথায় গেল মানে প্যারাগ্রাফ 10 yes 796
Thank you. Yes.
Under clause 2 of Article 226, the High Court is empowered to issue writs, orders, directions to any government authority. My lord, I'll be repeating that. So, my lord, if I can start from cause of action, which is the fifth line. Cause of action, as understood in the civil proceedings, means every fact that, if traversed, would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. To put it in a different way, it is the bundle of facts which, taken with the law applicable to them, gives the plaintiff a right to relief against the defendant. In Adani Exports, in the In Adani Exports, in the context of clause 2 of Article 226, it has been explained that each and every fact pleaded in the writ petition does not ipso facto lead to the conclusion that the facts give rise to a cause of action within the court's territorial jurisdiction, unless those facts pleaded are such which have a nexus or relevance with the list that is involved in the case. Facts which have no bearing with the list or dispute involved in the case do not give rise to a cause of action so as to confer territorial jurisdiction on the court concerned. Similar question was examined by in Spiker Properties. Here are certain properties, my lord. This is what it says, my lord. Basically, thereafter, my lord, if my lord comes down, the question which arose for consideration was whether service of notice at the head office of the company at Calcutta could give rise to a cause of action within the state of West Bengal to enable the High Court to exercise jurisdiction in a matter where challenge to acquisition proceedings conducted in Jaipur was made. It was held that the entire cause of action culminating in the acquisition of the land of Rajasthan Act arose within the territorial jurisdiction of Rajasthan High Court. It was not necessary for the company to plead the service of notice upon them at Calcutta for grant of appropriate writ, order or direction under Article 226 for quashing of the notice by Rajasthan government under so-and-so of the Act. It was thus held that the Calcutta High Court had no jurisdiction to entertain the writ petition. My lord, here, my lord, paragraph 12, I will not place. This is with regard to this particular case, my lord. Here also, my lord, certain orders were placed. Orders, my lord, were not later, my lord, carried out, my lord, because by then the state...
Paragraph 12 may be important because they may be relying on it, Ms. Rao.
Oh, very well.
Because here, please better read it.
Very well. In the present case, textile mills are situated in Bombay, and the supply of cloth was to be made by them ex-factory at Bombay. According to the writ petitioners, money was paid to the mills at Bombay. Learned single judge, after detailed discussion of the matter, held that Calcutta High Court had no jurisdiction to entertain the writ petition. Division bench has reversed this finding on the ground that concluded contract had come into existence which could be cancelled only after giving an opportunity of hearing, and consequently, question of revocation of the contract at its Calcutta address would constitute a cause of action.
I think this much would do because this is the important portion.
Now, my lord, the last, my lord, is our decision of the Calcutta High Court, my lord. Here, my lord, Magma Finance has their office here in Kolkata. Proceedings by Cochin. My lord, they say we received show cause notice here. We replied from here. Hence, my lord, to be this Calcutta High Court had jurisdiction. My lord, will kindly take that page 2, third paragraph.
Yes.
In the instant case, my lord has found that the subject
yes.
matter of challenge are impugned summons issued by the authority from Kochi in the state of Kerala. Impugned summons have been received in Kolkata by the appellant company. Such fact is an incidental one and does not constitute an integral part of cause of action so as to vest jurisdiction in this court. Reference in this regard, my lord, to the same decisions, my lord, I am not reading them out. Although it has been pleaded that the appellant company had been subjected to the alleged similar inquiries at the behest of respondent number 3 and other authorities in Kolkata, we are of the considered view that in the factual matrix of the instant case, as impugned summons had been issued by the respondent number 1 authority from Kochi, appellant company is required to respond to the same at Kochi also. Principles of forum convenience, as aforesaid, would dissuade the court from exercising its discretionary jurisdiction. Here, my lord, I have shown, my lord, that the proceedings for CIRP in Cuttack. He was appointed RP in Cuttack, confirmed in Cuttack. He performed all his duties with respect to the said proceedings, maybe from his office here, but they are all relating to Cuttack, my lord. My lord appeared before the Honorable High Court at Cuttack, carried them again to Supreme Court, came back to Cuttack, completed the proceedings, did not entertain 2 applications filed by 2 interveners in Cuttack. My lord, decision made. Those 2 people went up to the appellate tribunal. Appellate tribunal allowed their appeals. My lord made certain observations against the RP on the basis of which
he was cancelled as a resolution professional in this particular proceeding, or
yes,
in general?
No, in this particular proceeding, but not to carry on anymore as a resolution professional.
That is his best part regarding the jurisdiction.
Yes.
I mean, the effect concerns
everywhere,
is wider.
Everywhere in India.
Otherwise, you have a favorable line of judgments. I mean, but otherwise, the only thing which is to be considered is how far that effect can be restricted to either Cuttack, or you have to rely on.
According to him,
yes,
he carried on all his duties as a resolution professional with respect to a proceeding in Cuttack. My lord had to report to Cuttack. My lord, as a resolution professional, at intervals, you file a progress report.
The premise of his cancellation was in Cuttack because he acted in Cuttack. His acts were the
all
ultimate grounds. Everything.
By an authority who is situated in New Delhi.
New Delhi.
Show cause notice from there, his replies submitted, considered there, final order from there, communicated here. No, not even by post.
Communication alone cannot be a basis that has been held time and again.
Time and again.
Apart from Kusum inverse in both the others.
And show cause notice.
Yes.
Or my lord letters. Here, my lord, emails, there, fax messages, that time there was no email. My lord, that also, my lord, has been held that cannot constitute a cause of action. My lord, including, my lord, first of all, my lord, all these things were sent by email. There was nothing by post. Receiving email might be, my lord, anywhere. Today, if I'm
so according to you, it should be New Delhi or Odisha. You cannot say both.
Yes. I say both. My lord, it is for him to choose which he wants to choose. But I say, my lord, it cannot be Calcutta High Court.
Right.
Because, my lord, in another proceeding, I should be fair, my lord. That was with respect to not this gentleman, another gentleman, my lord, whose proceedings were in Kolkata. My lord, that challenge is in Calcutta High Court.
In this matter,
no,
this proceeding,
another
different.
Different. Yes. We have also submitted to the jurisdiction because, my lord, we said that it was with regard to all the proceedings arising out of proceedings in NCLT Kolkata. Lord,
but that is different.
But here, my lord,
that is not available here because here it was Odisha.
It is Odisha.
Yes.
Those are my submissions.
Yes. Yes, Mr. Gupta. On maintainability.
Yes,
only on
maintainability.
Yes.
My lord, just to give your lordship, my lord, a brief background on the issue of maintainability. This challenge in the writ petition does not emanate strictly from any proceeding in NCLT, because the challenge is only with respect to the order passed by the Insolvency and Bankruptcy Board of India. Maybe in respect of proceedings where the petitioner was the resolution profession, but the per se the challenge is an order cancelling the registration of the petitioner as an insolvency professional. passed by the Insolvency and Bankruptcy Board of India. So, my lord, in my humble submission, Cuttack will not have any jurisdiction whatsoever.
Why not New Delhi?
Yes, I need to answer that. My lord, I do not say for once that New Delhi will not have jurisdiction.
Why not only New Delhi?
Because
Decision was taken there.
decision was taken by IBBI in New Delhi. But my lord, the part cause of action, which is really my place of carrying on the business or the profession, is in Calcutta. My registered office is in Calcutta. I have received
Legal
the
age,
order.
can you say it is restricted to then in that event, Mr. Gupta, all over India you can claim, you can file several writ petitions in all of India, wherever you choose.
Yes,
you can do that.
I'll rely upon judgments, though possibly I'm not carrying it today. I'll rely upon judgments which by which Bombay High Court has entertained and set aside order of the IBBI in respect of a resolution professional filed in Bombay. I do not know why.
The proceedings was in Bombay also.
In Delhi. IBBI proceedings in Delhi.
IBBI obviously in Delhi. But,
in Delhi.
But
So
arising from-
IBBI is order challenged in Bombay High Court because the RP was in Bombay and it has been set aside.
Well, yes. What else?
My lord, now your lordship will kindly have a look at my paragraph 96, which my learned senior friend had placed, my lord. Page 42. But firstly, my lord, there's a requirement of the regulation to serve a copy of the order on the affected resolution professional. That has not been done, admittedly. So what has been done is uploading of this in the website of IBBI, stating that the registration has been cancelled.
That is on the merits. I'm only on maintainability now.
Well, kindly see,
Jurisdiction, anything else?
I understand. Kindly see paragraph, page 42, paragraph 96.
Yes.
My lord, all the show cause notices were issued, my lord, were received by the petitioner at Kolkata. The office of the petitioner, the registered office of the petitioner.
These have been turned down in the two judgment, NTC particularly, and also not.
But I shall try and distinguish that on facts. My lord. Possibly, my lord, in my humble understanding, your lordship, subject to your lordship's interpretation, of course, clearly is distinguishable on facts. Subject to, of course, your lordship's interpretation of those, my lord. May I try and assist your lordship in doing that? My lord, your lordship has seen this paragraph, so my lord, the affectation of right has taken place in Kolkata because, my lord, my registered office is in Calcutta and my registration has been cancelled forever. It's not a suspension, it's a cancellation. Now, my lord, your lordship will kindly take a look at, my lord, the judgment, my lord, of Kusum Ingots, my lord, reported as 2004-6 SCC.
Kusum Ingots, Mr. Gupta, is both ways.
Yes. I was trying to show the other way, which was.
No, both ways are available. Kusum Ingots, I am not so prejudiced by Kusum Ingots. I am being very candid. This lays down the law. But what about the others?
But your lordship is on, my lord,
On
oil
all
and
the three
natural
others.
gas. Oil and natural gas.
Oil, ONGC, yes. Oil and natural gas, national textiles.
Yes, oil and
all
natural
of which
gas.
probably mostly pertain to tenders, which took place, the decision took place elsewhere. And
Yes, yes. My lord, here, what happens is, my lord, in tenders, it's an open tender, my lord, where people from all over the country participates. So, my lord, that is why, my lord, the law in respect of tender matters would be possibly that, my lord, all the courts will not be clothed with the jurisdiction because the tenders are open tenders where each and every person sitting at every nook and corner of the country can.
You are relying on a similar principle. You are saying your country, your operation all over the country is being stopped.
No, my affectation is in Kolkata because my registered office is in Calcutta.
You are working as a resolution professional in a proceeding in Odisha, and you are saying your affectation is in Kolkata.
Yes, because the resolution professional has to be registered somewhere, and where the communication is being made with regard to his cancellation of license. But it's not that, my lord, I cannot be a resolution professional in some other NCLT in some other place. But, my lord, your lordship would kindly consider that, my lord, the 226(2) tests are possibly met here. Because, my lord, the substantial and material part of the cause of action, which is, my lord, the receipt of my cancellation of license and the affectation of my rights, has taken place in Kolkata.
Your receipt of the cancellation.
Yes.
Regarding that, please go through these judgments during recess and come back after you.
I shall.
ONGC, NTC, all of this.
I shall.
You are receiving the communication here. That has been dealt with here.
That is, my lord, those are cancellation of tenders. Well, I shall try and assist.
Yes.
I'll try and, my lord,
your answer should be rather obvious. But give that answer. Unless you give that answer, I won't accept it.
I shall try. I shall.
And
try.
she has to refute that also.
I shall try.
Very- Let us come back after.
Continuing matter.
Yes. Sure.
Before I proceed with my argument, is it your lordship's pleasure to kindly have a look at 226 once? Your lordship has seen it umpteen number of times. May I just place it? Just
I
for-
placed it a few minutes back.
Very
It was placed by your friend. Yes. So
226
which portion you want to realize? Tell me. Part
Just
of
that-
cause of action. Part of cause of action.
Part of cause of action.
Yes. That is the only thing.
Irrespective of whether the authority's office is situated.
Some of the judgment it has been held in minuscule part of cause of action may not operate in your benefit. No. The other way
But
around.
here, all the judgments hold that where the integral cause of action
Yes.
has arisen, then
True.
whatever facts have been pleaded in the petition which do not form part of the integral part of cause of action does not clothe the court with the jurisdiction. That's the only.
What is integral in Calcutta? Yes.
I'm sorry, Manoj?
What is integral in Calcutta in your
Yes. What is integral in Calcutta is what your lordship would consider whether that is material. Now, my lord, may I start my arguments by May I hand up a book as of now, my lord, the printout is on its way. My lord, this is, my lord, reported at All India Reporter 2015 Calcutta, page 67.
No.
Ache. But it's a coordinate bench judgment of this honorable court, my lord. Your lordship will kindly take a look from paragraph, my lord. 11. The paragraph begins with whenever an objection of lack of territorial jurisdiction.
Please, can you give me the citation to 2015?
Yeah, 2015 Calcutta, page 67. My lord, the printout, it's on its way, my lord. I shall hand up a copy, my lord.
Later on, yes.
Yes.
You are on paragraph?
11, my lord.
11.
It starts with whenever an objection.
Yes.
Has your lordship got it, my lord?
Got it, yes.
Yes. Whenever an objection of lack of territorial jurisdiction is raised, the decision since Viker Properties and Utpal Kumar Basu has been relied upon by my learned senior friend, my lord, are invariably cited by the objector. No court, much less than the Calcutta High Court, can choose to decide any matter touching the point of territorial jurisdiction before it ignoring the said decisions. Where perusal of the said decisions together with the decisions referred to therein would leave none in doubt.
Here, in fact, all the decisions were cited.
All the decisions.
ONGC, NTC.
Yes, yes. That Calcutta High Court incurred the displeasure of the Supreme Court on more occasion than one. It's a judgment written with a lot of emotions.
No, the same fate. I also had an occasion. It was cited. One judgment was cited 2 paragraphs probably. It was just to castigate Calcutta High Court, and that was cited for that reason only. So I had to observe something similar. We face these things always.
This your lordship would see, it's been written with a lot of emotions. Apart from
Should we? Yes. So I'm not prejudiced by that.
No.
So see, let us skip over that.
No, yes. But otherwise also, then I'm skipping paragraph 12.
Skip paragraph. That's entirely on that.
That is entirely.
I've seen it.
I'm skipping that.
Yes.
Paragraph 13. 29 years and 20 years have passed since the decision since Viker Properties and Utpal Kumar Basu respectively were rendered. Calcutta High Court.
This is also on that probably. We are continuing on that.
Very well, my lord.
So let us come to 14.
14. The discussion must begin with a caveat. It is indeed not within my province to answer the questions that are posed for. It is well known that a High Court judge would not be justified either in law or on considerations of judicial discipline, and to committee to show disrespect to any order or direction made by the Supreme Court, or to question the propriety of such order or direction either when the said judge is called upon to apply the law laid down therein without deciding an issue before him, or while betraying. This is also on
up to paragraph.
Yes. Kindly comes to paragraph 15 then.
Typical of Justice Dutta.
And now,
very good. I appreciate.
Now,
41, my lord, probably.
41.
Now, Justice Dotto had recently, my lord, in Supreme Court, of course.
Hindi.
Has laid
Hindi
down,
judgment is circulated everywhere. Witnesses can go and depose in Hindi,
Yes.
although they belong to West Bengal.
At least asked to question, I suppose.
But
Yes.
I am
Right.
not on that one. My lord. I am on a judgment where, my lord, it says that even if a disputed question of fact is there, writ can be entertained. 2023 May.
Yes.
So that is yet to be reported, but that is possibly the latest judgment operating in the field. So finally, he now has the power, my lord, to control all courts across the country. The decision in Swiker Properties is considered first. It deals with two important points. One is with regard to erroneous assumption of jurisdiction by the Calcutta High Court, and the other,
You're reading which paragraph?
paragraph 15, my lord, I'm sorry. Paragraph
Paragraph?
15, 1-5.
Of Justice Datta's judgment?
Yes.
Very well, yes.
It starts with the decision in Swiker Properties. Para numberings are different possibly.
No, paragraph is all right. Yes, it's right. Yes. Because after that also this refrain of Calcutta High Court thing continues. It's entirely on that, Mr. Gupta, basically.
No, but it
So,
deals with the 226(2) and what is integral cause of action.
Right.
Kindly see paragraph 16. Insofar as ex parte ad interim, insofar as ex parte ad in interim order made by the learned judge is concerned, the relevant passages from the said decision are quoted. Then, my lord, I'm not troubling your lordship with this portion. Then kindly comes to, my lord, paragraphs 70, paragraph 18.
You can directly come to para 41, as Ms. Rao said. Before that, it's a pristine glory of Calcutta High Court. Literally. 48. Read para 40, you'll understand. And prior to that, mostly from Calcutta.
I missed paragraph 40. Yes, absolutely.
After from paragraph 41, yes.
41.
Yes.
Yes. Turning to the objections at hand, it must be decided in view of the pleadings and not on the basis of the conclusions reached in Swiker Properties and Utpal Kumar Basu, that the Calcutta High Court assumed a jurisdiction that it did not possess. The decision in the former case never laid down the law that receipt of a notice within the territorial limits of a high court is not sufficient to clothe such court with jurisdiction. On facts, it was found that it was not necessary to plead the service of the notice. What the Supreme Court said was that the receipt of the notice in order to confer jurisdiction on Calcutta High Court must have been an integral part of the cause of action. In the latter case, even every event or incidental or incident material to the decision on the list was held to have occurred beyond the territorial limits of the Calcutta High Court. And even if the payments in the writ petition were taken as true, it could not be said that any part of cause of action arose within the jurisdiction of Calcutta High Court. Here the facts are different. Although the decision to withdraw the honor that was earlier conferred on the petition was taken in New Delhi, the chain of events could not have been complete without the public notice being published in terms of the direction of the chairman. There cannot be any doubt that the contents of the public notice itself bears a vital link in the entire chain of events, commencing from the grant of award to the petitioner with plaque, initiation of proceedings for withdrawal and decision to withdraw the award and the plaque, and to notify the public, including the petitioner, the decision regarding the withdrawal, and ultimately culminating in the paper publication wherefrom the petitioner could come to know of the impugned decision resulting in consequences as alleged. But may I pause here for a moment with your lordship's permission, Malud? Kindly juxtapose this with the present facts, where the from the website of IBPI at the petitioner's office, the petitioner has come to learn of this, and the provision of the regulations mandatorily prescribing that it has to be communicated to the petitioner's office. That is not. The claim of the petitioner that this court has territorial jurisdiction is also based on citus of affectation of rights. Mr. Such and Such has referred me the decisions in National Textile and Alchemist. The reasons for upsetting the judgment and order of the division bench of the Calcutta High Court are recorded in paragraphs 12 and 12.1 of the decision in National Textile. It is clear that the point based whereon the division bench had held the part of cause of action had arisen within its territorial limits was found by the Supreme Court not to have been pleaded in the writ petition, and that mere carrying on business of the writ petitioner at Calcutta or receipt of correspondence in Calcutta were not integral part of the cause of action. Although in Alchemist, the point of consequence of the letter of revocation was raised, the Supreme Court held, while affirming the order of the High Court, holding that writ petition is not maintainable before it, that none of the facts pleaded constitute essential, integral, or material facts so as to constitute a part of cause of action within the meaning of Article 226(2). The decisions are therefore distinguishable on facts. It cannot be disputed that whether or not cause of action in part has arisen within the territorial limits of a particular high court has to be examined having regard to the facts and circumstances of the case, as well as what is pleaded in support of claim, irrespective of what the defense of the adversary is. Each case must therefore be decided on peculiar facts and the nature of infringement of right that the aggrieved voices in the request. Then, my lord, it quotes from a judgment of 90 CWN. I am carrying that separately, my lord. I shall be placing that. Kindly skips this, my lord, as of now. Kindly comes to, my lord, paragraph 46. It begins with in Uma Shankar.
Yes.
In Uma Shankar Supra, Honorable Justice M.M. Dutt, speaking for a division bench of this court, held that an order of dismissal or removal from service is effective on the authority concerned as soon as it is sent out, but so far as the government servant is concerned, it becomes effective only when he is apprised of it either by oral communication or by actual service upon him. Consequently, the order of removal became effective when the appellant received it through post office in Calcutta, he having no prior knowledge of the same by any other means, and part of cause of action arose in Calcutta, conferring jurisdiction on this court to entertain the writ petition. Possibly our facts are somewhat similar to this. Kindly see paragraph 47. These decisions have stood the test of time and provide guidance that is invaluable. 48. To hold the service of an order or notice to the addressee would never give rise to a cause of action to move court within whose territorial limits the order or notice is received may not be reasonably sound. If service of an order or a notice is an event of substance, that is an event which is material, essential, or integral part of the list connected with the action that is impugned in a writ petition, there is no plausible reason as to why the same should not be construed as constituting material, essential, or integral part of the cause of action. The plea of affectation of right or interest by reason of such order or notice being served, if based on substantial fact forming a part of bundle of facts constituting the cause of action, would indeed be relevant for determination of the question as to whether the writ petition ought to be entertained or not. Here, the decision to withdraw the award and the plaque from the petition was never communicated to him prior to the public notice being published in the print media, and it is such publication the only one in the series to make the public aware of the penalty imposed on the petitioner that vitally affects the reputation and respect that he has earned over the years. Such affectation having taken place at Shantiniketan, where the petitioner alleges he read the public notice for the first time and derived knowledge of the impugned decision of the academy, being of no material, at least at this stage, that the decision was formally served on the petition in any territory beyond West Bengal prior to the public notice being published, is an essential, integral, essential, and material part of the list, constituting the cause of action to approach the court and conferring jurisdiction on this court to entertain the writ petition. The fact that the petitioners before the Allahabad High Court withdrew the writ petitions with liberty to approach the appropriate High Court is absolutely irrelevant and immaterial. I'm not going. So, Malad, the writ petition was, Malad, the argument on the maintainability was negated on this Malad, score. Now, your lordship will kindly have a look at Malad, the judgment which has been quoted, Malad, of 90 CWN. It's a judgment reported 90 CWN, page 438.
Yes.
Now, kindly see paragraph 4. The question whether or not cause of action, not here on facts, I should be candid, the High Court's jurisdiction was not found to be there. But kindly see the discussion in paragraph 4. The question whether or not cause of action wholly or in part for filing a writ petition has arisen within the territorial limits of particular High Court ought to be also decided in the light of the nature and character of the proceedings under Article 226 of the Constitution. Every High Court has jurisdiction to issue directions or orders writs for enforcement of fundamental rights and for any other purposes. The pertinent question would be whether within the limits of the High Court in which a writ application has been filed, any of the facts would entitle the petitioner to obtain relief under Article 226 of the Constitution has arisen. In other words, in order to maintain his writ petition, the petitioner has to establish that within the territorial limits of the court's jurisdiction, prima facie, a legal right claimed by him, such being been either infringed or is threatened to be infringed by the respondents. Such infringement may take place by causing him actual injury or threat thereof. Accordingly, when the impugned act of the respondents takes effect within the territorial jurisdiction of a particular High Court, it may entertain a writ petition of the person aggrieved, notwithstanding that the respondents have their offices or residencies outside the territorial jurisdiction. An order has been made by an authority or person at a place beyond the territorial limits of a particular High Court, but the same is given effect to against the petitioner within the said High Court's jurisdiction. In such a cause, at least a part of cause of action arises where the impugned order is implemented. Thus, when an order becomes effective only when it is communicated or served, the service of the order or receipt of a notice thereof would form part of cause of action for filing a writ petition by the person aggrieved. This is the portion I was relying. Now, kindly takes a look at a judgment delivered by my lord dated 13th of June 2023.
Oh, you got that also? Yes.
Kindly turns to page 4. But here was a question of blacklisting.
No, this is
Kindly comes to page 3 once.
Yes.
But this was regarding communication of a blacklisting.
Hmm.
But here alchemist judgment was cited. Thereafter, your lordship will kindly see the penultimate paragraph at page 3. The paragraph begins with that apart even logically. That apart, even logically, alchemist was considering a case where the challenge was primarily against the disapproval of the proposal submitted by the appellant company, which was tantamount to a refusal to enter into a contract or rescinding a contract. The premise of such challenge is very limited when compared to the present one, the latter being on a wider footing of blacklisting the petitioner for participating for 1 year for any work and the AAI. Moreover, as rightly observed by the division bench with utmost respect, another logic which sanctifies the territorial jurisdiction of this court is that the effect of the impugned blacklisting would directly be that the petitioner would not be able to function in any activity of AAI from its registered office situated in Kolkata, which is within the territorial jurisdiction of this court. Thus, the same operates on a wider scale than a mere refusal or rescission of a contract. Thus, the objection as to territorial jurisdiction taken by the respondent is turned down. Here also, the facts are somewhat similar. The last judgment which I would like to place.
But these are single judge judgments, Justice Datto's judgment and my judgment. But as opposed to the Supreme Court judgment.
Supreme Court judgments all have been considered by Justice Datto. And I shall show also from the facts by taking to those judgments which my learned senior friend had placed, that how the facts are completely different from our case. That also would be my.
Yes, they are, somewhat are. Yes. That's why he asked Ms. Rao to lead para 12 of NCC. Yes.
This is a judgment.
Multiply too many judgments.
No, this is the last one.
This
is the last one. No discussion in this judgment on jurisdiction. But I've given. But the only reason why I'm citing this is a judgment of the Bombay High Court.
That
challenge, yes, that I was saying.
Yes, yes.
The challenge was an order. Kindly see paragraph 2. The above petition is filed impugning the order passed by the disciplinary committee appointed by the Insolvency and Bankruptcy Board.
Right.
This pertains to an NCLT proceedings in Delhi. In our case, it is Cuttack. This pertains to IBBI order passed by Delhi in Delhi, same as ours. And the impugned order which is there is also quoted, yet the Bombay High Court has considered this and passed an order. So it is only for such purpose that I am placing this judgment that the jurisdiction has been exercised on the basis that the the affectation has taken place here.
No, was the jurisdiction point taken here?
No, no.
Then it's not an adjudication.
I am not on that. That's the first thing which I submitted while placing this.
No, no.
No issue on jurisdiction taken. But this shows that IBBI order in Bombay has been the writ petition has been entertained challenging an IBBI. That's the only thing.
Great.
Nothing. No question of jurisdiction even taken. Now your lordship will kindly take a look at the judgments which my learned senior friend had placed. My lord, may I start with my lord, oil and natural gas versus Utpal Kumar Basu.
Yes.
1994 4 SCC 711. Kindly, my lord, straight away, my lord, kindly come to paragraph 6 of the judgment. I'm sorry, my lord, paragraph 5, placetum C.
Yes.
Just the last sentence of that paragraph. In order to confer jurisdiction on High Court of Calcutta, NICO must show that at least a part of cause of action had arisen within the territorial jurisdiction of that court. That is at best its case in the writ petition.
Yes.
Then kindly comes to paragraph 6. I'm not troubling your lordship with the initial portion. Kindly comes to paragraph placetum E and F. No, E and F. Therefore, in determining the objection of lack of territorial jurisdiction, the court must take all facts pleaded in support of the cause of action into consideration, albeit without embarking upon an inquiry as to the correctness or otherwise of the said facts. In other words, the question whether a high court has territorial jurisdiction to entertain a writ petition must be answered on the basis of the averments made in the writ petition, the truth or otherwise whereof being immaterial. To put it differently, the question of territorial jurisdiction must be decided on the facts pleaded in the writ petition. Then skipping the next, because that is fact specific, kindly comes to paragraph 7. The learned counsel for ONGC contended that on these averments, no part of cause of action had arisen within the jurisdiction of Calcutta High Court, and hence the writ petition filed by NICO and another was not entertained by High Court. May I pause here for a moment with your lordship's permission, my lord? Here your lordship will see that they cannot contend that Calcutta High Court does not have a jurisdiction, because the communication or the office of the petitioner is here. Kindly sees the your lordship has possibly gone on to the next page.
No, this was regarding a tender.
This was regarding a tender, and the cause of action was based on the publication in newspapers.
Yes, yes.
So, this, in my humble submission, is not relevant. Kindly, only one other paragraph which I shall show, my lord. Paragraph 8, only placetum E, where the distinction is there with our case, my lord. The placetum E, one of the sentence starting with the advertisement itself mentioned.
Yes.
The advertisement itself mentioned that tenders should be submitted to Delhi at New Delhi, to EIL at New Delhi, that those would be scrutinized at New Delhi, and the final decision whether or not to award the tender would be at New Delhi. Then skipping the next sentence, therefore, merely because it read the advertisement at Calcutta and submitted the offer from Calcutta and made representations from Calcutta would not, in our opinion, constitute facts forming an integral part of the cause of action.
In your case also, decision was taken in Delhi.
I'm sorry, Mula.
In your case also, the decision was taken in Delhi.
Decision was taken in Delhi.
Here also, decision was taken in Delhi.
Yes. But here the cause of action was on the basis of, my lord, the paper publication and participation in a tender. It's a question of.
Here the petitioner saw the advertisement in a particular place in Calcutta, and it was said it did not have jurisdiction.
No,
in your
advertisement is for the tender. Advertisement is for the tender. While participating in the tender, he saw the advertisement in Calcutta.
Yes, exactly.
Yes.
Tender was to be performed elsewhere.
Yes.
In your case, the proceeding happened in Odisha, but that is regarding the proceeding only.
Yes. So we are not on the proceeding.
In this particular case, the main distinction is it was regarding a rejection of a bid in a tender process. In your case, not regarding one particular tender.
Not regarding,
but generally,
my entire license is gone.
Similar is for Bombay.
Similar is for that one, and also
NTPC also similar. NTC also similar. Page 12 narrates the facts.
It is also similar on that facts. And
Mr. Gupta, I cannot give too much time to maintainability. You have to be short. Yes, what else?
Yes, so these are my points. Paragraph 96, I have pleaded that the
So any other
affectation-
distinction in the other judgments you want to?
Your lordship has just now said that.
NTC is all right.
Yes, and Kusum ingots, your lordship.
Kusum
had-
is general.
Yes.
Magma.
Magma. Yes, your lordship will kindly take that judgment, my lord. My lord, this pertains to receipt of summons
Yes.
from Kochi. That was a case where, my lord, the challenge was to a proceeding which was in Kochi. Here, my lord, there is no challenge. The proceeding is over. There has been a communication of the final decision affecting the right of the. So there is not that some proceeding like in a 227 case. My lord, in other high courts, 226, 227 is normally taken up together.
Right.
Unlike in our case. Here it was a challenge to the summons. But I had missed placing one judgment, if your lordship permits.
Yes, do that.
2019 volume 20 SCC, Supreme Court cases, I'm sorry, 517. Well, this was a case where the Gujarat High Court had refused, the Ahmedabad, Gujarat High Court had refused to entertain a writ petition on the ground of lack of territorial jurisdiction. Kindly comes to straight away, I shall not trouble your lordship with everything. Kindly comes to paragraph 25 at page 522. Coming to the
Justice Dotto's judgment, Justice Dotto's judgment you had handed over to me. Did you?
No, my lord. Yes, my lord. I'm just now handing. Our copy is
Yes, yes.
Did it?
Yes, this. About the last one? Yes.
Paragraph 25 at page 522.
Yes.
But here the office of the respondent was at Calcutta. The writ petition was filed in Gujarat. Gujarat refused to entertain the writ petition, challenging that order, my lord. Supreme Court had decided the matter, saying Gujarat would have the jurisdiction, decided it on jurisdiction and remanded the matter back to Gujarat. Kindly comes to paragraph 25. 25 and 26 are the two paragraphs relevant, my lord, for our purpose.
What was the cause of action here? I mean, the cause for preferring the writ?
Probably paragraph 6.
Well, paragraph 6 regarding non-payment of outstanding wages and outstanding labor wages. My lord, there was an Industrial Dispute Act proceeding.
Right.
But here your lordship will kindly see paragraph 25. Respondent number 1, company has its factory at Porbandar, which is part of the state of Gujarat. Second, the Labour Court, Junagadh, was also part of state of Gujarat, entertained the dispute between the appellant, such and such, and the non-payment of the outstanding wages payable to the workers of the respondent number 1 company. In the light of these three reasons, we are of the view that the part of cause of action, as contemplated in Article 226(2) of the Constitution, has arisen within the territorial jurisdiction of Gujarat. Then paragraph 28 and 29. Indeed, the question as to whether the cause of action for filing of the petition wholly or in part arose in the context of territorial jurisdiction of the High Court is required to be decided keeping in view of the provisions of Article 226(2) read with Section 20 of the CPC. And thereafter, this was remanded.
Yes.
Those are my submissions.
Yes, Ms. Ravani.
My lord, let's start with the last judgment, my lord, the cement workers mandal.
Yes.
My lord, paragraph 6, my lord, he has placed dispute arose between the appellant union and respondent company employer regarding non-payment of outstanding wages payable to the workers. My lord will kindly turn over the next, or rather from paragraph number 9. Here, my lord will find that the DRT allowed the claim petition, which was filed in Kolkata, had allowed the claim petition ordered for sale of the properties of the company after giving due publicity. So what the workers wanted, my lord, against the sale proceeds, part to be kept aside for their payment. My lord will kindly turn over to page 519 and my lord will kindly see the reliefs A at the top. My lord has found
Yes, he's got it.
to issue an order to deposit 50% of the sale proceeds of Porbandar with the district collector Porbandar and district collector be directed to pay by way of an account pay check to each of the workmen proportionately towards the part payment of the legal dues, alternately this. So, my lord, here, my lord, the Labour Commission dispute was in Gujarat. The sale of the assets of the company happened in Kolkata in a proceeding in Kolkata, but the corpus, my lord,
The parent proceeding was in Gujarat.
yes, and my lord, they had asked for retaining a portion of that for adjustment of the proceeding in Gujarat. Hence, my lord, the Gujarat High Court would have, according to me also, my lord, it would have had the jurisdiction to try it. And my lord, the Supreme Court had remanded it back on that basis. And my lord will kindly take once paragraph 25, which my learned friend had pointed out. We find from the averments that respondent company has its factory at Porbandar, which is part of Gujarat, Labour Commission, Labour Court, Junagadh, which is also part of Gujarat. My lord, here the proceedings were relating to the Junagadh court. Hence, my lord, Gujarat had the jurisdiction. Two, my lord will kindly take first. My lord, I am not going through that IBBI judgment, my lord, because there, my lord, the Bombay High Court on the IBBI, because my lord, the jurisdiction point was not raised. My lord will kindly take first, my lord, the 1985 decision, my lord, Manupatra, which my learned friend has handed over.
90 CW.
My lord got that. My lord, paragraph 4. Question whether or not cause of action wholly or in part for filing writ petition has arisen within the territorial jurisdiction ought to be decided in the light of nature and character of proceedings of the Constitution. Every High Court has jurisdiction to issue writ or orders or writs for enforcement of fundamental rights or for any other purpose. Pertinent question would be whether within the limits of the High Court in which a writ application has been filed, any of the facts which would entitle the petitioner to obtain relief under 226 has arisen. In other words, in order to maintain this writ application, petitioner has to establish that within the territorial limits of the court's jurisdiction, prima facie, a legal right claimed by him has either been infringed or has been threatened to be infringed by the respondent. My lord, here, if we pause here for a moment, the legal right has been infringed or has been threatened to be infringed. My lord, his legal right was to be given a show cause notice, given to participate in that. He has participated. Opportunity of hearing was given. That was that there also he participated. So, my lord, there was no infringement of that. Now, my lord, accordingly, when the impugned act of the respondents takes effect within the territorial jurisdiction of a particular High Court, here it has not, it may entertain the writ petition of the person aggrieved, notwithstanding that the respondents have office or residences outside the territorial jurisdiction. Here, the respondent has an office outside the territorial jurisdiction of this honorable court. An order may be made by an authority or person at a place beyond the territorial limits of a particular High Court, but the same is given effect to a petitioner within the said High Court's jurisdiction. In such a case, at least part of cause of action arises where the impugned order is implemented. Now, my lord, here, in our case, my lord, agreed that his license would then stand cancelled. It would take effect here, but it would take effect for the entire country. Then, my lord, he can file the writ petition tomorrow.
The country, including Calcutta.
Including Calcutta, no doubt.
To go not on the reverse basis that whether Delhi had
because he had a registered
whether Calcutta has jurisdiction.
Yes, only on the basis of my lord his.
So in this case, as at least a part of the cause of action arises here.
No, my lord. I say, my lord, that the license with which he had to practice, my lord, was pan-India. My lord, that just he had a registered office here would not.
Pan-India, Delhi is as much India as Calcutta.
No, Delhi, my lord, I'm not standing in the way of Delhi.
Odisha is as much Calcutta as Kolkata. Here on Kolkata, whether Calcutta High Court has jurisdiction, not on whether Delhi also has jurisdiction. Delhi, Odisha may also have jurisdiction.
Yes, my lord, I say, my lord,
you are saying Calcutta does not. So you have to
say, my lord, it does not, because just having a registered office here and receiving the communication here, my lord, does not give him the cause of action. More so, my lord, they were all by email. All communication was by email, my lord. Just because I have a registered office here, my lord, and I receive the communications, even if I receive it by post, my lord, does not give a part of the cause of action arising here.
Yes.
Now, my lord, Justice Dotto's judgment.
Yes.
My lord, the first thing here is, my lord, there was no show cause notice issued to him, no hearing given to him. It was only from the publication made that he came to know that there was no, there were the proceedings against him, and my lord, his plaque and all was recalled. My lord will kindly take page 2 of the judgment, paragraph 8. Then, my lord, there is a subclause 8. Petitioner, the paragraph 8 in the writ petition has been quoted.
Yes.
Petitioner states that he was at no point of time served with the communication or notice granting him opportunity to explain his position. My lord, cause of action, bundle of facts, my lord. Every writ petition would have a different, my lord, a bundle of facts. My lord, here in our case is different, my lord. Here he had been given notice, asked to participate, he participated, and my lord, the order dated so-and-so, which has been claimed to have been issued under so-and-so of the Constitution of the Academy, was not served upon the petitioner. Until date, the petitioner is not aware of the contents of the order, which appears to be the basis of publication of the notice. He says he has not been served with the order, my lord. I have to come back with that. Petitioner states that he has made a demand of justice, wherein he has agitated the issue. Now, my lord will kindly take paragraph 44. It cannot be disputed that whether or not cause of action in part has arisen within the territorial limits of a particular high court has to be examined having regard to the facts and circumstances of the case, as well as what is pleaded in support of the claim, irrespective of what the defense of the adversary is. Each case must therefore be decided on its peculiar facts and the nature of infringement of right that the aggrieved voices in his writ petition. I have placed, my lord, paragraph number 96 at page number 42, accepting that, my lord, the communications were received here, nothing more. I have also shown, my lord, communications were all by email. Nothing was sent to this address. Of course, he has his registered office here. My lord's decision. My lord will kindly take this. Actually, I have not gone through.
Because it's my decision, I may be biased, so I should not rely on this.
So my
That
lord
is
will
one of the
kindly
grounds.
rely on this also.
No, the worst part for you is the blacklisting part. I mean, blacklisting has a, because the effect seems to be a.
He would say that cancellation of my license would also have the same effect.
Yes. Anyway.
My lord, in the page 2, my lord. In the said judgment, Supreme Court had inter alia gone on to hold that which had hold the fact that facts which had no bearing on the list or dispute involved with the case do not give rise to the cause of action, so as to confer territorial jurisdiction on the court concerned. In the said case, none of the respondents was stationed within the state of Gujarat, for which it has held that the High Court did not have territorial jurisdiction. Show cause notice was issued where perusal of the communication indicates same does not reflect any consideration whatsoever regarding any objection that the petitioner might have to the decision to blacklist the petitioner for 1 year. Be it for 1 year or even for a day, order of blacklisting not only casts a stigma, but also affects the goodwill of the party. My lord, here I have not gone into the merits, but I can show from the, my lord, what is being annexed by my learned friend. Each and every document relied by him has been considered by the IBBI.
Means now apparently it seems that the Supreme Court was unnecessarily harsh on Calcutta. I mean, Justice no, that's on a different aspect. Not because I am sitting in Calcutta and saying this. No, not for that. For the reason I'm telling you the reason, because 226(2) is only on even if a part of cause of action arises, you have jurisdiction. So presumption is you have jurisdiction.
Yes.
You have
Now
to
I
go
have to
against that.
negate
Right.
I have to negate that, my lord.
Right. You have to negate that.
Yes. Therefore, I have said, my lord, that just having a registered office.
And now the Supreme Court has time and again in 3 judgments, at least 2 judgments at least, which you have cited, and another judgment, which was not cited by you, but it has been held by Supreme Court time and again, integral part of this. Very well. Yes. Right. It has to be an integral part, but need not be the gamut of the facts, most of the facts. No, even if a stray arises within the jurisdiction of some particular court, it has jurisdiction.
Well, only one point here.
226(2) is that.
If it is a stray,
but it has to be a part of the cause of action.
yes, my lord, a stray fact, my lord.
Stray, I am not probably right on saying stray.
A fact.
Unimportant, you may say, or a minor fact. Yes.
A minor fact which affects the petitioner. But my lord will kindly see with regard to, my lord, consideration of the case as a whole. My lord, a minor fact might not have a bearing.
Although here it is not minor because his license is in
License
Calcutta.
cancelled. But my lord, it might not have a bearing. It has to be gone into on the facts that have been pleaded. His participation in the proceeding. His participation in the proceedings were not here. His participation in the show
No.
cause notice was not here. Hearing given by an authority in Delhi. Well, those would be the major facts which needs to be looked into. A minor fact that I have received the notice here, or I have received all
It's
of
major minor distinction. There I have some problem because 226(2) does not distinguish on that count.
Agreed. But my
Major
lord,
minor, you cannot
but
say
we-
major minor in a bundle of facts.
agreed, my lord, but this fact probably would not have a bearing on the entire case. That is what I see.
All right, fair enough.
These are my submissions.
So I'll close your arguments on maintainability only. I'll pass my order. I'll keep it as 4 orders for issue of maintainability, and I'll hear you on the merits if I turn down her
Yes,
plea.
well, only thing is, well, your lordship would, in the meantime, pass an order of stay of operation. Only for the reason being, my client is already a resolution professional in 2 other matters, not connected with this, in 2 other matters, which is
No,
already.
you cannot
going on.
proceed with that resolution. I'll try to be as fast as possible, Mr. Gupta, but you cannot proceed
But
with
the
other resolutions.
entire CIRP of these 2.
That will be granting you the relief in this.
My lord, that would not.
Others have to
probably-
be in suspension.
Well, may I try and persuade your lordship with only one provision of these regulations, with only one provision which permits that to be done. Which permits that to be done even if there is a cancellation of the license. Only that provision, because that authority is given in the statute.
No.
Even if there is a cancellation, then also, my lord, the board would permit to complete that. That is permitted by the statute. So only that thing. Not otherwise, my lord, those 2, they would be affected, my lord. And here, there is no financial defalcation allegation. Here is a case whereof neglect.
Mr. Gupta, I can dispose of the maintainability point right now, but the matter after
I understand.
you, the matter after you is of much more
I
importance than your
completely
matter.
understand. I'm not for once
Much more
saying,
important than
but
your
I'm not for once saying that, my lord,
It's
you're-
not regarding a resolution professional.
I completely
It's
understand,
on a
but
much higher footing.
but only because of that provision which
So very well,
permits that
then
to
I
be
can do this, Mr. Gupta. I'll put this as I'll just keep it in suspension your matter because I have origin side matters after this. I'll take up item 10, pass an order on that, and then come back to your matter if it is within 3. Otherwise, I'll continue this hearing and
But I
pass
leave
my
it-
order tomorrow.
Your lordship's procedure, whichever your
So
lordship.
I'll suspend this for a minute or 2. I mean, I'll take up the next matter.
Which whatever.
অরিত্র আইটেম 10টা উপরে দাওনি কেন? তুমি তো জানো ওটা কি ম্যাটার। প্রথমে দাওনি কেন? তুমি জানো না ওটা কি ম্যাটার? তাহলে ওটা তলায় কেন? লাস্ট ম্যাটার কেন? ওটা কমার্শিয়াল নয় বলে। ডাকো ওটা। I'll call on 10. And please just keep it in. You're in animated hibernation. Yes.
Item 10.
The other matters will not be called.
Everything will be called. Everything, one after the other. Yes, Mr. Dhar, any report has come.
Yes.
Lordship, there was a direction for filing on compliance.
এগুলো থাক না এখানে। Yes.
My lord,
Yeah, we are just filing.
there are most of the cases we come with lot of allegations, etc., etc. In this case, my lord, I feel very good to say, lordship's order was passed on 17th, and we could get the soft copy of the order within few
I was
minutes.
of the opinion of the mind of I'm recording it in the order. In fact, so much cooperation from all
My
quarters,
lord,
despite
on
Mr. Galib
my lord,
being there.
it was sent by WhatsApp to the CMOH, to the concerned CWC everywhere. They formed the committee on the same day, 2:30.
Any con to doing it?
And ultimately, the good thing is that the medical board have found, because it was given to me
File
also.
it, yes.
Yes, that.
File it.
Milord, may I just, Milord, hand over?
খুলে দাও, খুলে দাও, খুলে দাও। আমটা রেকর্ডে থাকবে অরিত্র।
Kindly see the last annexion.
Where should it be? Tell me, give me an option.
So,
Any
Milord, I had a discussion with Director Health.
Excellent, yes.
May be transferred to SSKM or Medical College, National Medical College, and it will be done.
Your choice, Mr.
Because
Dhar.
that is a budding medical college in Tamroli.
Yes, yes, you're absolutely right.
Lordship.
I was also thinking in that line because it would be a bit risky.
So it will be done.
Is it possible to bring her here within a day?
Yes, yes.
So you can take care of that.
My lord,
I'll direct the authority to the
Let us,
authority.
yes, let us go
You're
for.
doing so much, Mr. Galib, you do a
So
bit
let
more.
us go for SSKM.
Very well, SSKM. Act order record. Order. Our report is filed today by respondent number 7 and 8, which contains the opinion of the medical board dated August 18, 2023, full stop. Next para. The crux of the said report is that considering the circumstances and the physical condition, physical and mental condition of the patient, the board members have arrived at a decision that pregnancy should be terminated, but for the safety of the patient and to mitigate any complication, it should preferably be done at a higher center than the Tamrolipto Government Medical College and Hospital, which facility is available in the district of Purbo Mednipur, where the survivor is now located. Full stop, next para. In view of such opinion of the board, the a query is made by the court to the respondent number 7 and 8, through counsel, as to which would be a suitable hospital having the requisite facilities to carry out such medical termination of pregnancy for the minor. Full stop, learned counsel for the respondent number 7 and 8, upon taking instruction, submits that the SSKM hospital in Kolkata would be a suitable hospital for carrying out such procedure. Full stop, next para. Heard learned counsel for the parties, full stop. Since an extremely fair stand has been taken by the respondent number 7 and 8, the respondent number 7 and 8 are directed to ensure that the survivor, whose medical pregnancy is to be his pregnancy is to be terminated medically, shall be brought to the SSKM hospital at Kolkata, taking due care that the said survivor is attended to medically during such transit, and a team of doctors shall carry out the procedure of medical termination of such pregnancy of the survivor at the earliest, taking due care of all formalities as envisaged in law on such aspect of the matter, irrespective of the fact that the statutory period of 24 weeks of pregnancy has been exceeded. Full stop, next para. I'll dispose of the writ petition.
My lord, kindly involve 3 also. Director Health Service. Lordship.
Yes, yes.
Full stop. The respondent number 3
Lordship.
is also directed to ensure that the above order is duly carried out at the earliest. Full stop, next para. This court would be failing in its duty unless it is recorded that extreme cooperation and goodwill has been received from all quarters, including learned counsel for both sides, as well as the Purbo Mednipur District Legal Services Authorities and the doctors and all institutions concerned in seeking to ensure that the survivor in question gets appropriate medical care and attention. Full stop. Wishing the best to the child. WPA 19822 of 2023 is disposed of
Lordship, Kolaghat
in terms
PS
of the above observations.
Lord, Kolaghat PS has given us something in seal cover. I have not opened. Kindly keep it
Nothing
on.
is.
No, give it. Need not.
My lord, only thing that legal services authority, it should be Calcutta Legal Services Authority.
Oh, not the Purbo Mednipur. Purbo Mednipur Calcutta College. Thank you.
We are deeply obliged.
Thank you. We'll come back to that Mr. Gupta and Ms. Rao's matter.
Lordship.
Yes.
Okay.
Item 9.
The hot order likhi. No. The question of maintainability of the writ petition is raised at the outset by learned counsel appearing for the respondent. Full stop, next para. Learned counsel for the respondent cites The judgment rendered by the Supreme Court in Kusum Ingots and Alloys such and such, reported at 2004 6 SCC 254, comma, to argue on the contours of Article 226 within bracket 2 of the Constitution of India, full stop. Next para, learned counsel also places reliance on the judgment of ONGC versus Utpal Kumar Basu and others, reported at 1994 4 SCC 711, as well as 2004 9 SCC 786, in support of her proposition. Full stop. Next para, in ONGC, comma, it is argued, comma, it was observed that the dispute arose in connection with the rejection of a bid of the petitioner therein, comma, in a tender process floated by the ONGC. Full stop. Next para, the petitioner, comma, had inter alia contended that the advertisement was read by the petitioner at Calcutta and the offer was submitted from Calcutta. Full stop. Representations were made by the petitioner from Calcutta as well. Full stop. Next para. However, comma, the Supreme Court, comma, while turning down the said plea of the petitioner, comma, held that the Calcutta High Court did not have territorial jurisdiction to take up the matter. Full stop. Next para. In NTC Supra, comma, the Supreme Court held in similar lines, full stop, it was observed that the question which arose for consideration was whether the service of notice at the head office of the company at Calcutta could give rise to a cause of action within the state of West Bengal to enable the Calcutta High Court to exercise jurisdiction in a matter where challenge to acquisition proceedings was conducted in Jaipur. Full stop. The Supreme Court, comma, in the said case, comma, turned down the plea of the petitioner that the Calcutta High Court had jurisdiction to take up the matter. Full stop. It is argued that in the present case as well, comma, the entire resolution proceeding, corporate resolution proceeding, from which the cancellation of the petitioner's registration as a resolution professional arose, comma, took place in Odisha. Full stop. In fact, comma, the petitioner also participated in a proceeding in connection therewith in the High Court at Odisha. Full stop. That apart, comma, the decision to cancel the petitioner's registration was taken by the respondent in New Delhi. Full stop. As such, comma, the mere fact that the petitioner has his office in Kolkata has obtained the license in Kolkata, and that the cancellation of the registration of the petitioner was communicated in Kolkata does not confer territorial jurisdiction on this court to take up the present writ petition. Full stop. Next para. Lastly, comma, learned counsel places reliance on Magma Fincorp Limited versus Assistant Director such and such, reported at 2013 SCC Online, Cal 17881. Full stop. Next para. Learned counsel appearing for the writ petitioner, comma, while answering the question of maintainability, comma, places reliance on a judgment rendered by the Supreme Court in Everest Coal Company Private Limited versus such and such, reported at 90 CWN 438. Full stop. No, this was cited by you. This was also cited by you. This is Everest?
No.
Him. Well, in the said case, comma, the Supreme Court, the Calcutta High Court observed that to establish that within the territorial limits of the court's jurisdiction, in order to maintain, it was observed that in order to maintain the writ petition, the petitioner has to establish that within the territorial limits of the court's jurisdiction, prima facie, a legal right claimed by him has been either infringed or is threatened to be infringed by the respondents. Full stop. Next para. It was also observed that at least a part of the cause of action has to arise within the territorial jurisdiction of the court which assumes jurisdiction. Full stop. It is highlighted by learned counsel that the division bench in the said case observed that when an order becomes effective only when it is communicated or served, the service of the order or receipt of a notice thereof would form part of cause of action for filing a writ petition by the person aggrieved. Full stop. It is argued that the same happened in the present case. Full stop. Next para. Learned counsel submits another coordinate bench judgment of this court rendered in Pankaj Panwar such and such, reported at AIR 2015 Calcutta 67, where all the judgments cited by the petitioner were considered by the learned single judge. Full stop. Ultimately, the learned single judge came to a finding that to hold that service of an order or a notice on the addressee would never give rise to a cause of action to move the court within whose territorial limits the order/notice is received, may not be reasonably sound. Full stop. The learned single judge observed that if service of an order or a notice is an event of substance, that is an event which is a material, essential or integral part of the lease connected with the action that is impugned, there is no plausible reason as to why the same should not be construed as constituting a material, essential or integral part of the cause of action. Full stop. Next para. Learned counsel next cites another judgment of this court in Pranab Bose versus Union of India, which is an unreported judgment where it was, inter alia, observed that the premise of the challenge therein was very limited the premise of the challenge there was on a wider footing of blacklisting the petitioner therein for participating for 1 whole year for any work with the respondent authority. Full stop. It was observed that another logic which sanctifies the territorial jurisdiction of this court is that the effect of the impugned blacklisting would directly be that the petitioner would not be able to function in any activity of the respondent authority from its registered office situated in Kolkata, which is within the territorial jurisdiction of this High Court. Full stop. Next para. That apart, learned counsel for the petitioner cites Cement Workers HON'BLE versus such and such, reported at 2019-20 SCC 517 in support of the proposition that Article 226 within bracket 2 of the Constitution confers jurisdiction on any High Court, within the jurisdiction of which even a part of a cause of action has arisen, has jurisdiction to decide the writ petition. Full stop. Next para. Lastly, the learned counsel cites a division bench judgment of the Bombay High Court, which is also an unreported one, where the division bench entertained a writ petition, on a similar issue of challenge to the order passed by the disciplinary committee appointed by the Insolvency and Bankruptcy Board of India within bracket IBBI bracket closed, where the proceedings took place in Delhi, that is outside the territorial jurisdiction of the Bombay High Court. Full stop. A perusal of the judgment cited by both sides indicates that certain cardinal principles have been laid down by the Supreme Court while deciding the scope of operation of Article 226 within bracket 2 of the Constitution. First up, although facts differ from case to case, comma, it has been held that the cause of action or a part of it has to arise within the territorial jurisdiction of the relevant high court which assumes jurisdiction. Full stop. Next para, as echoed in the judgment of the learned single judge of this court, in Sri Pankaj Panwar Supra, comma, the court has to consider whether a material, comma, essential or integral part of the cause of action arises within the territorial jurisdiction of the court assuming jurisdiction. Full stop. Next para. The premise of the judgment rendered by the Supreme Court in ONGC Supra was a challenge to a rejection of a bid of the petitioner therein in a tender process. Full stop. The petitioner therein had sought to attract the jurisdiction of the Calcutta High Court primarily on the ground that the advertisement for the tender was read by the petitioner in Calcutta and that the petitioner had sent its offer from Calcutta along with certain subsequent representations. Full stop. Next para. As rightly held by the Supreme Court in the said case, comma, the simple fact of the petitioner having issued offers from Kolkata might not be a germane fact embodying an essential part of the cause of action. Full stop. The cause of action in the said case was a challenge to the refusal to accept the bid of the petitioner, comma, which took place outside Calcutta, and the Supreme Court was justified in turning down the jurisdiction of the Calcutta High Court on such count. Full stop. Next para. The other relevant judgment, comma, oft cited, comma, which was relied on by the respondent is that of NTPC Supra. Full stop. Next para. In the said case, comma, the question which arose for consideration, was summed up in paragraph 12. Full stop. The textile mills which were situated in Bombay and the supply of cloth which was in dispute therein was to be made ex factory at Bombay. Full stop. According to the writ petitioners, comma, the money was paid to the mills at Bombay, and the learned single judge in the said case, comma, after a detailed discussion of the matter, had held that the Calcutta High Court had no jurisdiction to entertain the writ petition. Full stop. The division bench in the said case, comma, reversed the finding on the ground that concluded contract had come into existence which could be cancelled only after giving an opportunity of hearing, and consequently the question of revocation of the contract at his Calcutta address would constitute a cause of action. Full stop. Next para. With utmost respect, comma, it could be argued, comma, as done in the said case, comma, that the said invocation of cause of action, invocation of jurisdiction could be termed as a bit convoluted, comma, having no direct connection with the bundle of facts which led to the said writ petition. Full stop. The prayer made in the writ petition was a writ of mandamus commanding the appellant therein to produce the entire records relating to withholding of delivery of goods pursuant to the contracts mentioned in the writ petition. Full stop. Next para. However, comma, the facts of the said case, comma, in the context of which the Supreme Court rendered the findings therein, comma, have no direct link with the present case. Full stop. Next para, Kusum Ingot Supra undoubtedly lays down the contours of the operation of Article 226 within bracket 2 of the Constitution. Full stop. The proposition was laid down therein that if a part of the cause of action arises within the territorial jurisdiction of a court, comma, the same has jurisdiction. Full stop. In fact, comma, in paragraph number 30 of the same, comma, the Supreme Court, while dealing with the concept of forum convenience, CONVENIENS, comma, observed that it ought to be reminded that even if a small part of cause of action arises within the territorial jurisdiction of the High Court, comma, the same by itself may not be considered to be a determinative factor compelling the High Court to decide the matter on merit. Full stop. In appropriate cases, comma, the court may refuse to exercise its discretionary jurisdiction by invoking the doctrine of forum convenience. Full stop. Next para. As opposed to the said cases, comma, in the present case, the effect of the impugned action of the respondent is on a much wider footing. Full stop. Next para. In most of the judgments cited by the respondent, comma, the dispute revolved around the refusal of a particular entity in a tender process or some other similar process. Full stop. Next para. In the present case, comma, however, comma, the cancellation of the registration of the petitioner as a resolution professional under the IBC 2016 is not restricted or confined to the proceeding happening at Odisha. Full stop. The petitioner, comma, while acting as a resolution professional, comma, undoubtedly operated within the scope of the Odisha tribunal and functioned as a resolution professional in the said proceeding, comma, including appearing before the Odisha High Court. Full stop. However, comma, functioning as a resolution professional before the Odisha forums is in direct antithesis to the cancellation of the registration of the petitioner as a resolution professional. Full stop. Next para. Hence, comma, the functioning of the petitioner as a resolution professional within the territorial jurisdiction of Odisha cannot, comma, by any stretch of imagination, comma, be cited as a determinant for territorial jurisdiction when the petitioner's very registration for acting as a resolution professional has been cancelled. Full stop. Next para. The cancellation, comma, as much as Odisha, comma, precludes the petitioner from acting as a resolution professional throughout the territorial jurisdiction of India, which is not restricted to a particular state, be it West Bengal, comma, Odisha, or the Union Territory of Delhi. Full stop. Next para. The mere fact that the decision to cancel the petitioner's registration was taken in New Delhi by the respondent does not, comma, in any way, comma, restrict the jurisdiction of the present cause of action to the Delhi High Court. Full stop. In fact, comma, as held in most of the cases, comma, even if a part of the cause of action arises within the territorial jurisdiction of a High Court, comma, it may very well assume jurisdiction under Article 226 within bracket 2 of the Constitution. Full stop. In the present case, comma, the consideration of the respondent authority was not limited to the functioning of the petitioner in New Delhi. Full stop. The basis of the decision apparently was spread throughout the country, comma, particularly in other states than New Delhi, such as Odisha. Full stop. Next para. As such, comma, it cannot be said that the territorial jurisdiction can be restricted to Odisha. Full stop. That apart, comma, the petitioner himself was registered in Kolkata as a resolution professional and thereafter has started functioning in such capacity throughout the country. Full stop. Next para. That apart, comma, the cancellation directly pertains to the registration of the petitioner, comma, which was obtained in Calcutta for pan-Indian purpose. Full stop. Moreover, comma, the cancellation was a composite continuum of the act of issuing the decision of cancellation by email and the petitioner receiving the same in Kolkata. Full stop. Receiving the cancellation order in Kolkata completed the bundle of cause of action by ripening the issue for the petitioner to prefer the present writ petition. Full stop. It cannot, comma, in any manner, comma, be equated merely with reading a pan-India advertisement online in Calcutta. Full stop. In the present case, comma, as such, comma, this court has territorial jurisdiction, comma, since at least a part of the cause of action has arisen within the territorial jurisdiction of West Bengal. Full stop. As such, comma, the objection as to maintainability taken by the respondent is hereby turned down. Full stop. The writ petition is now taken up for deciding on the question of passing ad interim order. Be very short, Mr. Gupta. Now I have to take up original set matters.
Yes, only one.
Be short on your ad interim.
Absolutely. Well, only one thing, my lord, that the order impugn, there has been a cancellation of the license. Now this pertains to one insolvency proceeding in respect of one particular corporate debtor, where the allegations have been made and the order has been passed. The petitioner is a resolution professional in 2 or 3 other, my lord, matters where also there is, my lord, he is working as the resolution professional, which are at the advanced stage. So, my lord, here, my lord, unless, my lord, your lordship, my lord, passes.
What was the ground? What was the worst ground against you, as per you, for cancellation?
May I only give the three grounds?
Yes.
First is, my lord, that I have constituted a committee of creditors comprising of certain related parties.
Your relatives?
No, the different companies who are part of the committee of creditors are related with each other. I have constituted that. And I should have objected. That's one ground. The second ground is that despite the order of the NCLT Cuttack directing me to submit documents with regard to the claims of these entities, I have not done so. There's an email issued to the registry giving all those documents within the time prescribed. I have that document, I have that page number noted. So far as committee of creditors is concerned, section 5, subsection 24 of the Act clearly says that there is no bar, and the relation between the financial creditors is not, between the financial creditors inter se is not related party. It has to be financial creditors qua the corporate debtor. So that on that count also it's bad. The third thing is that there is an affidavit which has been signed by my client on behalf of the resolution applicant.
Your client?
Yes, as in the petitioner, the resolution professional has signed one affidavit on behalf of the resolution applicant, which there has been an explanation that there was a previous affidavit already filed by them, and since he was signing on each and every page of each and every document for filing of that section 31 application, only one document had that signature. Otherwise, the entire affidavits, everything was there.
You
so
signed
there
the
is
resolution applicants?
No, that was signed in all the pages. He had signed. In that page, that deponent did not have any signature. That was a surplus affidavit which was given, whereas the actual affidavit which was to be considered for considering the resolution plan was already on record, rightly signed by the concerned person.
Mr. Gupta, if you are permitted to function in other corporate proceedings also, that will
but
be.
If your lordship,
judging the issue, I mean, if you are challenging that itself.
But that is one plausible view, I must admit. But if your lordship kindly looks at it from a different angle as well. My lord, this, if your lordship does not stay, or at least passes an interim stay, but kindly visualize from a different angle. If after hearing of the writ petition, which might take some time, after exchange of affidavits maybe, if they choose to file one, but if in all the in the interregnum, not is unable to perform even in the existing CIR, but then that could be an irreparable prejudice which cannot in any manner be compensated. Only that view, if your lordship is pleased to consider.
Ms. Rao, what do you say regarding this?
Only one sentence more, only one sentence. Your lordship would, I should be candid, your lordship would limit the interim order only for those
That
existing.
is the
proceedings.
question I'm asking.
That's
Mr.
the only.
My lord, with
Yes.
regard to the prayer now made, that it should be limited only to
Yes, yes.
those two. My lord, there is
Pending
no such
proceedings.
prayer.
There is no such.
My lord will kindly see page.
We can grant lesser relief, sir.
But my lord, in those cases, like which has been happening, my lord, the RPs, my lord, some other person steps in and carries on the same job. The COC would then make an application before the NCLT, my lord. The bench.
What is the worst case according to you against him for cancellation?
My lord, not just, my lord, he just said that the related parties are not related information of the COC. My lord, a detailed judgment has been passed by the NCLAT, including given the relations as to how they were related, why the CIRP was admitted, the fraud committed. In fact, there was fraud on the face of it. He has not gone into it and checked the facts and figures before forming the COC. My lord, he did not take into account that there were claims by the workers. It was his duty, the duties which were to be performed by him, to intimate the workers to file their claim. That has not been done. My lord, in fact, he did not go and appraise the court properly about, my lord, the orders which were passed by the High Court at Odisha. And my lord, about this signature which he says, affidavit page was blank. It was an affidavit to show that he was not a related party. A 29A affidavit which has to form a part of the resolution plan. That was not signed by the party. He signs and he submits it on his behalf.
Any short reply, Mr. Gupta, on this?
Yes.
Identity.
Point by one, the affidavit page which was blank, where there was no signature at all. Related party affidavit is separately on record, which I shall show. It's a separate affidavit already filed on record. This is a surplus affidavit. It's a second affidavit, which was there, which was not signed by the resolution applicant. First. Second is on the ground that workers' claim has not been admitted by the resolution professional. There's an information memorandum and a public announcement. The workers had to come within a particular time. That time was over. The COC meetings were over. And after that, my lord, when the resolution plan was accepted by
What
the
will be a irreparable injury if you are not permitted to act?
No, there are other proceedings where I am. It's at an advanced stage where
Can
my
be placed. You are not an integral part of that. As you.
no, I am.
Somebody else will be appointed.
Somebody else can be appointed. But my lord, otherwise,
Irreparable injury.
but if your lordship does not stays this only for the purpose of continuation of that,
Even that.
my lord, then my lord, here, my lord,
Even that.
but because I cannot, my lord, as a matter of right, claim a complete stay because that
Gupta,
could.
the difficulties we cannot reverse. Suppose if you lose ultimately, we cannot reverse the proceedings which you undertook, which you continued to undertake as resolution professional, despite this cancellation with the blessing of the court's order. That would be very bad. I mean,
The only thing is, the only consideration
remain
was,
tainted then.
I understand.
We cannot undo that. The balance of convenience is against your prayer.
No, I completely understand, but the only distinguishing factor possibly can be there is no allegation of any financial defalcation. The only allegation is of possibly negligence.
Negligence is criminal in certain cases regarding
But
the
here it's not that. And now the entire CIRP has already been undone.
No.
So here there is nothing.
Sorry. Yes. Learned counsel for the petitioner seeks to make out a prima facie case on the writ petition. Full stop. Next para, heard learned counsel for the parties of both sides. Full stop. Next para, although an arguable case has been made out for hearing of the writ petition, comma, for which the writ petition is being directed to be heard on merits, comma, this court is of the opinion that grant of an interim order as prayed, comma, even to the extent that the petitioner will continue to perform as a resolution professional in now pending proceedings, comma, would tantamount to granting the final relief in the writ petition. Full stop. Next para. Going by the concept of balance of convenience and inconvenience, comma, in the event the petitioner is permitted to carry on functioning as a resolution professional in some proceedings somewhere within India, comma, and ultimately the writ petition is dismissed, comma, the damage then done would be irreversible, comma, since the entire gamut of the proceedings cannot be put back in time. Full stop. Next para. On the other hand, comma, the petitioner shall not suffer any irreversible or irreparable injury in the event he remains restrained from functioning as a resolution professional due to the cancellation, comma, subject to the outcome of the writ petition, comma, since The resolution professional can be changed within the purview of the IBC 2016 at any point of time. Full stop. Next para. Keeping such considerations in view, comma, the interim prayer made in the writ petition prayers made in the writ petition are refused. Full stop. The respondents shall file their affidavits in opposition within 3 weeks from date. Reply, if any, shall be filed within a week thereafter. Full stop. The matter shall be listed for hearing on September 25, 2023.
I'm so grateful my lord, for providing us an opportunity.
Thank you and sorry. Yes.
No problem.
Original side. Pardon? এটা সেট করে দিতে বলেছে হ্যাঁ তুমি সেট করে
Original side matters, any mentioning?
My lord, subject to my lord's kindly leave us. No, 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 তুমি করো।
Again you? Yes.
Item 22. And may I have my lord's kindly to mention item number 22 of my lord's list.
Yes.
This is a matter where your lordship was hearing the writ petition on the ground of rejection of a fire insurance claim of the West Bengal Power Development Corporation. But their affidavits have been complete. I had used a supplementary affidavit, your lordship, as back as on 15th of June, directed them to file a reply if they choose to, they have not filed. Now the claim of 10 crores odd is lying stuck. If your lordship kindly, my lord, considers it on any day, my lord. Your lordship was in the middle of hearing of the matter, and our submissions have been concluded. They were already in the middle of their submissions, so it would hardly take any time, my lord.
That is all the more a deterrent. It will be finished soon. I mean, if I start it.
My lord, kindly, my lord. The entire
So I'll take up matters which
the
will take
entire
some
claim
time
has
and
been-
I'll have to deliver
but
judgment
the
later.
entire claim on mechanical loss that has been
No, Mr. Kamal. Not this.
Item number 16.
Yes, yes.
I am for the respondent. Food Corporation of India. We have suffering from lordship's interim order. And at that point of time, nobody appeared on behalf of the Food Corporation. Affidavits are complete. We are also filed and
Same answer, Mr. Kundu. Same answer. I'm sorry.
we are suffering from interim order. We cannot.
So many people are suffering due to my orders, but Mr. Kundu, I cannot help you. Let me take up some other sufferers matters.
My lord,
Yes.
subject to lord's kindly was mentioning this matter, my lord, it pertains to my lord lookout circular. Now, my lord, there was a direction upon the responsive for an affidavit in opposition. They have not done so. Now, my lord, the difficulty is that
which one?
My lord, this matter, which I mentioned
One.
before, lord.
Oh, no, you're mentioning.
I'm just mentioning.
Yes.
Now, my lord, there's a difficulty is that I cannot leave the country, my lord, due to my due to this lookout circular. My business is suffering, my lord. This could be taken up by your lordship any day, my lord. I'm mentioning upon notice. It's
in the list.
I've seen.
It's in the list.
No, not in the list.
Hand over.
Obliged.
Yes.
I have your lordship's kind leave to mention item
Get
number
into it.
42. I know this is not the right time to do so, my lord.
This is the right time. Absolutely right time. For
Lordship-
original side, this is the right time.
No, this is for appellate side, my lord. This is
Wrong time.
wrong.
Come back. Yes, Colin.
Item number 1 and 2, Gauri Prasad Goenka versus State Bank of India and others.
Yes, Mr. Manager, you may take your time.
Your lordship was hearing.
Argue for
Mrs.
days and don't file any. Yes.
Mr. Omnara and Ray was.
Oh, that matter, right.
Yes, not that we had indicated that Mr. Saha was unavailable.
Achha, when should I take it?
Till the 29th, he had indicated that for some personal reasons he won't be here. So if your lordship keeps it on any other day and extends the interim order, my lord.
When should I keep it in? Give me a date, particular date which suits both of you.
But if he's not jet lagged, he should be back on the 30th. So thereafter.
I'll keep it on 31st then.
Fine.
An adjournment is sought in the matter. Full stop. Accordingly, let the matter stand adjourned till August 31, 2023, when it will be listed under the same heading. Full stop. The interim order granted earlier is extended till September 30, 2023, or until further order, whichever is earlier.
Very grateful.
Thank you. Huh? Right.
So second.
Same one.
Contempt matter item number 3, Ashu Dhor versus Sri Santosh Kumar.
Lordship of the petition, lordship.
Yes.
I am for the contempt now, your lordship.
You have to hand over those.
Yes.
So if you hand over this bank draft, that will be, the entire thing will be over.
Yes, yes.
Thank God, yes. Learned counsel for the,
I have handed over, Your Lordship.
yes, learned counsel for the alleged contemner hands over a further bank draft to his counterpart appearing for the petitioner in court, full stop. Since the entire balance which was due to the petitioner has been cleared by the alleged contemner, comma, it is needless to sustain the present contempt proceedings, full stop. Accordingly, CC 82 of 2023 is disposed of as infructuous without an order as to costs.
Grateful, Lordship.
Thank you very much. Thank you for your cooperation.
Lordship.
Item number 4,
Not a
Yes,
big
Mr.
deal.
Vasu,
Raut
I
versus
appear for the
Mukesh.
petitioner, my lord. This is
First time?
appearing first time.
What is the contempt alleged?
My lord, may kindly come to page 16, my lord's order.
Hmm.
Second, but the last paragraph, since the petitioner claims to be the wife, it starts with
Right.
page 16. And the legal heirs of the deceased account holder late Rajan Raut, there cannot be any further impediment on releasing the amount lying with the said account to the petitioner.
Not disbursed.
Not disbursed. They have given a form for seeking indemnity or surety of the like amount that is lying with the bank. And the amount is about 10 lakhs. I'm a widow. The legal heir was, the nominee was, but the address was not traceable. My lord directed them to furnish the address. And they were incorporated. They appeared, but subsequently on the day my lord passed the order, they did not represent.
The order record. The petitioner has the petitioner has made out a prima facie case of contempt to the effect that the alleged contemner has not disbursed the amount directed to be disbursed in favor of the petitioner by the order dated July 5, 2023, passed in WPO 1024/2023, but insisted upon the petitioner furnishing an indemnity equivalent to the amount in question, comma, dehorts the direction passed in the said order. Full stop. Accordingly, the petitioner shall serve a copy of the contempt application on the alleged contemner, indicating that the matter shall be listed on September 8, 2023, when the petitioner shall file an affidavit of service.
Get put to rest. Much obliged.
Right.
September 8.
ব্যাংক ড্রাফট দিই। হ্যাঁ, ওটা ব্যাংক ড্রাফট। ও ব্যাংক ড্রাফটই দিয়ে যাচ্ছে প্রত্যেকদিন।
Review application, item number 5,
Yes.
Shobhan Kumar Datta
Lordship, I
versus State
beg
Bank
to
of
appear on
India.
behalf of the petitioner, my lord, non-compliance of the, my lord, master circular on willful defaulters.
Ground of review.
Your lordship, we had gone up to the division bench. My lord, the division bench had, my lord, directed us to come back and request your lordship.
Show me the scope of the division bench order
On
was.
the last occasion, my lord had passed an order
The
for
order
us
was
to
passed
file
by
an
your lord.
objection. Lord, that, my lord, I was praying for 2 weeks' time to file the objection, my lord.
Opposition.
Lordship, the division bench order is at page 213, volume 2.
Oh, I already directed it.
Lordship. No, there is already an interim order.
So you want to file an additional opposition?
Lordship,
2 weeks more.
lordship, kindly grant.
On the prayer of learned counsel for the respondent bank, the time for filing additional affidavit in opposition is extended till September 4, 2023. Full stop. Reply, if any, shall be filed thereto by September 11, 2023. Full stop. The matter shall be listed for hearing on September 12, 2023.
Very
I was led by Mr. Joy Shah.
He's in court.
Lordship, he is.
Mr. Joy Shah, nam to dijiye.
I'm grateful.
Thank
Your lordship, the interim order is your lordship expiring on the 15th. Lordship
15th?
had- Yes, your lordship. Lordship will kindly extend it for a week, my lord, in the event the matter is not taken up.
Now I fixed it before that. If
Very well.
necessary, mention it. I'll.
Very well. I'm obliged.
Thank
দিচ্ছি। Item number 6, Reliable Facility Services Private Limited and another versus Government of West Bengal.
Yes, Mr. Vanich.
My application, Mr. Bandyopadhyay was addressing your lordship. This is a matter where there was a blacklisting
Yes, yes.
and forfeiture. And we had argued.
Mr. Bandopadhyay has blacklisted you.
No, Mr. Bandopadhyay has blacklisted me. And Mr. Bandopadhyay was arguing, I had finished.
Yes.
He was addressing your lordship. There were two additional judgments that we wanted to rely upon, which we shared copies of. He's taken adjournment 4 times. On the last time, your lordship's desire was that both of us come with our notes. If they don't appear, then your lordship will close the hearing. There's really no further scope for affidavits here, my lord, because your lordship was kind enough to allow them to rely on a document which they say is the order passed by the committee. So, Lord, I'll just take your lordship 10 minutes time, Lord, to just indicate what was there, just to refresh.
What is Mr. Bandopadhyay?
Mr. Bandopadhyay is not in court today. He has a privilege to assist, my lord, honorable.
Yes.
He has a privilege to assist honorable Supreme Court, my lord, in a matter, my lord. So he's
not good ground. You are there. I'll hear out the matter. You are ready with the written notes?
My lord, we have prepared our written notes as well.
Yes, yes, Mr. Banerjee.
My lord, don't look at the papers, my lord. We've troubled your lordship enough with this.
No, this is my own order.
No, that
this has also troubled me enough.
Your lordship's order of recording of.
Yes.
There was a tender that was floated. I participated. I am the L1. I'll give your lordship what my case was and what Mr. Bandopadhyay also argued, just to refresh your lordship's memory. My lord, I was the L1 tender.
Right.
When I was the L1 tender, they sought a justification from me as to why I had quoted a price which was so low. The tender gives them the right to do that. I give a justification. I also put myself out there and give a physical demonstration. After that, the physical demonstration, they give me a notice.
Physical demonstration means?
This pertains to cleaning and all that. So we go and there's Collins.
You went there with the Colin and vacuum cleaner.
Colin and vacuum cleaner, all that. We go and physically clean. Then they give us a notice saying your explanation for the reduced price is vague and we don't accept. But in your letter, you've mentioned that you're going to use Collins. So you are only going to have to use Collins to go ahead
Colin probably. Collins is the dictionary.
Colin to clean. And then they impose 4 additional conditions,
right,
which are dehors the tender terms. Completely additional. I'll be able to show that. And they say that if you don't agree,
so please take your seat. Yes.
I'll give your version also.
No, you'll give your version also. Don't worry. Yes.
But if you don't, then you indicate whether you're going to do the work or not. We write a letter through the advocate that what you've done is impermissible because now you've gone ahead, not so much on Colin. Colin, I don't want to argue. That was a point that the client insisted that I did argue, but I don't want to argue that. There are 4 additional points. I said, you can't do that. So you can't, and therefore you can't forfeit my earnest money. Then they call me for a hearing. In the hearing, it pertains to resolution of dispute. This is the language for resolution of dispute and to ascertain the bid whom it is going to be given. Now, admitted this was an allegation that we had made that in this hearing that we were called, the L2 bidder was also there. This allegation now stands confirmed. It's been admitted that the L2 bidder was there. Now, who is the L2 bidder? The L2 bidder is the continuing contractor. What is his role? There was a previous tender also that was floated. That tender also given a lower cost than the L2 bidder. Again, the authorities had cancelled it. Then comes this one. Again, mine is naturally to throw the L2 bidder out, I have to give an L1 bid. Again, the L2 bidder is sitting there and the L1 bidder and everything has been. Now, they say we don't accept your at all. They impose additional condition. Interestingly, my lord, where they seek this kind of justification from me that how I propose to carry out the work, the difference between my work, my proposed rate, and to L2 bidder's rate is negligible. That document is on record. It is negligible.
Between the rates?
Between the rates is 40,000 rupees. So the L2 bidder is a continuing contractor and he somehow manages to ensure that the bid, that his contract continues. Anybody who has to give a rate, it will be lower than his. For a bid that is 40,000 less, they start giving me physical demonstration and now they've imposed additional conditions I'll show. So we go for the hearing. In the hearing, I say that if these are the conditions that you're going to impose, then I'm not going to do the work.
No, what about this 40,000? They have a right to match your bid. You are the lowest bidder.
I am the lowest bidder.
Yes. So
But
what about this 40,000 you couldn't get?
The L2 bidder,
Yes.
his bid and my bid,
Yes.
there's a difference of 40,000 rupees.
So you're very close then.
That's right.
The bids are very close.
Bids are very close.
How
but
does it help you? I mean,
because their justification to do this was my bid is so abnormally low that I will not be able to carry out the work.
You say it is not abnormally low.
I
Very
say I've given reasons why I can do it.
Very good. Yes.
But then they impose additional conditions. The security deposit, which is supposed to come after the contract, has now to be deposited. What is the amount that has to be given now has gone up by 3 times. There's a waiver which was there under the tender that they say we're withdrawing. You'll have to put in the entire money.
Right.
So everything designed to bring the to keep the L2 bidder in fray. That's one bit of it. These are prejudicial facts. What has actually happened is now they have gone ahead and forfeited my earnest money and blacklisted me. So I came up and showed that 2 tender conditions are there. One is if there is a situation where they cancel the bid, the respondent cancels the bid, then they may also blacklist and forfeit. And the other is where I have failed to give the security deposit after the tender, then they may forfeit my amounts. None of these 2 conditions get satisfied here because there is no contract admittedly. So the question of security deposit does not come. Hence, there is no breach. Second, this is not a case where my bid has been cancelled on a ground that I will not be able to do the work. This is a case admittedly where I have withdrawn my bid, which has a separate clause. So that was one, that this was divorced the contract. Second, you cannot blacklist me without putting me on notice. Your Lordship specific query to me, and I could sense it, that the conscience of the court was not satisfied because there is a clause that permits blacklisting. Of course, the facts were different and this court agreed that the facts were different, but there's a more general query that if the contract houses a clause which permits a party to blacklist, then even then does a party have to be put on notice. Disregard the matter, this query was put to me. Your Lordship was with me with regard to May. That factually is different, but legally this question was put to me. I'll try and satisfy your Lordship on that. And that forfeiture of earnest money can't happen unless there is a loss. There's a pre-estimated damages. Unless you show there is a loss, you have no right to forfeit earnest money. For that, I had showed Kailashnath and the Rice judgment, division bench judgment of this honorable court. This was my submission. Mr. Bandyopadhyay's submission was that there is an arbitration clause in the contract, so that I should be sent to arbitration. Secondly, that I was put on notice regarding forfeiture, but my advocate by its letter specifically referred to the clause that has blacklisting mentioned in it. Therefore, I had notice of what the probable consequences were, and therefore there could not have been a breach of natural justice. Secondly, thirdly, my lord, he had relied on a particular order that he had handed over to your Lordship separately, which according to him was the substratum of the or the basis on which the basis on which the order was passed. Yes, I have a copy of that. This is a resolution of a meeting that was held on 24th May 2023. He had given this and shown that this is the basis of it. One more point he had argued, my lord, I'll just indicate that after participation, I cannot challenge the tender terms. I have participated, therefore I can't challenge the tender terms. And lastly, he said, these are false. I made a false and fabricated claim. In other words, trying to imply that I projected certain work to be able to complete it when I did not have the wherewithal to do it. So this was a false fabricated claim.
And he hinted on L1 cannot have a vested right.
L1 can't have a vested right. L1 can't have a vested right.
It was hinted by. Yes.
This is admitted position in law because I don't want a vested right. I'm not claiming give me the tender. I'm saying don't forfeit my earnest money And don't blacklist me because you've not put me on notice. Anyways, the clause is irrevocable. With regard to arbitration, my lord, the law is clear, and we've referred to that in the notes, that when there is arbitrariness, violation of fundamental rights, those whirlpool considerations, arbitration clause is not a bar. It's at best an alternative remedy. Courts have, it's your lordship's discretion. Second, my lord, lastly had argued that there was a wrong mention of a provision in the order. But it actually is a case where false and fabricated claims were given. This, however much I like him, this I can't help him, because he really can't go beyond the order today, because the order is very, very specific as to why they're invoking that particular clause. Now, if your lordship permits me, my lord, I can take your lordship to the clauses, or I can just give your lordship the written notes. It's fairly elaborate. It refers to the clauses. Every part that I have thought it was distinguishable in facts or inapplicable in facts, we've indicated that.
Show me the size of the written notes.
No,
he's right. And he knows what I want to say.
This, my lord, it's not voluminous. It's 9 pages on double space.
You don't say the page number.
My lord, the compilation of judgments that are referred to, page-wise we've given. These were cited.
Yes.
And we've put Mr. Bandyopadhyay on notice.
2 additional judgments have been given here.
Yes.
She also referred to those before Mr. Bandyopadhyay.
Yes, yes. Before I gave the notes, I'd given it to him so that he can distinguish. And
right.
But if your lordship desires, I can indicate that legal query that your lordship had put, but I've put it there.
You can indicate. I mean,
I'll
just
indicate.
verbally indicate you can.
Yes, yes, my lord. This is 2014 9 SCC 105.
2 judgments are on that.
One judgment is on a different thing.
Yes.
The
Which
other one
is
is
appropriate on this?
2014 9 Supreme Court cases 105.
Right.
Paragraphs 26 and 33.
Yes. Right.
My lord, here also your lordship will find in paragraph 15 of that judgment that the High Court had returned a finding that because this was there in the contract, the right inhered in the party. Therefore, it just took a step in terms of the contract. Separate notice was not required.
But even then, natural justice was read into.
Even natural justice was read into it because there was a clause that had more than multiple steps or measures that the respondent could take on breach. So if you are right, I'm going to take measures against you. Then it may mean all or it may mean one. So if you have to put me on notice, because then I can very well come up and say why blacklisting should not be done. In this case, not the judgment, but in this case that we are appearing for before your lordship, my lord will find that that clause itself is inapplicable. Because that clause, the right to blacklist, naturally will come only when my justification is found to be fraudulent or false.
Yes, yes.
And they cancel my bid, then it may lead to. This is the language.
Right.
Well, these are, I will not trouble your lordship with anything more. Those are notes are there.
Right. Yes. Yes. What do you say?
If I've missed out any of Mr. Bandyopadhyay's argument, he can indicate.
First thing, the difference between the price of L1 and L2, my lord, it has not been pleaded in the writ petition.
Oh, I'm sorry, my lord. Sorry. I should have shown that, your lordship. Page 40,000.
40,000.
40,000. I'll just show that. That is part of the writ petition, my lord. Page number also? Mark actually. It gives me a minute, my lord. Kindly gives me a minute. Page 77. Factually, this was the only thing that I should have shown because it was new. The lordship will turn over and come to 79 once. First, total in figures. If your lordship looks at it from the left, the first one is that of the L2. This is 10,51,000. This is 10,51,458. And mine is one thereafter, the third one from left, 10,14,000.
Yes.
Lord, in the entire amount of 10 lakh, 40,000 makes a huge difference because the petitioner quoted something below 80% of the bid value. So 40,000 makes the 40,000 above the petitioner's price makes the L2 bidders less than 80,000 below the bid value, and then my lord, only the petitioner was considered for this scrutiny. During the scrutiny, my lord, the explanation provided by the petitioner was found unimaginable by the authorities, and as per the terms of the contract, my lord, we blacklisted them and forfeited their EMD. Although, my lord, the notice which was which the petition was put on did not cite the correct clause, which is the fulcrum of the submissions of my lord senior cents. But, my lord, the advocate's letter, who wrote under the instruction of the petitioner, he mentioned the correct term. He requested the respondent authorities not to terminate them and not to forfeit their EMD, and he provided explanation. My lord, this explanation was considered, and upon considering their explanation, my lord, this EMD was forfeited and
no show cause was given here. No show cause was given here.
My lord, a notice was given.
No.
But notice mentioned the wrong clause.
No, notice was also not given for blacklisting, nothing. I'll show that, your lordship.
Before they were asked to give a demonstration, my lord, a notice was given which included that if you
show me that page number.
Yes. It just says that if I don't agree, then they'll go ahead and
number 96, my lord.
page number 989, your lordship will come. Page number 89. 25th April 2023. If your lordship is on that page, I'll just highlight the additional clauses also. III, your lordship will find in terms of FD memo number 25th to 2022 as the reduced rate of security deposit at 3% ends on 31st March 2023, rupees 14,854, something into 10%. 10% of the tendered value will be the security deposit, including the EMD. Amount that will be turned into security deposit amount automatically if the tender bid is accepted. The difference between the security deposit amount and EMD amount turned into security deposit will be deducted at the rate of 10% from the progressive monthly bills. If work order is issued as extant provisions till the amount of security deposit amount is realized, the refund of the security deposit will be as per provisions of NIT and as per the guidelines. This one clause, well, my learned friend will just indicate from the terms of tender where these are there. 4 is additional performance security of 10% of the tendered value as per FD memo number so and so will have to be submitted accordingly if the tender inviting authority decides to.
Threatened action in default is that they may cancel your bid and you may lose EMD.
That's right.
These are the two.
These are the two. If I don't accept.
He is relying on page 96. Let us see what is there.
Well, that lawyer's letter also.
Yes.
If you kindly have a look at page
letter.
94, just once.
Lawyer's letter, they quote a wrong provision.
97
No, lawyer's letter also, just have a look at 94.
Yes.
I quote that forfeiture of earnest money clause. Then I close 8.95 because these are the two clauses that authorize them to forfeit the earnest money.
Yes.
And I say language of 8.95 is may. So there cannot be any automatic forfeiture, or the forfeiture cannot be absolute. In the present case, our client being a successful bidder has all along adhered to the terms and conditions of tender and provided proper justification. Just gives it a cursory glance. Your lordship will not find the word blacklisting anywhere. We were only addressing them on the clauses of the tender, which authorize them to forfeit the earnest money. And saying that none of these clauses are applicable, which is what I'm arguing even now. So you can't forfeit my earnest money because these clauses are inapplicable. There is absolutely no mention.
Let him argue. Yes. What about page 96?
97. Sorry. In their letter, in their advocate's communication, which was which is at page 90, at page 95, my lord,
you're moving between pages. You are referring to 97.
At page 95, they requested us to cancel the tender and refund the EMD at the earliest. My lord,
Yes.
they communicated their intention not to work with us. My lord, in reply to that, my lord, we have
Where is the threat of blacklisting? Where is the threat of blacklisting?
Lord, we put them on notice. we put
There is
them on-
nothing regarding blacklisting even at page 97. Nothing regarding blacklisting even at page
they are
97.
barred from participating in the future bids for 5 years.
Where is that?
At, my lord, at the last line of the first paragraph of page 97.
That's the impugned order. That's not a show cause notice. This is what I've impugned. What is my learned friend saying? I'm saying that this is.
Mr. Banerjee,
Sorry.
please.
Lord, we mentioned the particular clause under which we are taking this.
You are barred from participating.
Lord, this is the order with which, my lord, they were barred from participating.
Yes,
in the
anything
future.
else?
And my lord, we mentioned the particular clause, my lord, since because the documents which were provided to them were not found acceptable, and the documents which the mathematical expressions which were provided to them were not found plausible for by us. My lord, we exercised this clause and we forfeited their EMD. My lord, we informed them about our action of we informed them that they may lose their EMD if they fail to satisfy us, my lord, and they were put on notice regarding that. And since they provided us false and faulty document, and since they intimated us that they are not willing
What
to.
faulty document did they provide?
My lord, the documents, the basis of which they provided their mathematical calculation and justification regarding our queries, they were not found plausible to us. We have communicated that. And my lord, since they intimated us that they are not willing to participate in the tender, my lord, we forfeited their EMD as per clause 6.5.1, which authorizes us to forfeit the EMD of any tenderer, applicant who withdraws his bid. I mean, hence we took the action as is evident from page 97. This is our written notes of argument.
Thank you. I'll conclude hearing.
Well, could I just get 30 seconds? This note that was handed over, this order of minutes that Mr. Bandopadhyay handed over.
Yes.
There also your lordship will not find that blacklisting was ordered.
These judgments were cited by you on the last action. Let us see. Yes, petitioner.
Well, whatever we
repeating
had relied on, all are there in the compilation.
Very well. Yes. Hearing is concluded. Judgment is reserved in the matter. Written notes of arguments. Hearing is concluded. Judgment is reserved in the matter. Written notes of arguments filed by both sides be kept on record. Thank you.
Wait for me.
Item number 7, file Paul Odhikari versus Union of India.
Yes.
এটা তো আমাদের রেসপন্ডেন্ট pursuant to the last order passed by your lordship, my lord, the register general is supposed to be file a report.
কোনটা এটা কি ছিল? ও আচ্ছা আচ্ছা, that let me check.
নাম দিতে হবে না? রিপোর্ট ফাইল করেছে।
What is the crux of this, Mr.? You are appealing for the High Court?
No, I am appearing on behalf of the Millard state, and I have taken a point of maintainability as well.
Why do you say that?
Millard, there is no representation even. Stateway approaching the High Court. And this matter, lordship would see at page 5, this matter is also pending.
Pending where?
Before Millard Justice, before your lordship, I guess, Millard. Yes, before your lordship.
So this is also before me.
That's right. That
Pending
matter
means-
is pending.
This matter is also pending.
That's right. But in a same cause of action.
So
That
what?
can be. But there is no representation even to that extent.
The registrar sought for a report from all the districts. All the districts have given a nutshell report, which has been, the entire thing has been given as a bunch. And not only that, there is a précis also. So most of the courts are uploading orders. So you have to give specific instances then. I'll give you liberty to approach the registry of the specific court if you have any grievance. Because most of the quoted districts say they are uploading. And this order has been circulated on your writ petition to all the districts.
Actually, as per the scheme, this is a scheme of the central government and monitoring it by the Supreme Committee. As per the scheme, they are already uploading. But my point is this, they are not covering the entire things. Only in a particular case, kindly see 100 cases, they are only 10 or 15% is uploading and 80
No, much more than that. The report says much more than. You have to give specific instances then.
Let the time be given.
I'll
direct her to copy the service,
be done
copy.
This cannot be done judicially, Mr. Dotto. If you have any particular grievance, you can take it. I'll give you that liberty to approach the either the NIC or the registry of the particular court or registry of this court, whichever.
When your lordship already intervened into this matter and relegating me to the concerned department.
No, Mr. Dotto, the difficulty is this court cannot monitor the entire thing.
Yes.
Because the report has been given. This is sufficient.
Your lordship call for report. Report has been submitted, and as per the report.
Not only that, the report gives in a nutshell all the districts. All the districts have been. All of them have filed reports, which have been given in a nutshell. Each of the districts.
I can give a counter reply of this report, my lord, showing my lord, that there is the cases that no uploading is there.
I'll give you liberty to approach the appropriate district court on that score. If there is a particular instance of non-uploading of a particular order, we cannot
not
sit in
particular issue. My lord, there is a huge percentage gapping is there. This is the main point.
No. Not now.
Kindly, my humble prayer is this: the report may be allowed to go through. Then I might allow me to submit from my side.
প্রদীপ বাবু এটার এই রিপোর্টটা একটা সার্কুলেট করতে হবে ওনাকে কতদিনের মধ্যে এটা আজকের মধ্যে জেরক্স করা যাবে কালকের মধ্যে দিয়ে দেন A report has been filed by the Registrar General of this court, which indicates that the order of this court was circulated to all the districts concerned, and a comprehensive report has been filed by the registry of this court, including the feedbacks given by all the districts. Full stop. Except. Full stop, next para. However, comma, only with regard to the district of Alipurduar, comma, it has been recorded that no report has yet been received. First up, a primary perusal of the report in short indicates that there is sufficient compliance of the guidelines, of the extant guidelines in uploading the orders in question. First up, although there is little or no scope judicially to confront issues of individual cases where orders are not uploaded, comma, since learned counsel for the petitioner seeks a copy of the report, comma, for ends of justice, let a copy of the report be circulated to the learned counsel for the petitioner by tomorrow. Full stop. The matter shall be taken up for hearing on Monday.
15 days time may kindly begin. 15 days for no.
No, I'll not keep this pending.
1 week at least.
Mr. Dotto, I'll give you liberty to approach the appropriate.
Yes, all right. 1 week time, Lord. Otherwise, matter will not.
1 week definitely, yes. So Monday is 1 week.
All right, your lordship, no problem.
The matter shall next be listed on August 28, 2023.
Next. Item number 8, Sanjay Prakash Bansal and another versus UCO Bank.
This was I appear for the respondent bank. CPC
He's joined the parties.
Yes, bank.
No, this was LOC that we had challenged.
Report.
Lordship, yes, I'll just find it.
Report original.
I'll make a template for these orders.
Sealed in hell of my lord. I'm not supposed to open. So I'm. And this is a report.
Lordship had directed us to file a report along with the request for the issuance of the lookout circular. My lord, there is a communication according to which we are not supposed to disclose it.
No, you're
nor
right.
serve it. Therefore, my lord, that has been handed up. In fact, Lord, even I haven't had the occasion to look at it.
No, you. What are the names of the petitioners? Sanjay Kumar Bansal
And his, yes.
But
And
before your
Leela
lordship
Bansal.
takes that up,
Leela Bansal.
I must indicate, my lord, I'm taking a point of maintainability also.
Why?
On two grounds, my lord. First, that there's a misjoinder of the petitioners. Number two, that this writ application has been
Disjoinder
filed.
of the petitioners means?
There are two separate petitioners. There are two petitioners. And the second, my lord, on the ground that this has been filed in suppression of material fact, which itself should be ground for the dismissal of the writ application. These 2 points.
What is the
of
material fact?
There are several, my lord. Number one is that the fact that they are saying that this lookout circular needs to be set aside is on the ground that the petitioner number one is a director of certain companies that are still in existence, and he requires to travel, which is otherwise also a fundamental right. But with respect to that, my lord, this person has already been, his DIN has already been deactivated, the director identification number. So number one, this person is no longer a director of any company, nor can he perform. Second, my lord, is they've referred to the certain companies, 3 companies who were the borrowers of the bank, my lord, which have now all gone into CIRP, but they have not brought to your lordship's notice that there are also applications under section 95 of the code, my lord, which are pending for bankruptcy against individuals. That is, have also invoked the personal guarantee against these individuals. Not one shred of any sentence, my lord, in the writ application which discloses that. I will show those orders which are pending before the NCLT. Third, my lord, there is a forensic audit report which has been issued. They do not mention it in the writ application, in which there are observations, my lord, where there are fraudulent transactions which have been carried out by the directors. So these 3 I'll place before your lordship.
Could I just?
Yes, sir.
Yes.
Only reason is willful defaulter declaration.
At that point, there has been certain.
LOC has to go. You take steps under the various provisions.
May I only say this, my lord, to answer that query? The LOC would have to go pursuant to the order passed by this court. So your lordship would have to pass a mandamus. Your lordship, in my understanding, my lord, in my humble submission, lordship tests it, would be able to pass the mandamus only if the petitioners cross the first 2 tests, the thresholds. Number one, that their writ petition otherwise is not barred because of misjoinder, even though that is not fatal to the writ application, that would be sufficient for, that would still be an illegitimate petition. Well, that's the wording. Second is, if they've come with unclean hands, that itself will be a cause for the dismissal of the writ application. I'll be pressing on these 2 points.
Your first is DIN has been cancelled.
With respect to the suppression of material fact, my lord, first is that the DIN of the petitioner number 1 has been cancelled. I'll make over that copy, my lord, which is available on the portal.
What else?
Second, my lord, that there are applications under section 95 of the Insolvency and Bankruptcy Code, which are pending, wherein I have invoked the personal guarantee sought for personal bankruptcy to be declared against the petitioners. There are 2 separate proceedings, my lord. Again, because they are also personal guarantors, that is an admitted fact. I'm sure they'll not deny it. So there are already proceedings pending. There is not word mentioned in the writ application with respect to that. And that itself is a sufficient consideration for the request to be issued. The third, my lord, is that
forensic audit report.
There is a forensic audit report. These 3, I was also on the merits of the matter. I'm just canvassing out the points, my lord.
Merits of the matter only pertain to the issuance of LOC. Issuance
of the LOC.
Nothing else.
But then the issuance is based on a request that I sent. They have challenged the LOC. I'm trying to impress upon your lordship one point. I don't really have a lot of judgments that support me on this. There is an LOC which is not issued by me. The LOC is issued by the government. The office memorandum permits me as a PSU bank to only issue a request. That request, my lord, in my humble submission, again, your lordship will kindly test this point. In my humble submission, a request will not have to stand the test of reasonableness as far as the Wednesbury principles are concerned. Mr. Banerjee corrects me, Wednesbury principles. So he's
my chamber junior, so that much right I have over him.
Also, I'm slightly more intimidated at this point in time. But with respect to that, the request will not have to stand the test of a reasoned order, because this is only in the nature of my formal request asking the authorities to issue the lookout circular. So it doesn't have to be in the nature of an order passed by a civil court, which takes into account evidences that have been tendered in a trial. So I'm just canvassing my points, my lord.
Absolutely, why not? Yes. Yes, Mr. Banerjee, what about suppression?
Look, two things I'll just indicate. Look, all proceedings that are pending against me, I have disclosed. Now, what I really needed to show was with regard to every fact doesn't have to be pleaded. Well, the memorandum which authorizes them to issue a LOC is on 3 counts. And that your lordship has very succinctly recorded in my lord's judgment. Well, if I may just rely on this, no other fact is relevant. Suppression, there's a reason why courts insist that material facts have to be suppressed. What pertains facts that are relevant or have a proximity to the cause of action, if not disclosed to the court, courts will frown upon a litigant like that. Facts which have no relevance to the cause of action. Well, kindly allow me to just place 2 paragraphs of your lordship's order. This is with regard to UCO Bank.
No, need not.
Look, the test is very, very clear. I'll read it out, Manoj, for my understanding and my junior. Look, 2 things issue.
Yes.
Look, paragraph 4, I had to copy these, okay? Page 4, last paragraph. Oh. May I just hand it over, Manoj?
Yes.
Page 4, last paragraph. The office memorandum in question. Sorry.
Yes.
The office memorandum in question dated December 5th, 2017, which has been sought to be relied on the bank, specifies several grounds. The grounds which might have been relevant, kindly mark this in the context of suppression also. In the present context is only that the person concerned leaving India would be detrimental to the bilateral relations with any country or to the strategic and or economic interests of India, and or such departure ought not to be permitted in the larger public interest at any given point of time. On these 3 tests, my learned friend will not be able to show your lordship anything which I have suppressed. The rest becomes extraneous to the cause of action. And that is one of the, and Lord, I'll just indicate this person before your lordship and his wife, the person is actually known as the Tea King of India. I have annexed, it's the only person in the country who has been awarded by the Harvard Law Review and the Harvard Law Board to mean or to have achieved certain status. This white tea that your lordship has possibly that we've started having was his invention. Look, there are letters by the ministry congratulating me for what I've done for the tea industry. A short resume is there. And I've pleaded, my lord, I did not want to face the ignominy of going all the way, and my foreign partners have given me invitations, they're on record. I've taken instructions from my client. It's factually incorrect that my DIN is inactive. But even if it is, my petition does not say that I'm going as a director. It specifically records that I am going to develop or recreate my business again. And those invitations are on record. But if your lordship looks at page 22 once, just to issue a LOC against somebody, my lord, with the intent of harassing someone to pay up money. This is what your lordship has frowned upon in this judgment. 22 just gives it a cursory glance. My lord. This is the person before your lordship. Turns to 24 once, my lord. Just once at page 24. These are the awards that he has won. From the government also there are awards for achieving the highest export of Darjeeling tea at one point of time. I personally did not know, because when he had come to my chamber, I offered him coffee. And then he got me a packet of white tea and he told me that this was his invention. These are his awards. And the 2 important things, Lord, why I need to travel. If your lordship looks at page 46 onwards. These are my clients who are there internationally. I have meetings scheduled with them and I want to go as an individual. Will not test this and throws it in the bin. The law as a fundamental right allows me and my wife to travel. And with regard to misjoinder, it would have been a misjoinder if there had been no jural relationship between the parties. If parties who have a jural relationship and
separate LOCs were issued.
But my lord, the LOCs were issued by the bank because of a default in connection with a loan that we taken together.
Even then, you are challenging the two LOCs separately.
Well, that I don't know, but it would be two LOCs. It could be one order.
What is the court fee for a?
Yeah, that I'll pay. That your lordships insist on, I'll pay.
So I don't think payment of the court fees would be the cure to this particular defect, unless I understand that this is not fatal. I will concede to the fact that it's not fatal, but I will not concede to the fact that today your lordship will not have the discretion to decide some solution to this other than payment of court fees, such as the petitioner number 1 gets to proceed with this, the petitioner number 2 doesn't. There are ample examples. And the reason I'm taking this point today is because if I do not, then I'm barred from, it would be deemed to have been waived off under order 1.
No, definitely.
So
I'll record it.
I'll come after Mr. Banerjee completes. I'll
Please
wait
just
for my-
complete it. I cannot go on and on between you. Yes.
No, no, I have completed.
Yes.
So I'll have to take your lordship through the 3 things. But before that, my lord kindly takes up para number 15 of the rate application once, which is on page 8. Lordship, page 8 of the rate application.
8, right.
Page
Yes.
8.
Yes.
They write, my lord, sometime in 2021, the petitioners were prevented to travel abroad by the respondent number 3 at the airport in New Delhi, purportedly on the basis of a lookout circular. This is sufficient. Then they go on to write why they could not, because of COVID, etc. Their plans had to get cancelled. So as far back as 2021, they were already aware of the existence of the lookout circular. Or in this case, my lord, the lookout circulars, because there are 2 separate lookout circulars issued against both the different petitioners. Lordship keeps this aside for a moment. There was a willful defaulter identification committee order which was passed against them. Show cause order. They assail that before your lordship's court. Your lordship holds that there is an alternative remedy, review committee. Be that as it may, your lordship sets aside the order. Mr. Banerjee appeared in that matter. Your lordship says that you have to give them a fresh hearing. There has to be an issuance of a fresh show cause notice, on the basis of which there'll be a fresh hearing that would be concluded. On the basis of that, my lord, I issue a fresh notice, a show cause notice. Lordship kindly takes a look at the
Keep the
email.
notice with you. Why?
Slightly relevant, my lord, otherwise I wouldn't have insisted.
Definitely, yes. Give a copy to your learned senior also. Yes.
Lordship kindly marks the date. Lordship kindly marks a look at the date, my lord, 1st of August.
Yes.
1st of August, my lord. Lordship looks at the date of affirmation of the writ application. Page 21. 4th. So from 2021, they're aware of a lookout circular that has been issued against them individually. They file a writ application challenging the same only 3 days after the show cause notice has been served upon them. This itself, in my understanding, my lord, would cause for sufficient questions against their bona fide to come before this honorable court, apart from the fact that I'm already challenging their maintainability, my lord, on the ground that they've already suppressed facts and facts which are material. So before I take your lordship through what are the facts that have been suppressed, lordship kindly marks what are the facts that are material. In a situation, my lord, where there is a request for the issuance of a lookout circular, the most important fact to my mind that would be relevant is whether or not there are pendency of any proceedings either for recovery or which pertain to any financial transaction. Otherwise, my lord,
Not under the law, no. Not under your guidelines.
No,
Definitely.
because under the guideline, first
These are entirely irrelevant. Entirely. Only thing, economic stability of India or economic interest of India or public interest.
This person owes approximately, according to their own submission in the writ
He
application.
owes, you have a proceeding, recovery proceedings are pending against him. You have a remedy there. Are you
Yes.
enjoying any attachment order there?
I'm not enjoying any attachment order.
You are not even enjoying any attachment. You did not take that recourse at all. You are seeking to use this
No,
as
there
an
are
alternative
SABYASACHI
parallel?
proceedings.
No.
There are SABYASACHI proceedings. Three of the
This is not that proceeding. You cannot deter him from leaving the country on just because proceedings are pending.
Next thing, Dharan,
Get an order there.
No.
Attach entire properties of this person.
I'll tell you, Lordship, why this consideration is otherwise material is because if today this person and or at least to the mind
It
of
has
the
been
issuing authority,
repeatedly deprecated that the banks are using this as an alternative of recovery proceedings,
proceedings.
which you cannot do.
I am not saying that I'm doing that.
You cannot do.
I'm not saying in the
You are
greatest
doing
of respect-
precisely that. You are saying your premise of argument is that there are several pending proceedings. So what?
No, I'm not talking about the pendency
There
of
may be
proceedings.
umpteen proceedings, unless those are criminal proceedings, which there is a right you have under the law, under the circular. Yes.
No, I'm not referring to the pending proceedings vis-a-vis the ground for me to issue the lookout circular or to ask for to request for the issuance of the same. I am referring to the pending proceedings because that has been suppressed and that is a material
How
fact.
is it German? You are repeatedly saying that he has suppressed. If it is German, only then suppression comes up. How are they German at all?
Because
whatever proceedings are pending, unless there is a criminal proceeding which is absent.
there is no criminal proceeding that to my mind is
there
or
is
to
no
my knowledge.
suppression at all. Suppression can only be of relevant issues. These are not relevant at all. Even if I feel that this person, yes, he is a threat, I mean, to your bank, then that does not give you a right to ask for a lookout circular.
But if he runs and doesn't come back, and
It's
the
like, it's
possibility-
like a nuclear weapon in the hand of an animal. I mean, you're playing with it, toying with it. This is the liberty of a person, sir, Indian citizen. You cannot toy with it like this. Lookout circular. I want a lookout circular, and you issue a request. And that request the little boy has requested and it has been granted to you. No, sir. This is not the way a lookout circular is issued in any country, in any civilized country.
I bow down to whatever you're
You cannot do this.
No, I'm not.
You have filed proceedings against it. Proceed with those. What deterred you from getting an attachment order in those proceedings? When did you initiate the proceeding?
Originally, my lord, 3 of the companies that he refers to have already gone into CIRP. So
When were the proceedings initiated? You're urging that certain proceedings were. When was the DIN cancelled? When was the request made by you? Tell me. Give me the date.
With respect to the request, my lord, I'll not be able to assist your lordship because that has not been made over to me in view of the.
You must know the request date at least.
That your lordship, I shouldn't say this to my lord, but I'll request your lordship to kindly only in this exceptional rare case, my lord, to refer to the document because I've not been made over the copy of that.
Not exception. In every case, I did refer because there is nothing so close in this which is required to be kept. Now, your date is 28th of September 2020. When was his DIN cancelled?
DIN was cancelled post.
Post. When was he declared as a defaulter?
He's not been declared as a defaulter because the lordship said it
Till
aside.
date.
There is a proceeding which is pending today
Very
because
well.
the show cause notice has
So
been issued.
nothing has happened prior to issuance of this request which could deter him from traveling abroad. Nothing.
Except for
there is
the
not a
companies-
single pendency even.
Except for the companies which have gone into gone into CIRP and
When
there
did
is
they
a
go
foreign-
into CIRP?
I'll take your lordship.
So a company going into CIRP, he was a director of that is sufficient for issuing a lookout circular, requesting for a lookout circular.
And not just a director, he was the promoter, he was the person who
So
was
what?
controlling the company.
So what?
And there is
It's
a
an
foreign
economic action, it's a financial action, you have taken out a recovery process.
and the fact that there is a forensic audit report
No,
against
sir, I
him.
won't hear you.
I've had the
more
I've
on
had
this,
the
no.
occasion to go through judgments passed by
You
this
may
court.
have occasion to go through
No,
whatever.
I'll
judgments.
indicate why.
It is not German here. I cannot
Lordship
let
kindly
you
looks
go
at-
on and on and on.
Lordship kindly looks at the audit report once in that case.
Why
my lord,
should I?
Where it's
Why should I? What bearing does an audit report have on this?
because there is
Has he had an opportunity to rebut that report before issuance of this lookout circular?
he could have challenged it in a separate
No, sir. FAR cannot be the basis of any lookout circular whatsoever. Let us see the government have the gumption to say that FAR issuance of a forensic audit report by a particular entity, that is sufficient basis to issue a lookout circular. Let us see that circular by the government.
No, there is
I can assure you it will not see the light of day before any court of any high court in India. I can assure you that. We know how to protect our laws and constitution.
but may I
This is not the way.
I'm not
The banks cannot misuse this. No. You have to learn when. Unless costs are imposed on you for issuance of these requests, you would never learn.
may I make
Since
one-
you have prepared so well, let me start with you by imposition of cost. Some costs have to be imposed on bank for issuance of these lookouts, so requests. Otherwise, you won't learn. You only know the world language of finance. Let me be on that.
may I make one submission, my lord?
Yes.
May I? I'm not on that. I bow down to whatever your lordship
Yes.
has said. With respect to the personal liberties of a person being snatched away by, I'm not on that at all. I'm only saying this with respect to the forensic audit report. There is no law, there is no master circular, nothing which says that that would be taken as a consideration. But this forensic audit report was issued pursuant to the order of the CIRP. So CIRP gets admitted. There is a person who's appointed as an IRP, then IRP. He appoints a forensic auditor. Forensic auditor gives a report. So in that CIRP proceeding, the suspended board has the right to challenge it. They do not challenge it. But in the forensic audit report, there are categorical observations about fraudulent transactions that are impugned against the petitioners.
Have you got a copy of that forensic audit?
It is a part of my report.
We have an.
If you check up, there must be something to say that this cannot be used in any other proceeding. You check up, in every forensic audit report, there is a rider. There must be. I can assure you. If you don't want, I can read out for you. I haven't seen the forensic audit report.
No, it's there.
Every forensic audit report contains that statutory warning sort of thing. This forensic audit report is injurious to health sort of. In every forensic audit report, there is such a right. In your forensic audit report, it must be there.
Must be, but
any chartered accountant or accountant worth his metal will put that in.
Disclaimer is there.
It must be there. I'm telling you.
Disclaimer is
And you're relying on that to ask for issuance of an LOC. I mean, how dare you?
No, these were not on instructions. These were submissions that I
See the forensic audit
I
report.
take full
Find out if it is not there. Tell me.
I take full responsibility for submission that I'm making in my individual capacity. But then I fall back on my
Don't ever take responsibility like this. You are functioning for your client. You are a creature of instructions, and you are doing your duty very well. But don't take personal responsibility for anything.
Yeah,
Why should you take personal
fall
responsibility?
back on my earlier 2 points? of
Yes, yes. Those points
maintainability.
remain. That's
And I've handed up the copy of the deactivation of the
This matter I'll impose question, not for you. You have
Sure.
argued very well. Learned counsel for the petitioner has challenged the issuance of lookout circular notice against the petitioners. First, it is argued that such lookout circulars have been issued without any basis whatsoever. First, such contention is refuted by learned counsel for the respondent bank. It is submitted by the bank that the writ petition is not maintainable, since a single writ petition has been filed by the two writ petitioners, against two separate lookout circulars issued on the basis of separate requests by the bank. As such, it is submitted that a single writ petition at the behest of both is not maintainable in law. Secondly, it is contended by the bank that the writ petitioners have suppressed several extremely relevant documents. It is submitted that the DIN block A of the petitioner number 1 has been cancelled. That apart, proceedings are pending under section 95 of the Insolvency and Bankruptcy Code 2016 against the petitioners, for invocation of personal guarantee as well as personal bankruptcy declaration. Next para, learned counsel for the respondent bank also relies on a forensic audit report within bracket FAR bracket closed, which it is contended, is incriminating against the petitioners as far their financial offenses stand. Next para, as such, it is argued that the writ petition ought to be dismissed at the threshold. Next para, even on merits, it is contended by the bank that the petitioners are suffering from the pendency of several proceedings against them, and as such, the issuance of the lookout circulars were justified. Next para, the respondent bank hands over copies of the requests made by the respondent bank for the issuance of lookout circulars, in a sealed envelope, on the specific direction of court. Next para, the contents of the said requests, only insofar as they are not sensitive in any manner or do not disclose any source or can be harmless to the interests of the state are discussed here. For the next para, it is evident from both the said requests that in the clause regarding the reason for opening of LOC, comma, in case of both the petitioners, comma, the reason given is that director and guarantor of NPA account, and that the bank has identified the borrower as willful defaulter, comma, the examination of which is under process. Full stop, next para. The said requests were issued on September 28, 2020. Full stop, next para. As such, comma, it is clear from the requests themselves that no basis within the purview of the concerned office memorandum regarding issuance of lookout circulars has been satisfied in the present case. Full stop. The office memorandum in question dated December 5, 2017 provides for several grounds for issuance of lookout circulars. Full stop. The only grounds which might be relevant in the present context is that the fact that a person leaves India would be detrimental to the strategic and stroke or economic interests of India, and or such departure ought not to be permitted in the larger public interest at any given point of time. Full stop, next para. The expressions within double inverted economic interests of India, double inverted close, and within double inverted larger public interest, double inverted close, cannot be equated with the limited interests of a bank or financial institution to recover its its alleged dues. Full stop, next para. For such purpose, comma, there are several legal avenues open to banks, comma, such as recovery of such dues in due process of law. Full stop. The alleged suppression of material facts are not germane to the present case at all. Full stop, next para. Although the petitioner disputes the cancellation of the DIN of within bracket director's identification number, bracket closed, of the petitioner number 1, comma, the same, comma, in any event, comma, is not a material consideration within the purview of the concerned office memorandum. Full stop. The pendency of a proceeding under section 95 of the IBC is also not a germane consideration or a bar contemplated in the office memorandum to restrict the fundamental right of an Indian citizen to move within the territory of India and to go abroad. Full stop, next para. Learned counsel for the respondent bank also seeks to place reliance on a forensic audit report, comma, which might have been authored for the purpose of a particular proceeding, but does not have a binding effect, at least for the purpose of issuance of an LOC. Full stop, next para. Insofar as the single writ petition having been filed by 2 writ petitioners on separate causes of action, comma, since the causes of action emanate from similar requests by the bank, comma, which are exactly contemporaneous, comma, such defect can be cured easily by permitting the writ petitioners to put in deficit court fees, comma, equivalent to the court fees payable for filing of another writ petition. Full stop, next para. That apart, comma, thus the allegations and pleadings made in the present writ petition would suffice. Full stop. Instead of relegating the petitioners to 2 separate writ petitioners, to 2 separate writ petitions, comma, even after hearing the matter on merits, comma, would be a mere travesty of justice and would serve no useful purpose. Full stop, next para. Insofar as the conduct of the respondent bank is concerned, comma, it is being noticed that on several such occasions, banks are seeking to use the power conferred upon banks and financial institutions to issue requests for issuance of LOCs as a parallel proceeding to coax alleged debtors to pay up the alleged dues. Next para, such a parallel effort on the part of the banks and the financial institutions have been deprecated time and again by different high courts of the country as well as the Supreme Court of India, but has fallen in deaf ears. On deaf ears. Next para, such conduct on the part of the respondent bank in the present case and of banks and financial institutions in general, to usurp the authority, based on the high pedestal of the economic interest of the country and public interest of large, for their restricted purposes to recover their alleged dues cannot be taken, cannot be permitted to go on. Next para, hence, as a token gesture, the present respondent bank ought to be saddled with costs to deter the bank from taking such a course of action, as a parallel proceeding as an alternative to recovery proceedings in future. Next para, in view of the above observations, the issuance of LOC, which is blindly done by the immigration authorities on the request of the banks and financial institutions, being dehorse the office memorandum of the government itself, is cannot stand the scrutiny of legal inquiry. Accordingly, WPO 1485 of 2023 is allowed, thereby setting aside the lookout circulars issued against the writ petitioners. The respondents shall communicate to all concerned authorities, to whom the issuance of the LOC has been formally communicated, to ensure that the petitioners are not deterred from leaving the country in due course of law. Next para, it is made clear that the respondents shall remain restrained from acting on the quashed lookout circulars for the purpose of restricting the petitioners from traveling abroad. Next para, the respondent bank shall pay costs of rupees 50,000 to the petitioners, being rupees 25,000 to each of the writ petitioners, to compensate the harassment suffered by the writ petitioners due to the unjust and unlawful request for issuance of LOC made by the bank. Such costs shall be paid within. How soon can you can you prefer an appeal? What is a reasonable time? I'll give that time.
I was praying for your lordship to reconsider it in view of the fact that it's the immigration which is issued the LOC. But
Immigration turns a blind.
Lordship decides on the
30 days. Within 30 days from date. Next para, nothing in this order, however, shall deter the respondent bank and or the immigration authorities from taking steps for issuance of lookout circulars against the petitioner in the event any of the criteria as stipulated in the concerned office memoranda of the government governing the issuance of lookout circulars are met in future. No rest to Kostavad.
The only thing is, in your lordship's last order that I referred to, there's some directions contained on the Immigration Bureau, which is also implemented.
I put that in general terms, Mr. Banerjee. Whichever authority have been communicated, they have.
I shall then forward it.
And they have been restrained from preventing you, so they have to take care of that.
Lordship, only one thing, my lord. As a part of my submission, lordship kindly records that a total amount of 134 crores is due as a part of my submission.
No,
not to be held to be material.
The matter is over.
No, not
I will
to be
state it in
It's a part of my report. It's a part of my report. As per the report, lordship refers
the report as a part of your stay application in the appellate.
Possibly, I'll advise them not to, which is why.
Why not?
As a part.
Test it. At least for the costs you have to go, you'll be instructed to.
Lordship, kindly, with respect to my submission, Lordship disregards.
So not after the matter is over. You did not argue this at the time of hearing. Quantum was never argued, and that is not a relevant factor also.
I understand, Lordship doesn't
So that
consider
I
it to
won't
be a
take it
relevant
after
factor.
passing my order.
The only submission I had made, my lord, was very well, my lord.
May I have my lord's kind leave?
The factor line, the requests for issuance of LOC of LOCs handed over in court be made a part of the record.
May I have my lord's kind leave to mention item number 208. This is an upon mentioning matter.
Appellate side.
Appellate side.
May I be permitted to mention, my lord, inclusion, my lord? My lord, kindly, my lord, the division